One minute.
Please, sir. Start again.
Right. Morning. Yes.
The lordships kindly, one transfer matter, my lord. I don't want to disturb the petitioner. I have been without any posting from 7 months.
7 months.
ಹೌದು.
Next week ಹಾಕೊಡಿ.
Kindly date may be given, my lord.
Next week. Okay. ಹೇಳಿ ಅವ್ರು ಮಾತಾಡ್ತಾ ಕೇಳ್ತಾ ಇಲ್ಲ. ನೀವು ಮೈಕ್ನೇ ಮಾತಾಡೋರು ಮಾತಾಡಿ.
One matter,
ಮೈಕ್ ಇಲ್ದವ್ರು ಲಾಸ್ಟಿಗೆ.
one matter pertains to suspension, my lord.
Ah.
I was appointed as the inspection officer.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಹೇಳಿ ಅದ್ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದ್ ಬೇಡ ಮೆರಿಟ್ಸ್ ಮೇಲೆ.
I had the benefit of interim order before the tribunal, my lord.
ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದೇನೆ ಈಗ.
No, my lord. Suspension order is passed, my lord.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದ್ದಾಗ.
It, my lord.
ಅದಕ್ಕೇನು ಸಂಬಂಧ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಡಿ.
I have been continued by way of interim order, my lord.
No.
Now it is dismissed by the tribunal.
ಅದೇ ನಾ ಹೇಳಿದೆ.
My request for Thursday, my lord.
ಥರ್ಸ್ಡೇ ಡಿಫಿಕಲ್ಟ್ ಬ್ರದರ್. ವಿ ಹ್ಯಾವ್ ಡಿಫಿಕಲ್ಟ್ ಬಿಕಾಸ್ ಬೇರೆ ಬೆಂಚಸ್ ಇದಾವೆ ಅದಕ್ಕೆ.
Please, my lord.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರ್ತೀನಿ. ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ.
My lords, matter pertaining to 214(2)(b, my lords.
214 deduction from pension.
Yes, my lords.
ಕೊಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
My lordships, the petitioner doesn't have any source of income and their employment has not been regularized, my lordships. The KIT has dismissed their petition.
ಯಾವಾಗಿದ್ದು?
I'll seek instructions towards it.
ಸರಿ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಹಾಕೊಳ್ಳಿ.
Your lordship, serial number 27, your lordship.
27.
Yes, your lordship. This is departmental appeal, ITA. 15 days time can be granted, your lordship. This is the prosecution is going on in this matter. Prosecution is pending. 15 days time can be granted, your lordship.
Let us see when it reaches, not now. Yes.
Lordship, serial number 23, your lordship. May I
23.
ask for 2 weeks' time, your lordship?
ಯಾಕೆ?
Lordship, some instruction.
2017 matter.
Yes, your lordship. Last 2 weeks, it was argued, your lordship. Some records we have to ask for the client, your lordship. That's
No,
what is getting
no,
delayed.
not-
Next week, your lordship,
No,
please.
not I mean. Parted matter. We
Yes.
remember. Other day, your senior was arguing
But
that matter, no?
Yes, your
we
lordship.
know
Court
that. No,
has
no
asked
timing.
few records,
Yes,
your
next,
lordship.
next.
At
next.
least tomorrow, your
No, no,
lordship, please.
nothing like that. Yes.
My lords, in item number 10 and 11, requesting
number?
for 10 and 11, my lords, requesting for 2 weeks' time. The arguing
11.
counsel is in some personal difficulty.
You are for whom?
My lords, we
Respondent.
are for respondents.
But we will condone the delay. 122 days is there.
My lords, we have to object on the.
You file
delay.
objections. 1 year, how many, when you are served with the notice? ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ರಿ ನೋಟಿಸ್ ಎಲ್ಲ? Wait. You will not give time. Yes, next.
My lord, serial number 25, my lords.
25.
My lord, it may be tagged along with the CSTA 4 of 2009. It is arising out of the same order, my lords.
Huh?
CSTA 4 of 2009.
2009.
Please, my lord.
Will you argue this and we will duplicate this order into that matter? No time. Yes, next. When is having paid the amount
order
to
of this
respondent
under court
with
has been
original
complied.
check. Complied, huh?
Complete. You are in receipt of it.
You have received that money? Are you happy with the court? Okay.
Madam,
Learned senior panel counsel appearing for the appellant submits that the amount directed in terms of order dated 14/8, order dated
7/3/2025.
2025 has been handed to the writ petitioner who happens to be respondent
Yes.
herein. First stop. Counsel for the said writ petitioner and the writ petitioner personally are present before the court and they agree with the submission of learned panel counsel. All right.
Much.
Yes.
My lord, I'm the appellant in serial number 2 and 2.4.
2 and 2.4 you want to withdraw?
Please, my lord.
Why you not happy with the court?
My lord, the tax dispute has been settled under Vivad Se Vishwas scheme.
Barkadi. Learned counsel appearing.
Respondent, he is not there in the panel now. Even
my name may be. ಯಾರು ಹಾಕೊಂಡು ಹೇಳಿ. Got it. Learned ನೋಡಮ್ಮ serial number 2 and 2.4 ನಲ್ಲಿ learned counsel appearing for the appellant assessee submits that the list involved in this appeal has been settled. ಎಂತ ಯಾವ ಸ್ಕೀಮ್ ಅದು?
Direct tax Vivad Se Vishwas scheme 2000.
In terms of Vivad Se Vishwas scheme, and therefore the appeal be accordingly disposed of. Full stop. To this effect, he has filed a memo seeking leave of the court to withdraw the appeal, which reads as under. Next paragraph. Learned panel counsel Shri so and so has no objection for granting leave to withdraw the appeal. First, in the above circumstances, the appeal is disposed of as having been withdrawn in terms of memo. ಇದೇ ಆರ್ಡರ್ನ ಡೂಪ್ಲಿಕೇಟ್ ಮಾಡಿ 2 ದಲ್ಲಿ ಹೇಳಿದೆ ಈಗ 2.4 ದಲ್ಲಿ ಡೂಪ್ಲಿಕೇಟ್ ಮಾಡಿ.
So just one submission, the memo has been filed by the client itself, my lord.
Client himself. All right. No issue.
The, my lord, 2.1 and to 2.3, my lord, these matters were earlier kept pending because the matter is being disputed before the Supreme Court, my lord. On the earlier occasions also, my lords had taken note of that and.
But how long we can wait? Is there any restraint order by the apex court? You don't decide like this when such orders were there under section 24.
Please.
ಆ ರೀತಿ ಯಾವ್ದು of the
There are-
2013 land acquisition matter.
There have been contrary decisions of different high courts, my lord. And
Ah.
that's why my lords, on the previous occasion, had decided to keep the matters pending, my lord.
But how long we can keep it?
There are
We are
40
asking you.
There are 40, 50 matters clubbed, my lord, and in the batch matters in the Supreme Court, the matter is going on, my lord. There are about 40 matters, my lord.
Is it being heard?
Yes, leave has been granted, my lord.
Correct. But leave has been granted. The apex court said, unless we halt the proceedings, the high court should not halt the proceedings.
Because revenue as well as the assessee both are before the Supreme Court. my lord. Therefore,
Subject to outcome of that, we will dispose of this.
yes,
My lord, can be posted on some other date, my lord. We'll make our submissions on the matter.
Call these matters. Along with the list ಕೊಡಿ ಯಾವ್ದಾವ್ದು matters first list ಕೊಡಿ ಎಲ್ಲ ಮುಗಿಸ್ಬಿಡ ನಾವು ಇಟ್ಕೊಂಡ್ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಪೆಂಡೆನ್ಸಿ ಸಲುವಾಗಿ
it is before Supreme Court, my lord, 40 matters.
ಅಲ್ಲ
are there.
ಇಲ್ಲಿರೋ ಮ್ಯಾಟರ್ಸ್
Illiro matters, I will make a list.
ಅದನ್ನ ಕೊಡ್ಬೇಕು ಲಿಸ್ಟ್ ಕೊಡ್ಬೇಕು
Yes.
ಕಾಲ್ ದೀಸ್ ಮ್ಯಾಟರ್ಸ್ along with other connected matters, other similar matters, list of which should be furnished by the panel counsel
Within a week time.
within 1 week. First off, post after 2 weeks.
Yes.
Great.
Yes, next.
For the respondent, this matter is also settled under the VSV scheme.
Nodama. The appellant assessee has filed a memo dated so and so,
My lords, I'll be the respondent in this matter.
respondent assessee,
I am for the appellant.
disposed of.
Yes.
ಮಾಡ್ಬೋದಾ ನೋಡಮ್ಮ
Liberty may be reserved, my lord. Liberty may be reserved.
learned counsel appearing for the panel counsel appearing for the revenue submits that the list in question has been settled under vivatse.
This one. Your lordship, the submission is made by the respondent counsel, ma'am. They have filed the memo. On the basis of that memo, it may be disposed of.
ಅಲ್ಲಿ instead of senior panel counsel ತೆಗೆದು learned counsel appearing for the respondent assessee has filed a memo dated 28/2/2025, which reads as first off, in view of the memo, the appeal is disposed of.
My lord,
First off, if assertion made through the memo is not true, comma, it is open to the appellant revenue to seek revival of this appeal. Okay. Ordered accordingly and appeal disposed of. Next.
I'm appealing to the appellant.
Have you
Order
given
has
the
been
books?
complied, please, man.
Which books you have given?
Pulimavina Maraman.
Yardu.
To the
Who is the author of that book?
P. Lankesh Malan.
Correct. ಓದ್ಬೇಕು ಅವನ್ನೆಲ್ಲ. All right. The compliance of order dated 5/2/2025 is reported. Okay. Written submission. Dispense, the filing of written submission dispensed with. Then IA2 for dispensation ಏನದು? Huh?
Lordship,
Appeal is already admitted.
appeal is already admitted.
Huh.
IA, arrestor A, Lordship is the order of the tribunal that required to be stayed. I have completely paid the demand.
Then why it should be stayed?
Only reason is the same order is being cited in other cases. Only it will lead to multiplicity. That's all.
Again, they can come to this.
There is no consequence in this case.
What he says appears to be sensible. Yeah, that order is being reprinted in other appeals.
Other appeals.
ಅದು ಇಲ್ಲಿ ಜಾಸ್ತಿ ಹಾಕೋತ್ ಹೋಗ್ತದೆ. ಇದು ಮ್ಯಾಟರ್ ಮುಗಿಲಿ. ಇದನ್ನ ಬೇಕಾದ್ರೆ ಆರ್ಗ್ಯೂ ಆರ್ ಯು ರೆಡಿ ಇನ್ ದ ಮ್ಯಾಟರ್ ನೌ?
Yes, Lordship, it can be fixed any date.
Fixed any date. Are you ready now in the matter?
Lordship, it's not posted for final hearing.
Anyway, that makes no difference because of the apex court.
I'll file the paperwork, short date maybe.
All right. Counsel for the appellant revenue wants to file a paperwork, and therefore 3 weeks, a period of 3 weeks is granted to do the needful. First up, application in IA number 2 of 2024 is favored and dispensation as sought for is granted. Okay. Next,
Annexure A,
non-compliance of office objections.
that is already complied, Lord.
Complied.
Complied.
Office objections are complied.
Stay of Annexure A.
Admit ಆಗಿದೆ ಏನಿದು?
Admit agide.
ಏನಿದು ಮ್ಯಾಟರ್?
A question of law on the cost of acquisition. Imputed cost of acquisition on 1/4/2001 is what I have adopted.
ಕ್ಯಾಪಿಟಲ್ ಗೇನ್ಸ್ ಇತ್ತಾನೆ.
Capital gains. Bonus shares, so the department says I have to take the nil cost. But under section 55(2)(b),
How brother, nil cost? How nil cost? Whether land comes from heaven? Some cutoff date is fixed. As on that date, what is the cost? That will be the factor. That's what we have said in the Dharwad.
Not gone through the papers, maybe.
Call after 2 weeks at the request of. Stay application, where is the no application for stay?
yeah, yes, sir, there is in
ಎಲ್ಲಿದೆ? ಹಾಕಿರಾ?
Annexure A may be state. Page number.
You have to, this is an appeal, not writ petition. Therefore,
Appeal.
separate application has to be
Yes,
filed.
sir, in page 178, there is an application.
You have filed that?
Yes, sir.
Appeal is now admitted.
appeal is admitted.
Barkali. Learned counsel appearing for the assessee submits that appeal having been admitted on the question of law, comma, under section 70. ಯಾವ section 60?
268.
268, the substantial question of.
Yes, yes.
On the substantial question of law framed, comma, interim protection is to be accorded. First up, he draws our attention to the application filed in this regard, which is supported by an affidavit. First, ordinarily, the apex court said, ordinarily, comma, the apex court said, comma, where appeal is admitted, the interim protection needs to be granted subject to all just exceptions. First, no exceptions are pointed out by the counsel representing the revenue. First, in view of the above, the interim, stay of
Annexure A.
impugned order, stay of impugned order.
It is also submission made by the appellant that all taxes have been paid.
Yes, demand I have already discussed.
While making this order, we have noted the submission of counsel for the assessee that entire demand in terms of the order in question is met.
Yes,
Okay,
much obliged.
next. ಅದು ಎಷ್ಟಿದೆ ಇಂಥ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಪೂಲ್ ಮಾಡಿ ಮುಗಿಸ್ಬಿಟ್ರು. ಇಟ್ಸ್ ಕವರ್ಡ್ ಬೈ ದಿ ಜಜ್ಮೆಂಟ್ ಇನ್ ಧಾರವಾಡ ಬೆಂಚ್.
No, there are no other matters.
All right.
Serial number 6, I'm appearing for the petitioner, my lords.
Yes.
The office objection is with respect to.
Maintainability. What is this matter?
My lords, and I'm not made R3 and R4 as a party, my
Right.
lords. No claim is sought against them, my lords.
Now, what is this maintainability?
My lords, may I make a request, ma'am?
6. Sorry.
May I make,
Six.
may I make a request? ma'am?
Ah.
My lords, my name is shown as representing R2, my lord.
Ah.
I've resigned from the Lokayukta institution, my lord. Lordship.
You are resigned.
Please,
So who appears?
Lordship, my
Sri Venkatesh Rabatti is requested to appear for the second respondent Lokayukta,
please.
comma, learned counsel Sri Haladi having been permitted to retire from the case.
I will inform.
I'll call this matter.
Monday, my lords, my kind.
What's the urgency?
My lords, he's been dismissed from service, my lords.
ಇರ್ಲಿ, ಎಷ್ಟು ಯಾವಾಗ ಆಗಿದೆ dismissal?
Agide, but
Call after 4 weeks. Next.
Great.
Ah, 7. ಕೊಡಿ. ಅಪೀಲಿಂಗ್ ಮಾತ್ರ ಬರಲ್ಲ. How CRP is maintainable? Post this matter tomorrow for a possible dismissal. So that counsel for the petitioner would come and argue on maintainability. Yes. Registry to show it, show this in the record list. Okay. Krishnamurthy for the,
Appearing for the respondent number 1, your lordship.
you appear for first respondent.
Yes, your lordship.
Steps of Krishnamurthy.
I have already taken a hand summons after obtaining permission from your lordship.
You have served.
I have served and I have already filed in the office also. I don't know, the office has not shown in the list.
Shri Krishnamurthy appearing for the petitioner submits that the hand summons has been served on respondent number 2 and an acknowledgement is also filed in the registry on
24/2/25.
24/2/2025. First up, registry to verify. Post this matter after 2 weeks. Interim order is there.
There is an interim order, but there is an urgency for this reason. Not 1 year is expiring by the.
Interim order, the period will be excluded.
No, what happened in this matter is respondent number 1 has filed the counter as well as the.
No, anyway, any
Statement of
limitation,
defense.
while computing the limitation period under any law.
Yes.
Where the stalling of proceedings takes place because of the court orders, that period has to be excluded.
My lord, here is a little different problem, my lord. What happened is now proceedings, though proceedings is not stayed, proceedings cannot continue because the second respondent pursuant to the order has submitted the his statement of defense, but by that time this court has passed an order of stay. So therefore, that cannot be taken into consideration for framing the issues. Now, therefore, virtually the proceedings cannot continue there, but there is a 1 year period which is fixed under section 23 is going to expire in May. So therefore, in May. So therefore, if this matter is disposed of.
Call this matter in the second week of April.
Please.
Not
That's one
but-
submission.
May I request in the first week, my lord, at least, because we will have sufficient.
Already post back ಹೋಗಿದೆ. Second week we are not very sure, but ಬರಲಿ at least very interesting point ಇದೆ. ಆ ಕಾರಣಕ್ಕೆ.
May I make one submission? Respond number 2, I am representing minutes.
ಮತ್ತೆ ಸುಮ್ಮನೆ ಇದ್ದೀರಲ್ರಿ.
ಅದು respond number 3 ಗೆ minutes.
ಈ ಆರ್ಡರ್ ರೆಸ್ಪಾಂಡ್
That is, that summons is for
ತೋರ್ಸಿದ್ದಾರೆ.
respondent 3.
wrongly shown. R3 ಆಗ್ಬೇಕು.
R3.
R3. Okay.
Please.
ಒಂದ್ಸರಿ R3 ಹೆಸರು just ಹಂಗೆ ಕೂಡಿ.
May I request for a date, my lord?
Native Resorts Private Limited. Native Resorts Private Limited.
Court officer called out name of third respondent loudly in the open court. First off, there is no response. Call this matter in the
May I
second
request
week
for
of
a date, my lord?
Bharat, next.
Please.
Yes,
No, the petitioner is a
dispensed with.
Kannada translation. No, the petitioner is a retired, my lord, assistant sub-inspector. He was involved in a trap case. My lord, he was imposed with a punishment. Kindly go to my lord, ink page 48.
48. ಏನ್ punishment?
My lord, page 51. Increment was, my lord,
Withholding of increment by 2 years.
and he retired from service on 31/8/2012.
31, oh,
18/8 punishment, 31/8/2012, he retired.
ಆ ಪೀರಿಯಡ್ ಇರಲಿಲ್ಲ ಅವರಿಗೆ.
Andre, he, my lord, he agreed for, my lord, the punishment.
ಅಲ್ಲ ಹಂಗ ಪನಿಷ್ಮೆಂಟ್ ಇಫೆಕ್ಟ್ ಆಗುದಿಲ್ಲ.
31.
Because apex court say where the postponed period will not occur because of pre-retirement, then such a punishment cannot be imposed.
Now, he has not questioned it, this punishment. Criminal case, my lord, it's a case of, my lord, he has taken trap case. Allegation is he has taken 5,000 rupees for closure of a criminal case.
ಆ ಕೇಸ್ ಏನು?
ಅದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಕನ್ವಿಕ್ಷನ್ ಆಗಿ
ಆ ಕನ್ವಿಕ್ಷನ್ ಏನ್ ಕೇಸ್ ಅದು? ಕ್ರಿಮಿನಲ್ ಕೇಸ್, ಮರ್ಡರ್, ಡಕಾಯಿಟಿ,
prevention of corruption. Against that, my lord, conviction was passed, criminal appeal is pending. Now, my lord, parallelly departmental inquiry was conducted and this punishment is imposed. I have not questioned this order. For 4 years, they have granted the pension. Thereafter, they have stopped. But I approached the tribunal, my lord, for releasing of pension, because it would be imposing 2 punishments for the same offense. Now,
what is first time, my lord, issue emergent notice, learned AGA is requested to accept notice for official respondents. ಅಷ್ಟೇ ಪಾಯಿಂಟ್ ಅದು ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು.
may I seek indulgence of this honor, provisional pension on the way.
ನೋಡೋಣ,
70 ವರ್ಷದ ಆಗಿವೆ.
ಅದು 70 ವರ್ಷ ಅಂದ್ರೆ ಅವ್ರು ಕ್ಲೀನ್ ಹ್ಯಾಂಡ್ ಇದ್ರು ನಾವು ಒಪ್ತಿದ್ವಿ.
ಅಲ್ಲಲ್ಲ, ಆ
60 ಇದ್ರು ಒಪ್ತಿದ್ವಿ. ಅಲ್ಲೆಲ್ಲ ಕೈ ಎಲ್ಲ ಹೊಲ್ಸ್ ಮಾಡ್ಕೊಂಡು
ಇಲ್ಲ ಆ ಎವಿಡೆನ್ಸ್ ಮೈ ಲಾರ್ಡ್,
ಕನ್ವಿಕ್ಷನ್ ಯಾಕೆ ಚಂದ ಆಗತ್ತಾ? ಆ ಮೊದಲಿಗೆ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ ಅಂತದೇನೋ ಮಾಡಿರ್ತಾನ ಅವನು. ಎನಿವೆ
ಅಂದ್ರೆ ಎವಿಡೆನ್ಸ್ ಮೈ ಲಾರ್ಡ್, there is no.
ನೋಡೋಣ ಅಲ್ಲಿ ಏನೋ ಸಮ್ ಪಾಯಿಂಟ್ ಇದೆ ನೀವು ಹೇಳೋದ್ರಲ್ಲಿ. ಡಬಲ್ ಪನಿಷ್ಮೆಂಟ್ cannot be imposed ಅನ್ಕೊಂಡು.
And your lordship's judgment is there, my lord.
ಅದೇನ್ ಬಿಡಿ, ಇದೆ ಎನಿ ನಂಬರ್ ಆಫ್.
It's a property, my lord, pension is a
not property provided he properly conducted himself as a civil servant. Okay,
may I seek
ನೋಡೋಣ notice please. Okay.
Lordship, in this case, there is delay of 122 days. I have already filed the additional affidavit and it is also served, my lord.
Yes, sir.
Seal number 10 and 11 are connected, my lord.
10 and 11, maybe he couldn't log in, Lordship. He wants time, 2 weeks time, your Lordship.
10 and 11. When did you serve the copy of application?
January 25, my lord.
25.
Even
January
the
25.
Copy is not,
ಇನ್ನೊಂದು copy ಕೊಡಿ.
are not given, your
ಅವ್ರಿಗೆ
Lordship.
ಇನ್ನೊಂದು copy. Call this matter next week.
2 weeks, your Lordship. 10 and
No, 2 weeks.
your Lordship.
Next week. Okay.
Magic.
Okay. Finally, date ಕೊಡಿ. That date ಬರ್ಬೇಕು ಈ matter. All right.
I am appearing for the petition, my lords.
Yes, sir.
We are withdrawing this petition.
Okay.
Well,
He wants to withdraw.
please, my lords, there's one submission here. The parties, that is, I was the petitioner on the basis of whom the underlying order is passed, which is by way of which CIRP was initiated. The parties have settled the matter. Resultantly, my lords, my request would be that the underlying order may be set aside because today there is no underlying debt. So simple withdrawal would only mean that the CIRP order I have taken the money, my lords. So I must rightly put the settlement agreement before this honorable court.
ಇದೆಯಾ ನಿಮ್ಮಲ್ಲಿ?
Please,
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿರಂತ.
please, my lords.
ಮತ್ತೆ ಹಂಗ ಹಾಕ್ಬೇಕು. ವಿಡ್ರಾವಲ್ ಮಾಡಿ ಹೋಗ್ಬಿಟ್ರೆ ಮುಂದೆ again you will proceed against them.
Please, my lords.
Whether settled.
Please, my lords.
Settled.
Yes, my lords.
ಸರಿಯಾಗಿ ಉತ್ತರ ಕೊಟ್ಟಿರಿ. ರೆಕಾರ್ಡ್ ಆಗ್ಲಿ ಇಲ್ಲೆಲ್ಲ. ನಾಳೆ ಹಂಗ ಹೇಳಿಲ್ಲ ಹಿಂಗ ಹೇಳಿಲ್ಲ ತೋರ್ಸ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಇಲ್ಲಿ ರೆಕಾರ್ಡ್ ನಲ್ಲಿ ಇದೆ ಅಂತ.
My lords,
Whether they have settled the dues.
Yes, my lord.
they have settled my dues.
How much money they have settled?
My lords, they have given me money. Please.
Yes.
As per the instructions, my lord, today morning we have got mail that from the client.
Where is that mail copy? Mail copy.
It's not.
Not with you.
No.
What it says. But if you agree that there is a settlement, then in terms of settlement, matter has to be disposed of. Otherwise, if you withdraw, the impugned order remains as it is, and consequently proceedings may be taken against her or client.
I'll seek instructions, my lords, please.
Pass over.
Please, my lords.
Pass over. ನೋಡ್ಕೊಂಬನ್ನಿ. ಬರೀ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ ಮತ್ತೆ ಹರೆಸ್ ಇಲ್ಲ ಅವರು ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಅನ್ಕೊಂಡು ಹೇಳ್ತಾರ. ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಟ್ ಸೆಟಲ್ಮೆಂಟ್ ಪಿಟಿಷನ್ ಈಸ್ ಡಿಸ್ಪೋರ್ಡ್ ಆಫ್, ಇಂಪ್ಯೂಗ್ನ್ಡ್ ಆರ್ಡರ್ ಈಸ್ ಸೆಟ್ ಎಟ್ ನಾಟ್. ಇಫ್ ಅಸರ್ಷನ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಸ್ ನಾಟ್ ಟ್ರೂ, ಇಟ್ ಈಸ್ ಓಪನ್ ಟು ಯು ಟು ಸೀಕ್ ರಿವೈವಲ್. Anyway, you also want to withdraw. ಬರ್ಕೊಳ್ಳಿ. Learned counsel appearing for the petitioner seeks to withdraw the petition.
One submission. I appear for respondent number 3 RP in this matter. My fees is not been paid since March 2023, my lord. That's why I filed an application.
You will pay that.
No, my lords. I had twofold submission. I was directed to pay 2 lakh rupees to them for 1 month by the Honorable NCLT, which I have paid. Thereafter, this Honorable Court passed an order directing no further proceedings. I informed
Therefore,
him.
you will not pay any fees at
No,
all.
my lords. It appears when this order came to be passed against me, I informed him there is an order against which this Honorable Court says don't take precipitative action. It appears that they have continued to work for the petitioner and they're raising a bill of 40 lakhs on me. My lords, he's not been confirmed because there was a stay order. Therefore, in my opinion, there was no question of him working for the petitioner and then asking me to pay for that money. For the 1 month that he paid, NCLT told me give him 2 lakh rupees. I've given him 2 lakh rupees.
Generally, where money, the fees are not paid, where application should be filed?
By NCLT.
We will permit you to move the application.
Liberty may be given.
Learned counsel for the petitioner has filed a memo seeking leave of the court to withdraw the petition. First, learned counsel appearing for respondent number
2, my lords.
2 submits that mere grant of leave to withdraw is likely to prejudice interest of her client in as much as full settlement has already been done. First up, we find logic and justice in the submission of learned counsel appearing for second respondent. First up, next paragraph. At this stage, learned counsel appearing for respondent number 3 submits that his fees have not been settled by the second respondent. First up, the second respondent submits that after interdiction of proceedings before the NCLT by virtue of an order made by a coordinate bench of this court, the question of paying any fee would not arise. First off, she also adds that whatever arguable services the third respondent has put in is for the benefit of the petitioner and not for her client. First off, this dispute need not be examined by us in as much, the right forum for this being the NCLT itself, where parties can join issues. First, in that regard, all contentions are kept off. Next paragraph. In the above circumstances, writ petition is disposed of, setting aside the impugned order in terms of pleaded settlement. First, if assertion of settlement is not true, it is open to the aggrieved to seek revival of these proceedings. First, ordered accordingly.
Please, much obliged, ma'am. Much obliged.
Having settled ಅಂತನೇ ಇದೆ ಅಲ್ಲಿ ಒಂದು ಮೆಮೊ ರೀಡ್ಸ್ ಆಸ್ ಅನ್ ಬರುತ್ತೆ ಹಂಗಾಗಿ ಇದು ಬೇಕಾಗೋದಿಲ್ಲ ಲಾಸ್ಟ್ ಪಾರ್ಟ್ ನಾಟ್ ಟ್ರೂ ಇದೆಲ್ಲ ಇದೆಯಲ್ಲ ಅದೆಲ್ಲ ಬೇಕಾಗೋದಿಲ್ಲ ದೇ ಹ್ಯಾವ್ ಸೆಡ್ ಸೆಟಲ್ಮೆಂಟ್ ಇನ್ ದ ಮೆಮೊ ಎಸ್
My lords, I'm for petitioner.
Yes,
kindly request you to pass over the matter. Colleague is on the
Set-top box matter.
set-top box.
Set-top box matter, your lordship.
covered by judgment.
Yes, my
In
lords.
your favor. Still you don't want order.
Illa, sir.
Set-top box is.
So fairly he is saying, na? Akali.
My lords, only one submission.
Kindly be seated. Kindly be seated. Fee ಏನ್ರ ಬರೋದಿದೇನೋ? Fee settlement ಆಗ್ಬೇಕಾ?
Illa, my lord. We have couple of submission to be. My senior is on the way, so we have filed one more writ petition for a different year. So I kindly request you to pass over my.
Pass. The application allow ಮಾಡೋಣ. Condonation of their short.
Condemnation.
Yes.
Notice agilva. Issue notice. Learned AGA Aditya Vikram Bhatt is requested to accept notice for respondents. First, appeal is filed after booking a short delay of 54 days.
Yes, my lords.
First, an application supported by affidavit in IA number 2 of 2025 is moved, seeking its condonation. First, delay being short and explanation for that being plausible, comma, the same is condoned. Application is disposed of. All right, pass over.
There is one more matter, my lord. 21, serial number 21, similar
21
matter for different year.
Doesn't appear to be any delay there.
No, that
20.
is not for a delay, my lord.
21.
It's for admission.
Okay.
So that also we will make some submission.
All right, ನೋಡಮ್ಮ
Pass over me.
ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಅದನ್ನ ಜೊತೆಗೆ ಮಾಡಿ. All.
Much of.
Whether any stay has been granted by the apex court?
No, my lords.
No stay has been
No,
granted.
my lords. Matter has been tagged with the
Other pending matters of others.
Tripura and Allahabad, and no stay was granted.
All.
Appear in the connected matter.
Yes, sir. This pass over.
Sub registrar.
ಹಾ ಎಷ್ಟು ಸರಿ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಇದು ಈ ಮ್ಯಾಟರ್ 3 ಸರಿ ಬಂದಾಗ? ಹೌ ಮೆನಿ ಟೈಮ್ಸ್ ವಿ ಹ್ಯಾವ್ ಪಾಸ್ಡ್ ಓವರ್? ಹೌ ಮೆನಿ ಟೈಮ್ಸ್ ವಿ ಹ್ಯಾವ್ ಅಜೆಂಡ್? ನೋ, ನಿನ್ನೆ ಇದು ಯಾವತ್ತು ಬಂದಿತ್ತು? ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ಸ್ ಅದಲ್ಲಿ ಇದು.
ಹೌದೌದು.
ಹಾ ಮತ್ತೆ
ಲಾಸ್ಟ್ ವೀಕ್ ಇಂದ ನಿನ್ನೆ ಬಂತು, ನಿನ್ನೆಯಿಂದ
ಲಾಸ್ಟ್ ವೀಕ್ ಬಂದಿತ್ತು. ಅವಾಗೂ ಪಾಸ್ ಓವರ್ ಮಾಡಿಕೊಂಡು ಆಮೇಲೆ ನಿಮ್ಗೆ AG ಬರ್ತಾರಂತ ಹೇಳಿದ್ರಿ, ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು, ಡೇಟ್ ತಗೊಂಡ್ರು. ಏನ್ ಚಿಕ್ಕ ವಿಷಯ ಇದೆ, ಆ ಡೇಟಿಗೆ ಸರ್ಕ್ಯುಲರ್ ಆಗಿತ್ತ ಇಲ್ಲೋ ಅಂತ ನಾವ್ ಇಷ್ಟು ಕೇಳ್ತಾ ಇದ್ದೀವಿ. ಪಾಸ್ ಓವರ್. ಚಿಕ್ಕ ಚಿಕ್ಕ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಇಟ್ಟು. ಎಸ್
Lord, reopening of assessment, my lord.
Yes, sir.
It was beyond 4 years, so they had to obtain the permission of the commissioner. Now the tribunal decides the matter, keeping open this jurisdictional issue, and decides the matter on merits, my lord. That is why we have come up.
How? It goes to the root of the matter.
It has to be decided.
Decided all. That order has to be satisfied. Where is the sanction? Sanction is a must.
Your Lordship, whether there is sanction or not, whether the conditions or.
You should say.
That has to be argued. my lord.
Argued ಅದು. ನೀವು sanction ಆರ್ಡರ್ ಕಾಪಿ ತೋರಿಸ್ಬೇಕು.
Tribunal has to give reasons.
ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ ಈಗ. ನೀವು ನಮಗೆ ತೋರಿಸಿ. ಮತ್ತೆ ಅಲ್ಲಿ ಕಳಿಸಿ ಒಟ್ಟೆ ನಾವು ಲಿಟಿಗಂಟ್ ಅನ್ನು ಹರಾಸ್ ಮಾಡಿ ಕೂತ್ಕೊಡ್ಬೇಕೋ ಏನು? ಇಲ್ಲಿ ತೋರಿಸಿ ನಮಗೆ. ಸ್ಯಾಂಕ್ಷನ್ ಕೊಟ್ಟಾರ ನೋಡಿ ಸ್ವಾಮಿ, ಕಳಿಸಿ ಕೆಳಗೆ ಅಂತ.
Get the records.
ಎಸ್ ಬ್ರದರ್, ಎಷ್ಟು ಚಿಕ್ಕ ಚಿಕ್ಕ ಮ್ಯಾಟರ್ಸ್, ಎಷ್ಟು ಸಿಂಪಲ್
To ascertain whether there was a
ಸ್ಯಾಂಕ್ಷನ್ ಆರ್ ನಾಟ್.
and reasons.
ಅದಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ಅಗತ್ಯ
ಇಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ತರಿಸ್ಕೊಂಡು ನೋಡ್ಬೇಕಾಗುತ್ತೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡಿ, ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಮಾಡಿ. ಆಲ್ ರೈಟ್. Reluctantly adjourned by 2 weeks.
Or it may be sent back to a tribunal to consider.
Why?
With a time frame, my lord.
Correct. Why we should send back? Suppose if it is time but again one more exercise. ಆಮೇಲೆ ಅವರು ಇಲ್ಲ ಅದನ್ನ ಅಗೇನ್ ಏನೋ ಒಂದು ಹೇಳಿಕೆ ತಪ್ಪು ಹೇಳಿ ಕಳಿಸ್ತಾರೆ, ಮತ್ತೊಂದು ಪಿಟಿಷನ್ ನಮಗಿಲ್ಲಿ ಬೇರೆ ಕೆಲಸ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ, ಬೇರೆ ಇವನ್ನ ಮಾಡ್ಕೋತ ಕೊಡ್ಬೇಕಾಗ್ತದೆ. You see, whether there is sanction or not is not a matter of argument. Whether something is a rainbow or not, whether it's a ವಿಬ್ಗ್ಯೂರ್ ಇದೆಯಾ ಇಲ್ಲೋ, ಅದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೋದು. ಸ್ವಾಮಿ, 2 ಬಣ್ಣಗಳು ಸರಿಯಾಗಿ ಕಾಣ್ತಾ ಇಲ್ಲ. ಎಸ್, ವಿ ಮೇ ಆರ್ಗ್ಯೂ ಅಲ್ವಾ? ಈ ಸನ್ ಆರ್ ಮೂನ್ ಅನ್ನೋದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇಕಾಗಲ್ಲ, ಎಲ್ಲ ನೋಡ್ರಿ ಗೊತ್ತಾಗ್ತದೆ. ಅಷ್ಟೇ ಇದು ತೋರಿಸಿ. ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ ಈಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು secure the record and make a submission as to whether for reopening of the assessment, the sanction of the jurisdictional commissioner of income tax was accorded in as much as such an exercise was undertaken arguably after the lapse of 4 years. Okay.
2 weeks.
2 weeks.
My lord, I appear for them. This relates to an import of a gold.
Import of gold.
May I submit, my lords?
Under the foreign trade policy.
Yes, they will file certain documents.
23 appeal.
They have said that they will be furnishing some documents. In the meantime, this matter, so far as respondent is concerned, my lords, Mr. Kiran Javli will.
ಸ್ವಲ್ಪ ಜೋರ ಮಾತಾಡ್ಬೇಕು, ಕೇಳ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ, ಕೇಳ್ಬೇಕು ಹಿಂದವರಿಗೆ. ಮೈಕ್ ತೊಳಿ.
Kiran Javli would.
Case weak ಇದೆಯೇನೋ?
Kiran Javli would be appearing in this matter. Last week, he collapsed in the court hall itself.
Why?
My lords, because.
Today?
No, last week. Now.
Wait, what happened?
He was unwell, my lords.
How is he now?
Now he is better.
All right, call after
For admission,
weeks.
my lord can admit it and.
Kiran Javli is not well.
May I just, my lord, place on record some, my lord,
ಹೆಂಗೆ ಅಪೀಲ್ ಅಪೀಲಿಗೆ ನೀವೇನಂತ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು ಹಿಂಗೆ ರಿಟ್
relevant provisions, relevant provisions which have been relied upon in the appeal memo.
ಅಷ್ಟೇ
ಅಷ್ಟೇ. ಅಂದ್ರೆ ಅದು
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
ಅವರು extract of the foreign trade policy and my lord hand.
These are all subordinate legislations ಆಗ್ತದೆ.
Subordinate legislations, my lord. So I have extracted the relevant, my lord, the portions of it which have been relied upon. Just for the
Mr. Niralgi, learned panel, senior panel counsel appearing for the revenue, has placed on record certain documents after serving copy thereof on the other side. First, call this matter after 2 weeks. 2 weeks. Tell Mr. Javli that we have wished him speediest recovery.
Please, my lords.
Yes, Satyanarayan.
The foreign, my lord. My colleague is in VC. My colleague is VC.
In VC is arguing. All right. Yes, brother.
Yes, my lord.
Enidu?
My lord, this is with respect to 64-1 order, which is passed, my lord.
64-1 order, revision order.
Revision order, SMR order, passed by the ADCOM, my lord.
Now, you know, what is the fault in this order?
Joint Commissioner has passed an order in my favor, and subsequently this was SMR has been taken, initiated.
And reversed.
And reversed, and to the extent, I mean, the entire amount, entire turnover, they have been considered as a turnover, my lord. I mean, which means total amount, entire gross amount, whatever they shown, entire thing they considered as a turnover, and they have levied tax.
But then turnover tax, enidu?
Total.
What is this matter, Mr. Aditya?
My lords. Matter contains, pertains to, my lord, 3 issues. One is the deduction of labor and like charges in a works contract. There is, if he produces books of accounts, vouchers, etc., I can take a look at that. He refuses to produce it. And even at this stage of reassessment, he refuses to produce it. There is no foundational basis found in his return. Point number 1. At the stage of reassessment, he ignores the proceedings. I am constrained to conclude the proceedings ex parte. Matter pertains to labor and likes charges, the claiming of TDS and input tax credit. Then, my lords, the first appellate authority, he goes and admits that his accountant, with an intent to commit fraud, has submitted inflated documents, overstated the eligibility, etc., etc. Still no documents are produced. For some reason, my first appellate authority sympathizes and says, oh, if it is the accountant that has committed fraud, we will remit it back, it can be looked into. So motor revision picks it up and says, look, you have not produced anything at the stage of reassessment. This admission of fraud, does not come to your benefit, and these sort of stories are an afterthought. And therefore, my lords, it is
His agent's fraud, he cannot take benefit of that.
Not take benefit. He cannot take benefit. And there is a categorical admission. And the suo motu revision authority also says that, look, you have taken, it is not as if that fraud is dehorsed you. That fraud is consistent with your other filings such as VAT 100 and your other documents, etc.
My lord.
Which you have signed. Therefore, my lords, on several grounds. One is foundational basis in the return being lacking. Point number 1. Second, it is a case of fraud in the revenue. Third, my lords, there is still no books of account.
My lord,
suppose once you agree that it is a works contract,
my lords.
So naturally, the labor or service component will be there.
Yes.
My lord.
On that, what is the law?
Yes.
My lord, in my submission here, which means the total turnover, which is as per turnover, I mean, fraudulent.
Which place you are arguing from? Now, ಎಲ್ಲಿಂದ argument ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
Bangalore.
ಯಾಕೆ ಇಲ್ಲಿ ಬರಬಾರ್ದು? ಇಲ್ಲಿ ಬಂದ್ರೆ ಒಂದ್ ದಿವಸ ಮುಗಿಸ್ಬಿಡ್ಬೋದಲ್ವಾ?
My lord, just some sort of difficulty, my lord.
Your difficulty?
No, actually, I was some in hospital. I mean, some issue, so I'm not able to come.
ಒಂದೇ ಆದ್ರೆ ಒಂದು ಡೇಟ್ ಕೊಡೋಣ, ಆರಾಮ್ ಮಾಡ್ಕೊಂಡು ಬರ್ರಿ.
No, my lord, this is something which is very clearly turnover, what they considered, the turnover considered itself is wrong, my lord, because my what I said, my accountant, previous accountant, what he has done, which is actually error. I mean, wrong, the fraudulent ankondu kuda. Subsequently, we have made a payment, my lord. I mean, the payment, whatever we taken refund, fraudulent refund, which is already refunded. And the turnover, which is, he wanted to match that to.
ನೀವು ಯಾವ ಡೇಟಿಗೆ ಇಲ್ಲಿ ಬರ್ತೀರಿ ಹೇಳ್ರಿ, ನೀವು ಇಲ್ಲಿ ಬರ್ಬೇಕು. ಇಲ್ಲೆಲ್ಲ we have to turn pages here.
Okay, okay.
Simple ಇಲ್ಲ.
Okay, my lord. I mean,
ನೀವು ಯಾವ
any
date
day,
ಅಂತ ಹೇಳಿ ಆ ಡೇಟಿಗೆ ಇಲ್ಲಿ
any at the earliest date, my lord. At the earliest date, anything.
ಏನಂತ?
At the earliest, any date.
Earliest date.
ನಾಳೆ ಹಾಕೊಂಡು ಬರ್ತೀರಾ?
Okay.
ನಾಳೆ ಹೆಂಗಿದೆ? ಹಾಕಬಹುದಾ?
Okay.
ಇಲ್ಲ, ನಾಳೆ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ. ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್ಸ್ ನಾಳೆ. ಇದು ದಿಸ್ ಆಲ್ಸೋ ಟ್ಯಾಕ್ಸ್. ಜಸ್ಟ್ ಲೆಟ್ ಅಸ್ ಸಿ. ಕಮ್ ಟುಮಾರೋ.
Okay, man.
ನಾಳೆ ಬರ್ತೀನಿ ಅಂತಾರೆ. ಆಲ್.
Same matter next month. Similar matter.
Identical. I'll call along with 17, 18 together tomorrow.
This appeal is also settled under the scheme. This file on them.
Same order. Vivad se
Vishwas scheme.
Vishwas scheme. Disposed of.
And liberty might be reserved for the SSC in the event. Because my appeal, in the event the forms are not subsequently issued, have been issued only form 2.
Liberty is reserved to the assessee to seek revival of this appeal in the event the efforts to settle the list in terms of Vivad se Vishwas scheme does not fructify. Okay.
Great.
Income tax.
My lords.
Question.
My lord, I am praying for a remand in this case, my lord. May I just state the facts, my lord. In this case, what has happened is, I am a cooperative society. I have formed a layout and transferred it to my members. Order came to be passed, treating the entire sale consideration as capital gain. I filed an appeal to CIT. CIT accepts that it is business income, allows me partial relief. I go before the tribunal and say, I am a mutuality, nothing should be taxed. Worst case scenario, you should tax only the profits. The tribunal doesn't give me time to file documents insofar as mutuality. It is an admitted fact I am a mutuality.
Mutuality ಅಂದ್ರೆ ಏನದು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ನೀವು ಸ್ವಲ್ಪ
I'll explain, my lords. What happens is, a group of people come together, pool money, buy land and allot farm sites and get it transferred to themselves. So basically, there is no profit motive.
Group of people, unincorporated.
No, we are an association of persons.
Association of persons.
Please, my lord.
That's unincorporated act.
Yes.
Association is not incorporation.
My lords. I am registered in the Registrar of Societies as an AOP, Association of Persons. We don't have a profit motive. We buy land, farm sites and get it allotted back to us.
To yourselves.
Please. The society here is the face of all the members together. So the tribunal holds saying that I have not filed documents. I have filed an affidavit to the effect that I have asked for time. I just need to file my memorandum. That's all.
What is the status of association under the Income Tax Act? Under general law, Justice Venkatramaya, yes Venkatramaya, where in a club where wine was served. The club sold the wine to club members, therefore tax is payable on the tax hakid. Justice yes Venkatramaya said, if wine is served by right hand to the left hand, it is not a sale on the whole.
It is not for profit, it is no
Not-
profit.
No, there is no sale at all.
No sale.
If I take wine bottle from my left pocket, sachet, and puts that sachet in the right pocket, there is no transfer of property.
Your lordship, but in this case, not they have to prove, your lordship, in this make, they are making the layout, they have purchased the land, they have converted into sites, they are selling it.
ಯಾರಿಗೆ ಸೇಲ್ ಮಾಡ್ಯಾರ?
It is to their
ಅವ್ರಿಗೆ?
members. It is to, my lord, it is to their members, my lord. Your lordship, as per, they are claiming deduction under section 80P, my lord.
ನಮ್ದೊಂದು ಯಾವ್ದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತಲ್ಲ ATP ಅಲ್ಲಿ.
80P, that is whether there is a, it is a cooperative society or not.
Sauharda, whether Sauharda is a cooperative society or not.
No,
That's not the issue
That's
here.
not the issue. No.
They are a cooperative, they are not a cooperative society.
No, my lord. We are a mutuality.
ATP ಯಾಕೆ ಬರ್ತದೆ?
Your lordship, they are claiming under section 80P only, my lord.
I'll
What is-
explain. My lord.
One second, ATP could ಯಾವ್ದದ್ದು judgment?
Your Lordship, that is in the case of Sauharda Credit Cooperative Society. But in that case, whether it is a Sauharda is entitled
Or
for
a
ATP
cooperative
or not.
society.
Yes, Your Lordship held that it is applicable. But the issue is not that in this
No, I
case.
want to know whether ATP extends to
Yes, ma'am.
any society other than a cooperative society.
Yes, ma'am.
Let us see section ATP.
Page
ಅದು
number-
appeal ನಲ್ಲಿ ಏನಾರ appeal ನಲ್ಲಿ ಏನಾಯ್ತು?
No, well, after that, there is an amendment in the State Act itself. Not that we have not gone into SLP. Writ appeal we accepted. Page number 1.696.
Society. ಸೌಹಾರ್ದ ಅಂದ್ರೆ cooperative. I felt that way. ಕೊಡಿ ATP ಓದಿ.
ATP, Milord.
1.696.
1.696, Milord.
1.696.
Deduction in respect of income of cooperative societies. Where
Respect
in
of cooperative society.
Where in
Where
the-
in the case of,
Yes,
where
ma'am.
where is the
This is being-
definition of cooperative society?
219, my lords.
219.
Section 19.
Definition ಅಲ್ಲ?
Yeah, please, my lords.
Section 2.19.
Milord.
2 clause 19.
Clause 19, Milord.
Page ಅಲ್ಲಿ
Page
number
1.14.
1.14. Two point two, clause 19.
Please, my lord.
Cooperative society means a cooperative society registered or in for the time being in force and for the state of. You are not a cooperative society.
My lord, I am a cooperative society.
How?
I'll explain. May I take my lords to page 53 of the petition, my lord? There's a
53.
finding of fact, please. This is the CIT's order. I'll read the second paragraph. Page 53.
Where is your registration certificate? Shows
My lord, page 74, my lords.
74.
Please. Petition after the Vakalatnama. I have this is a certified copy saying that so and so resolution part by cooperative
VML
society.
employees cooperative society.
Please. There's a finding of fact at page 53. I'll just point.
Even certificate is there, na? That you are a cooperative society.
Yes, my lord. Third paragraph, my lord, the CIT notes what my activities are. Page 53.
53.
Second paragraph, my lords.
Ah.
During the appellate proceedings, the appellant contended that the main objects and activities of the society are as follows: providing credit facilities to its members, formation of residential layout and allotment of these sites to its members, dealership of LPG for Bharat Petroleum. All these three are my business activities. What the CIT holds, I'll just take my lords over the page.
But if, therefore I asked you,
Please, my lord.
an association unincorporated is one thing, an association incorporated is another.
I am a registered cooperative.
Please understand.
Please, sorry.
When judge says, he says this after research.
My lord.
Please understand that first.
Please.
Yes. Under section 9 of the Cooperative Societies Act, you are an incorporated entity. So you are a person. You are treated as an assessee.
Yes, my lord.
There is a difference between you and your members, like company shareholders and the company.
Yes, my lord.
Read section 9 of the Cooperative Societies Act.
Yes, my lord. Individual existence.
Individual personality.
Yes, my lord.
It is an individual personality. It has a personality.
Please.
It is not a collective name to the members of the society, which someone discusses under the chapter person. You in a society registered under the Society Registration Act, that is not incorporated. There is no difference between members and the association of members. They are one singularity. This is how Justice C.S. Venkatramaya treated.
Please.
But under the Cooperative Societies Act, Section 9 grants corporate personality once the society is registered. There is difference between society and its members, like the company incorporated and the shareholders. If all the members die in a bombshell explosion, society still continues, exists and continues. With this premise, you have to build up the argument. Your first argument that we are an association, society buys it and gives it to ourselves, means we buying and we are taking it in a species, is no argument.
May I clarify? The members have pooled their funds, bought land, formed a layout.
Correct.
Now what
Members are society.
Members have pooled the funds in the name of the society.
Name of the society agalla.
Yes.
ಅದಕ್ಕೆ ಹೇಳೋದು ಹಂಗಾಗಲ್ಲ. Because if it were to be a society under the Society Registration Act, straight away we'd have allowed your appeal.
My lord, may I be permitted to file the registration certificate, my lord? That I am registered.
It's there, it's a cooperative society.
Yes.
Kindly come to cooperative society ಕೊಡಿ ಅವ್ರಿಗೆ. ಬೇರೆ ಆಕ್ಟ್ ಅನ್ನೆಲ್ಲ ಓದಿರ್ಬೇಕು ಲಾಯರ್ಸ್. ಯಾವುದೋ ಒಂದ್ 2 ಸೆಕ್ಷನ್ ಓದ್ಕೊಂಬಂದ್ರೆ ಆಗಲ್ಲ ಅದು.
Please. Sorry.
ಇಂಟ್ರಾಕ್ಟಿಬಿಲಿಟಿ ಇರ್ತದೆ ಎಲ್ಲ ಬೇರೆ ಲಾ. ರೀಡ್ ಸೆಕ್ಷನ್ 8 ಅಥವಾ 9 ಇದೆ ನೋಡಿ. Society, cooperative society is an entity. It is an illegal entity ಆಗ್ತದೆ. Section 8 9 ಯಾವುದೋ ಒಂದಿದೆ. Please come to that. Section 9. So cooperative societies to be bodies corporate. It is like a company. If all the members of the cooperative society vanish away by committing mass suicide, still the society will exist. Like all the members, shareholders dying in Solomon versus Solomon. Same principle. ಹಂಗಾಗಿ ನಿಮ್ ಫಸ್ಟ್ ಕಂಟೆನ್ಷನ್ ಫ್ಲಾಸಮ್ ಇದೆ. ನೋಡ್ಕೊಂಬನ್ನಿ.
My lords.
ನೋಡ್ಕೊಂಬನ್ನಿ ಒಂದ್ಸಾರಿ ಜಸ್ಟ್ ನೋಡ್ಕೊಂಬನ್ನಿ.
Please.
ಹಿಂಗೆ ಹೇಳ್ತಿದ್ದು ತಪ್ಪು ತಿಳ್ಕೊಬಾರ್ದು.
No problem.
ಏನಾಗ್ತದೆ ದಿವಸ ಬಹಳ ಮ್ಯಾಟ್ರಸ್ ಬಂದಿರ್ತದೆ ಅನ್ನೋದಕ್ಕೆ ನಾನು ನಿಮ್ಗೆ ಹೇಳ್ತಿರ್ತೇವೆ. ನಿಮ್ಮ ಏನೇನೋ ಸ್ಪೆಷಾಲಿಟಿ ಇರ್ತದೆ ಟ್ಯಾಕ್ಸ್ ಆಕ್ಟ್ ನಲ್ಲಿ. ಬಟ್ ಬೇರೆ ಇಂಟರ್ಪ್ಲೇ ಆಫ್ ವೇರಿಯಸ್ ಲೆಜಿಸ್ಲೇಷನ್ಸ್ ಇರ್ತದೆ. juristic person ಆಗ್ತದೆ ಅದು ಬಿಕಾಸ್ ಆಫ್ ಸೆಕ್ಷನ್ 9.
Date may be fixed, my lords.
ಹೇಳಿ ಯಾವ ಡೇಟ್ ಬೇಕು?
Any date after 2 weeks, my lord.
ಒಪ್ಕೊಡ್ರಿ ಒಂದ್ ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಓದ್ಕೊಂಬನ್ನಿ.
Obliged.
2nd of April. Please.
I may be permitted to appear on behalf.
ಹೇಳಿ.
It is arising out of an order
Yes, Mr.
passed by the commission, state commission. Approximately, there was an agreement of joint development agreement between the parties herein and others. And for construction of a residential apartment. Approximately, kindly see page number 28. Construction. Yes. The promoter shall construct the scheduled property multi-story residential apartment building based on the working diagrams and sketches and concurred by the parties hereto with internal external service amenities facilities. There was an agreement. It ought to have been constructed within 33 months, madam. Your lordship may kindly see page number 30. Within 33 months. Delivery.
ನಿಮ್ಮ 30 ನಮ್ 31 ಡೆಲಿವರಿ ಅಂತಿದೆಲ್ಲ ಅದ
ಹೌದು ಸ್ವಾಮಿ ಡೆಲಿವರಿ
ಪ್ಯಾರಾ 6 is at page 31.
ಹೌದು ಅದ್ರಲ್ಲಿ 33 months ಅಲ್ಲಿ ಇದೆ.
promoter shall commence construction immediately and the owner shall hand over the vacant possession of the scheduled property for the purpose of construction immediately.
Yes, ma'am. Since there was no construction activities done, that's why a consumer complaint was filed by one of the party. That was allowed. That was allowed. Your Lordship may kindly see the page number. The final 48, page number 48.
What is the final order?
Your Lordship may kindly see hand over the complaint as per terms. Further directed to hand over all original documents pertaining to the property in total of JDA and to pay sum of rupees 90 lakhs for loss caused to the complainant for non-construction of the apartment building and for delay and to pay for 50,000 towards the litigation. I was asked to pay for 90 lakhs.
Yes.
That was carried in appeal before the Supreme Court. It was dismissed, the National Commission, it was dismissed, upheld by the Supreme
SLP also.
SLP also. Now, after the completion, I have paid the 90 lakhs and 50,000.
When did you pay?
That is not in dispute.
No, we are disputing.
Yes, yes, no.
Writ motive.
Yes, no. 30th of, amount paid is on 30th of September 2024.
30th of September 2024. Ellide?
Document hakila. But an application was filed. Since 90 lakhs was paid and 50,000 was also paid. The entire satisfaction, section 47, to record satisfaction. The court says we can't record satisfaction of the order and you have to pay, execute a special power because I filed this application.
Payment and check ninda madidre yang madi? Check ninda madi.
Check al kotradu.
ಈಗ ಏನಾಗಿದೆ?
ಈಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು not to the standing that you have to give a, because we have applied for a construction license, plan and license before the corporation. Corporation BBMP has rejected this one. I am not able to construct it now. That is why it was impossibility of construction, section 56 of the Contract Act. There is a frustration. That is why an application was filed to record satisfaction. I have paid 90 lakhs. I am not able to construct. I have suffered several.
ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದು ಒಂದು ಸ್ವಲ್ಪ ಏನಾರ ತೋರಿಸ್ರಿ ರಮೇಶ್ ಚಂದ್ರ.
ಅದು ಇಲ್ಲಿ ಹಾಕಿಲ್ಲ.
ಎಲ್ಲಿರ ಹೇಳಿರಾ ಪೇಮೆಂಟ್ ಮಾಡಿವಿ ಅಂತ?
ಹೌದು,
ಸೆಂಟೆನ್ಸ್
ಹೇಳಿದ ಅಪ್ಲಿಕೇಶನ್ ಸಿನಾಪ್ಸಿಸ್ ಇದೆ.
ಹೇಳಿ ತೋರಿಸಿ.
30th, your last page. Third page ಅಲ್ಲಿ. ಆರನೇ ಇದರಲ್ಲಿ third page ಅಲ್ಲಿ. The petitioner filed application under section 47 of the after the payment of last.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ನೋಡಿ. ಅಲ್ಲೇನ್ ಪ್ರೊಸೆಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
Process ಮಾಡ್ತಾರೆ. Interim order.
Emergent notice and interim order as laid for till next date of hearing. First off, this interim protection has been granted on the repeated assertion of counsel appearing for the petitioner that his client has already remitted a sum of rupees 90 lakh in EA 45 of 2021. And that the same has been stated at page 3 of, in page 3 of the synopsis. First off. Yes, sir.
Lordship, he's online, your Lordship.
Yes, sir, Mr. Parthasarathi. Yes, sir.
I pray for a short time, 1 week, your Lordship, because my personal inconvenience, I'm not able to physically present.
Call this matter on next week, date 26. All right.
Much obliged.
Let the request of the learned
Much
senior
obliged,
advocate
sir.
appearing for the assessing. Okay. For further hearing. Finally. Yes.
The 24, that I'm for.
Yes.
Petitioner. Yeah. That I did not complete my sentence because while making submissions, I reached a dead end regarding the corporate guarantee, and I wanted to know whether they are happy with the corporate guarantee and still insist for inclusion.
Yes.
But they reopened everything, including the maintainability, my lord. Therefore, my lord, it's my duty to
Yes.
reply. But I have prepared the
Synopsis.
Buddy. Very brief synopsis. Number one, it captures the legal position hitherto. And second one is my submissions.
Buddy. ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
Yes, yes.
Lord, I'm led by Mr. Raghavan, who's logged in online.
Yes, Raghavan, Mr. Raghavan is here.
Yes, yes.
Yes.
Blood, the group of companies, doctrine, as your lordship, sir, it started in 1982. Kindly see the first page. There were
King and Cox.
no Dow Chemicals, 1982.
That reiterated in a little modification, which except that Justice P. Narasimha's addition.
I'll explain.
Yes.
Explain. Because it little bit history is required.
Yes.
Well, I will not take much time.
No problem.
Kindly see the first page. Now, Dow Chemical Company is the parent company. Now, there are two contracts.
Yes.
First page, madam. First page.
First page of petition.
Notes of the petitioner. And
Notes. These notes.
Yes. Now, Dow Chemical Company, that was the parent company.
Correct.
Now, there were two contracts. Dow Chemical Venezuela is the subsidiary of Dow Chemical Company. It entered into contract with a French company, which later assigned the rights in favor of the respondent, that is aforesaid company, Gobin. That is contract number one. Second one is Dow Chemical Venezuela assigned the contract in favor of Dow Chemical AG. That is the original contractor, that is Dow Chemical, which entered into an agreement with the French company. It assigned the rights in favor of Dow Chemical AG. Now, the second company, that is the French company, it assigned the rights in favor of ISOR. The contract number two. Now, Dow Chemical Europe, like subsidiary of again Dow Chemical AG, it entered into similar contract with three companies, which subsequently assigned the contract in favor of ISOR. Now, kindly similar, Dow Chemical Company was not a party to the proceedings.
Yes.
Now, the both contracted provided, kindly, this is important. Both contracts provided that the deliveries of the products to the distributors will be made by Dow Chemical France
or any
other subsidiary of Dow Chemical Company. Dow Chemical Company is the parent company. Now, several suits.
Dow Chemical Company
is the parent company.
Dow Chemical Company means Dow Chemical AG.
No, that is AG, I think, refers to German companies. German company. I'll come to them. Dow Chemical Company is the parent company. It had basically 3 or 4 subsidiaries. One of the subsidiary, that is Venezuela company, entered into a contract with a French company, and the French company assigned the rights in favor of Saint-Gobain, Saint-Gobain.
Correct.
Second contract, that is, then thereafter, Venezuela itself assigned the rights in favor of Dow Chemical AG. Therefore, there was a fight between Dow Chemical subsidiary company with Saint-Gobain in contract number one. In contract number two, another subsidiary of parent company, Dow Chemical, that is Dow Chemical Europe, that is a subsidiary of Dow Chemical, which itself was a subsidiary of parent company. It entered into similar contract with three companies, which subsequently assigned the contract in favor of ISOR Saint-Gobain. Therefore, it was a direct fight between number one, Dow Chemical Venezuela versus Saint-Gobain. Second one is Dow Chemical Europe versus Saint-Gobain. Now, both contracts provided that the deliveries of the products will be made by Dow Chemical France, which was not a part of the agreement, or any other subsidiary of Dow Chemical Company. Several suits were instituted against Dow Chemical Group companies before the French court. Now, in response, this is important. 4 companies of Dow Chemical Group, the 2 formal parties to the contract, Dow Chemical AG and Dow Chemical Europe, and 2 non-signatories, that is Dow Chemical Company, the parent company, and Dow Chemical France, instituted arbitrary proceedings against ISOR Saint-Gobain before the Paris Arbitrary Tribunal. The primary issue was to determine its own jurisdiction over the non-signatory parties. The tribunal sought to determine whether there existed a common intention of the parties to be bound by the arbitration agreement. The tribunal established the common intention of the parties by analyzing the factual circumstances underpinning the negotiation, performance, and termination of the contract. But I have not read this judgment. But Cox and Kings itself, in sometimes in
Refers to
some
that.
parts uses the word and. Justice Narasimha uses the word and termination. The tribunal held the
ಹೌದಾ?
Dow
ಎಲ್ಲೋ
Chemical.
ಒಂದ್ ಎರಡು ಮೂರು ಕಡೆ
ಹೌದು.
ಬಸವರಾಜ್ ಐ ರೆಡ್
yes.
ನೆಗೋಷಿಯೇಷನ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್
And
ಆರ್ ಟರ್ಮಿನೇಷನ್
and ಅಂತಾನು ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಎರಡು ಇದೆ ಬಟ್ ವಿ ವಿಲ್
ಹಂಗಾಗಿ ಎನಿವೇ ವಿ ಆರ್ ನಾಟ್ ಇಂಟರ್ಪ್ರಿಟಿಂಗ್ ಸ್ಟ್ಯಾಚ್ಯೂಟ್
Yes, sir.
ಜಜ್ಮೆಂಟ್ಸ್ ಅನ್ನ
cannot be read as statute. The tribunal held that the Dow Chemical France, which was a non-signatory, was a party to the two contracts and consequently the arbitration agreements contained in them because it played a predominant role in the negotiation, performance and termination of the contract. As far as Dow Chemical Company, that the parent company, the tribunal held, here Dow Chemical Company is in similar to MDPL before your lordship, held that the holding company had ownership of trademarks under which the products were marketed in France and had absolute control over its subsidiaries who were involved in the negotiation, performance and termination of two contracts. The tribunal also relied on the fact that Saint-Gobain applied for the joint of holding company into court proceedings in France before the Court of Appeal of Paris. Relied on. However, the arbitral tribunal did not base its decision to extend the arbitration agreement to non-signatories solely on the fact that both the signatory and non-signatory parties were members of the same group. It emphasized the importance of determining the true parties to the arbitration agreement on the basis of their participation in the negotiation, performance and termination. Therefore, the concept of group of companies was yet to be evolved at the stage of Dow Chemicals. Then came two judgments of the Supreme Court in Sukanya Holdings and Indo-Wind Energy. They straightaway rejected that a non-signatory can be included in the arbitration proceeding. These two judgments adopted a rigid and restrictive approach by placing strict emphasis on the formal consent.
ಮಸ್ಟ್ ಬಿ ಎ ಸಿಗ್ನೇಟರಿ ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ.
Pardon?
ದೇ ಮಸ್ಟ್ ಬಿ ಎ ಸಿಗ್ನೇಟರಿ.
Yes.
ಓನ್ಲಿ ದೆನ್ ಯು ಕ್ಯಾನ್.
Yes. Three underlying percept. Arbitration could be invoked at the instance of a signatory to the arbitration agreement only in respect of disputes to another signatory party. The court would adopt a strict interpretation of the provisions of the Arbitration Act, particularly the unamended Section 8. Because after chloro control, Section 8 also was amended, similar to Section 45, which only allowed reference of parties to an arbitration agreement. There was an emphasis on formal consent of the parties, thereby excluding any scope of implied consent of the non-signatories to be bound by the. Then comes chloro control. Now, this is the beginning of the
doctrine of
yes, doctrine. But chloro control used the word claiming under. The difference is not that of the lifting the corporate veil or piercing. The chloro control adopted a very rigid methodology, which UK court has adopted. That one must be claiming. I'll come to that. Singapore, they have straight away rejected this doctrine. UK straight away they rejected. US adopts this only on the ground of principles of estoppel, that your conduct is such that you cannot escape from the liability. Only in India and in Europe, that is in France, that this theory, that doctrine has been completely adopted. Singapore straight away rejected, UK rejected, and US, it's only on the ground of principles of estoppel. Now, chloro control, my lord, it has a limited application of the group of companies. Now, these are the principle. My lord, I will skip the facts because dot number 1, 2, 3, 4. 4 may kindly be seen. All the contracting parties were not signatory to all the agreements, including the shareholder agreement. Then last dot, the foreign entities applied for referring the disputes to arbitration, stating that the agreements are binding on the non-signatories because of the composite nature of the transaction. The court held that non-signatory parties are required to claim through or under the signatory. Now, this is overruled in Cox and Kings. The court accepted that the arbitration is possible between the signatory to an arbitration agreement and the third party or non-signatory claiming through a party. There goes Sukanya Holdings. The also held that a non-signatory could be subjected to arbitration without their prior consent in exceptional cases on the basis of 4 determinative factors. The court held that a non-signatory could be subjected to arbitration without their prior consent in exceptional cases on the basis of the 4 determinative factors. Number 1, a direct relationship to the party, which is a signatory to the arbitration agreement, a direct commonality of the subject matter and the agreement between the parties being a composite transaction, the transaction being of a composite nature, where performance of the mother agreement may not be feasible without the aid, execution and performance of supplementary ancillary agreements for achieving a common object and collectively have a bearing on the dispute, a composite reference such parties will serve the ends of justice. But then came the Charan properties. Charan properties, my lord, applied section 35 and said that at the time of execution, even the other non-signatory will be held responsible. That 2018 issues was whether the arbitral award could be enforced under section 35 of the Arbitration Act against a non-signatory was a nominee of one of the signatories to the arbitration agreement and direct beneficiary of the underlying contract between the parties. 35 of the Act postulates that an arbitral award shall be final and binding on the parties and persons claiming under them
respectively.
Yes. The court observed that the expression persons claiming under them refers to every person whose capacity or position is derived from and is the same as a party to the proceeding. It held that non-signatory, being a nominee of one of the signatory parties, was bound by the arbitral award as it was claiming under the signatory. Till now, my lord, we have not reached the group of companies where the scope was expanded. Then 2018, Amit Lalchand, the court was dealing with an arbitral dispute arising out of 4 interconnected agreements executed towards a single commercial project. The issue was whether the 4 agreements were interconnected to refer all the parties to arbitration. In that case, all the parties were not signatory to the main agreement containing the arbitration clause. The court relied on chloro control to hold that a non-signatory, which is a party to an interconnected agreement, would be bound by the arbitration clause in the principal agreement. It observed that in view of the composite nature of the transaction, the disputes between the parties to various agreements could be resolved effectively by referring all of them to arbitration. But all these judgments till now, my lord, they all only dealt on at the time of referring the matter to the arbitration under section 11. Lord Ricket Benkaiser, the court was dealing with an application under 11.6 of the Arbitration Act seeking the appointment of an arbitrator. The issue before the court was whether there was a clear intention of the parties to bind both the signatory and non-signatory parties based on their participation in the negotiation of the underlying contract. The court held that non-signatory party, even though a constituent part of the corporate group, did not have any casual connection with the process of negotiations preceding the agreement or the execution thereof whatsoever. Thus, the participation of the non-signatory party in the negotiation and performance of the underlying contract was held to be the key determinant of the intention of the parties to be bound by an arbitration agreement. Then MTNL. The court emphasized that the group of company doctrine could be invoked on the basis of the principles of single economic unit. The facts may not be relevant. While last paragraph, while dealing with the contours of the group of companies doctrine, the court noted that the doctrine could also be invoked in cases where there is a tight group structure with a strong organization and financial links so as to constitute a single economic unit or a single economic reality. Then, my lord, comes the ONGC, where, my lord, 5 principles were laid down. The facts may not be necessary. After the dotted words, my lord, the court laid down the following test: mutual intent of the parties, relationship of non-signatory to the signatory, commonality of the subject matter, composite nature of the transaction, performance of the contract. The termination was introduced in Cox and Kings. It was only performance of the contract. Now this is a referral judgment, Cox and Kings. The bench of 3 honorable judges of the Supreme Court will consider an application under section 11.6 of the Arbitration Act sought to re-examine the validity of the group of companies doctrine to the Indian context on the ground that it is premised more on economic efficiency rather than law. Chief Justice Ramana criticized the approach of the 3-judge bench in chloro controls of relying upon the phrase claiming through or under in section 45 of the Arbitration Act to adopt the group of companies doctrine. Chief Justice Ramana also observed that economic concepts such as tight group structure and single economic unit alone cannot be utilized to bind a non-signatory to arbitration agreement in the absence of an express consent. Now, these are the questions referred. Whether the phrase claiming through under section 8 and 11 could be, there is a mistake, it appears. Could be, my friend would be able to, it may not be 8, could be interpreted to include group of companies doctrine. Whether group of companies doctrine is expounded in chloro control case and subsequent judgments is valid in law. Whether group of companies doctrine should be construed as a means of interpreting implied consent or intent to arbitrate between the parties. And whether the principles are alter ego and piercing the corporate veil can alone justify the pressing the group of companies doctrine into operation even in the absence of implied complaint. Consent.
Yes.
Judgmentally editor's note is.
Huh?
These are the, these are the actual words from the judgment. Whether the phrase claiming through under section 8 and 11, I saw editor's note in SEC that there is a mistake, and so I wanted to learn from my friend. Editor's note in SEC. But these are the conclusions in the latest judgment, that the definition of parties in 2(1)H, that they trace it to the act itself. Under section 2(1)H and 7, the conduct of non-signatory
Referred to section 7 only.
Therefore, they wanted to make sure that all this
Within the
should not be some utopian ideology which will be overruled subsequently. The definition of parties in 2(1)H read with 7, the Arbitration Act includes both signatory and non-signatory. Conduct of the non-signatory parties could be an indicator of the consent to be bound by the arbitration agreement. The requirement of a
This is more like estoppel of English doctrine.
no, English doctrine straight away reject US doctrine.
No, English people said they adopted estoppel principle.
Yes.
This aspect.
Equity principle.
Equity. All estoppel is always a piece of equity
Yes.
only. It is on this one, but anyway.
Four.
They have also.
Yes, 4.
Next.
Under the Arbitration Act, the concept of party is distinct and different from the concept of persons claiming through or under
a party.
Therefore, chloro control is gone. The underlying basis for application of group of companies doctrine rests on maintaining the corporate separateness of the group of companies while determining the common intention of the parties to bind the non-signatory party to the principle of alter ego piercing the corporate veil cannot be the basis for application of the group of companies doctrine. And
No, principle of alter ego or piercing the wheel ಇವೆಲ್ಲ ಇದೆಯಲ್ಲ ಅದು ಬೇರೆ ಡಾಕ್ಟ್ರಿನ್
individual cases.
ಅಲ್ಲಿ ಇಂಡಿವಿಜುವಾಲಿಟಿ ಇಸ್ ಲಾಸ್ಟ್ piercing the wheel ಆದಾಗ ಪ್ರೊಫೆಸರ್ ಎಂತ ಸಿಂಗ್ ಅವತಾರ್ ಸಿಂಗ್ ಪ್ರೊಫೆಸರ್ ಅವತಾರ್ ಸಿಂಗ್ in his company law writes that piercing the wheel ಆದಾಗ the identity of another entity is lost. ಈ ಬುರ್ಕಾ ತೆಗೆದಂಗೆ we see who is behind. But illi doctrine of group of companies stands on a different footing.
The earliest, I think, in 89, when we came here, Hegde and Gole and all those, Mr. Shekhar Shetty used to argue. In Companies Act, in the winding up proceedings, this concept used to quote that you cannot shield yourself behind the veil and you have to find out the real intention and all that.
That's what.
The group of companies doctrine has an independent existence as a principle, which stems from a harmonious reading of 2(1)H along with 7. This crystallizes. To apply a group of companies doctrine, the courts or tribunals, as the case may be, have to consider all the cumulative factors laid down in discovery. Resultantly, the principle of single economic unit cannot be the sole basis for invoking group of companies doctrine. The persons claiming to or under can only assert such a right in a derivative capacity. The approach of this court in chloro control, this is where chloro control is diluted. To the extent that it retraced the group of companies doctrine to the phrase claiming through or under is erroneous and against the well-established principles of contract law and corporate law. The group of companies doctrine should be retained in the Indian jurisprudence.
This 10 is so simple. It is like a res judicata. Res judicata. Parties to the proceeding or persons claiming under the parties to proceedings. Similarly, if they are claiming under the parties, where is the question of doctrine of group of companies?
I'll simplify before going to the legal. This is claiming through or under them is a vertical analysis.
Correct.
For example, a holding company, subsidiary company, and in the case of Dow Chemicals, there was a subsidiary of a subsidiary. There was a subsidiary of a subsidiary. So vertically, it's like a co-personary system.
This
group
is
of
like
company.
This is horizontal.
Several companies come together and they work together to achieve the ultimate goal. The scope may be limited, but one of the argument I heard the arguments from gavel to gavel. These group of companies argument before the Honorable Supreme Court. One of the fundamental fear expressed by most of the advocates was the assets of the person who is sought to be included will be exposed. Today, kindly similar, the CVPL does not have independent assets. I just subject to independent assets they do not have. Now, the whole idea is to bring MDPL. CVPL assets may be more than 200, 300 crores subject to. MDPL is more than 1,000 crores. Under section 17, Blood property, your lordships are aware, may not be a fundamental right, it's a human right. All the assets of MDPL are exposed. There can be injunction, there can be appointment of a receiver, there can be not to alienate the property and all that. Every one of the orders under section 17 will be invoked against MDPL because MDPL is solid in terms of money. This is the fear exposed before the Honorable Supreme Court that you should be extremely careful when exposing another company which has solid assets to arbitration proceedings, because the assets will be exposed. Kindly the next position, Miller.
But your client is a guarantor.
That is why I said my liability is limited to the extent of about 650 crores, which was obtained from Pyramil. Or if CVPL commits default till today, that is why I said, Miller, it's premature. CVPL has not committed default. Suppose CVPL commit default, then two options. Either they can file the application before the arbitrator. That is also not possible because I'll come to the legal position. If they want to include a third party, they have to come before High Court under section 11. They cannot file the application before the arbitrator. Arbitrator do not have the power to refer the arbitration against a third party. It's only under section 11 before the High Court. Of course, there are two conflicting judgments.
You mean to say,
yes,
doctrine of group of companies is invocable only when you seek reference at
Yes,
the hands
yes,
of the High
yes.
Court.
Supreme Court also says so. Where paragraph 168 says,
not by the arbitrator.
no, they cannot. They do not have the power. It virtually amounts to referring the party MDPL to arbitration. That can be done only under section 11 because.
No, just you show me. We'll revert within a few
yes,
minutes. Please, within a few minutes, we are reverting. Okay.
Court officer, court officer, court officer, court officer, sir,
SCC ನಲ್ಲಿ this is not correct ಅಂತ ಹೇಳಿದ್ದಾರೆ. Section 8. Wait, ಈ judgment ತೆಗೀರಿ ಒಂದು ನಿಮಿಷ. You have this judgment? This is not, note ಇದೆ, ಅದಕ್ಕೆ ನಾನು note from you.
Court officer. Court officer.
Yes, madam.
Madam, when the bench will resume?
5 minutes, madam.
Okay.
Reference to section 11 seems to not it is correct. I think by mistake now both the 8 is wrong. 8 is correct. 11 ಬರು. Okay. 8 ಆದ್ಮೇಲೆ 8 is correct. ಯಾಕಂದ್ರೆ section 8 ಅಲ್ಲಿ amended after chlorocontrol they amended similar to 45. That's 8 is right. 11 ನಲ್ಲಿ the reference to 11 seems to be inadvertent. Claiming to or not found in 11. 11 ಅಲ್ಲಿ ಯಾಕೆ ಬರ್ತದೆ? Okay. What they meant is 8 and 45. 8 is invoked. 45. Refer ಮಾಡಬೇಕಾದ್ರೆ 11 ನಲ್ಲಿ. Are you looking? So rather section 11 it has 45. So that the price is going that is a domestic arbitration. ಇದು ಬಂದಿಲ್ಲ.
Yes, sir.
Yes, ma'am.
Yes.
I was reading
Ah.
referral, the conclusions on Cox. But before that, but there is some doubt was there. We got it clarified. The referral court, my lord, uses the word section 8 and 11, but the marginal note of the editorial says that it is not 11 because in 11 there is no word like claiming through under. It is 45, 8 and 45.
1845.
Right. So 11 has to be read as 45. There is a mistake in the judgment. That's all. Now, in Cox and Kings, my lord, Lord, I must refer to para 12. After reading
At the
para
referral
10,
stage.
that group chloro controls, then group of companies doctrine should be retained. Then 12, at the referral stage. That means if it goes to the referral stage, the referral court should leave it to the for the arbitral tribunal to decide whether the non-signatory is bound by the arbitration agreement. The Bombay High Court, my lord, uses this to say that the arbitrators have the power to implead them at the arbitration stage. But and that is also distinguished by the Delhi High Court, my lord, in Advaya.
Kindly come to.
Yes,
Suraj.
yes.
12 odi one sorry.
12 million. At the referral stage, if the matter goes to section 11, the referral court should leave it for the arbitral tribunal to
panel.
decide.
If that is so, the doctrine cannot be operated by section 11 court at all.
Pardon?
The meaning, this para 12 we have coined based upon the ratio of so many decisions. Kindly see, at the referral stage,
yes,
the referral court should leave it for the arbitral tribunal to decide whether the non-signatory is bound by the arbitration agreement or not. This is on the doctrine of group of companies only. In other words,
certainly, it does refer to group of companies only. There is no.
If that is so,
yes, ma'am.
your contention, submission,
yes, ma'am.
that that there should be reference under 11, even for impleadment.
Yes, ma'am.
That falls to the ground.
I'll read one paragraph from the Cox and Kings Constitution Bench judgment itself, which speaks about the how para 169 minute, para 169
of Cox and Kings.
Cox and Kings. Minute.
What the judgment citations book citation book.
It's in volume 2 of our judgments.
The 2024 4 SEC page 1, page number 90.
901 volume 1 padi.
Page number 90, internal page 90, paragraph 169.
Running page
308, my lords.
308.
In our compilation, running page 308.
You're right.
Lords have para 169, yes.
In case of jointer or non-jointer parties to an arbitration agreement, the following two scenarios will prominently emerge. First, where a signatory party to an arbitration agreement seeks jointer of a non-signatory party to the arbitration agreement. And second, where a non-signatory party itself seeks
invocation
of the arbitration agreement. In both scenarios, the referral court will be required to prima facie rule that the existence of the arbitration agreement and whether the non-signatory is a veritable party to the arbitration. This chance I lost. I could have established before the referral court that there exists no arbitration agreement so far as I am concerned. I'll come to that. I'll come to that. In view of the complexity of such a determination, the referral court should leave it for the arbitral tribunal to no doubt about it. There is no doubt. But I would have had the opportunity before the referral court to say that I need not address all these arguments before the arbitrators or even before this honorable court because the scope is limited. After the judgment of the latest judgment of the Supreme Court, it is a prima facie consideration whether arbitration agreement exists or not and other things. The referral court should have had the opportunity.
No, kindly read
I'll read
further
it.
two
In
sentences.
view of the complexity of such a determination, the referral court should leave it for the arbitral tribunal to decide whether non-signatory party is indeed a party to the arbitration agreement on the basis of factual evidence and application of a legal doctrine. The tribunal can dwell into the factual,
circumstantial, legal aspects of the
legal aspects
matter
of the matter to decide whether its jurisdiction extends
to the non-signatory party.
in the
Tribunal
process, the
itself has
tribunal
to do
should
it.
comply with the requirements of natural justice such as giving opportunity. This interpretation also give effect to the doctrine of competence by leaving the issue of determination to. But the problem is, my lord, the right of the petitioner before the referral court that there exists no arbitration proceeding.
You can take up before the tribunal.
No, that cannot be done. That cannot be done because the ultimate power is to refer a matter to tribunal. Arbitration.
What is meant by this paragraph?
If there is a referral application under section 11, where that is why I said, but all earlier cases, well, this judgment will be a landmark judgment for this reason. In none of the cases, subject to my, in none of the cases, there was an issue at the arbitral level except the Bombay High Court. All the earlier judgments of the Supreme Court, it was either execution stage or referral under section 11. If there is a referral under section 11, the High Court will have to prima facie consider, but it is not that straight away it will be left. Prima facie, the existence of the arbitration agreement can be gone into by the referral court. I can demonstrate that the agreement is vitiated by so many factors, assuming for a moment. Or non-signatory being dragged into arbitration proceedings is prima facie contrary to law. This opportunity I lost because that power is, my lord, authoritatively and audaciously taken over by the arbitrator. This cannot be done. Tomorrow, I'll give an example. Tomorrow, there is a water tanker supplier, which is a company, or electricity supply company, or a furniture. In the large scale, everybody will be dragged into arbitration proceeding by simply filing an application under section 7, read with section 2(1)(h).
No, suit hakid mele impleading application type.
No, that is why, my lord, that
criminal side reference kodaku under section 319 of the CRPC.
I will answer the question. For example, a suit is filed between A and B, which contains arbitration proceedings. Section 8 application is filed to stay the proceedings and refer the matter to arbitration. Now, can we visualize a situation where the civil court will implead all and sundry persons to refer the matter to arbitration? Because the power of the civil court is much, much more when compared to arbitrators under the summary proceedings. If this analogy is accepted, even under section 8, a third party can be added. Because referral under section 8 to the arbitration proceeding, under section 11 also, almost identical. No, if this can be done, section 8 also can be done now. Therefore, my chance of attacking the arbitration agreement, if they file an application under section 11 before this honorable court, is lost.
Lost, and nothing can be done because apex court says like.
No, my submission is this cannot be done before the arbitrator. I will straight away take your lordships to the judgment.
Even Bombay,
which is against
appears to have held against you.
Yes.
Pardon?
Bombay
is straight away against me. That is why, my lord, I will refer to the Delhi High Court, which refers to Bombay High Court. But paragraph 17 of the judgment in Adavia. What happened in Cardinal Anta? But paragraph 17 only, they refer to paragraph 41 of the Supreme Court judgment.
Not to 169?
Cardinal is the judgment of the Bombay High Court. What I have forwarded to your lordship is the Delhi High Court judgment. They refer to Cardinal energy matter at paragraph 17. Cardinal says, yes, arbitrators can be impleaded. This is what Cardinal says. But can I take your lordships to paragraph 17, which refers to 41 of Cardinal? Thus, from the conclusions of the Supreme Court, your lordship got it?
Yes, 41.
It is clear that the Supreme Court has held that where at a referral stage impleadment of non-signatory to the arbitration agreement is raised, The referral court should leave it to for the arbitral tribunal. Thus, it is clear that the arbitral tribunal has the power to decide
I-
whether non-signatory is bound by. I do not find a reading of the Supreme Court judgment that merely there being no prayer to implement of a non-signatory in section 11 application, the applicability of the doctrine of group of companies by the sole arbitrator is excluded. Arbitrator does have the power authority to implead the non-signatory if such non-signatory is otherwise liable to be impleaded on the basis of group of companies doctrine. But this is what the cardinal says. That is the Bombay High Court. The one which I have forwarded is the Delhi High Court. That distinguishes at paragraph 25. I am of the view that after considering Adavia of the Bombay High Court, I am of the view that one section 21 notice dated 11/17 so and so, and thereafter section 11 petition do not raise any disputes against respondent 2 and 3. The petitioner cannot be permitted to raise the dispute subsequently by filing the statement of claim. That is similar to impleading them. Respondent number 2 and 3 had no chance or opportunity to dispute the averments made by the petitioner therein in the notice under section 21 or in the petition seeking reference to arbitration. It cannot be that the respondent 2 and 3 for the first time before the arbitral tribunal will file their statement of defense and would contest the arbitration proceedings. Now, it is a matter of fact that there was no notice, and till today, no allegations are made against MDPL of either the breach or any averments pertaining to their claim. This is what it says. I am of the view that one section 21 notice and thereafter 11 petition do not raise any dispute against respondent 2 and 3. Petitioner cannot be permitted to raise dispute subsequently by filing its statement of claim. Respondents had no opportunity or chance to dispute the averments made in the petitioner either in the notice under section 21 or in the petition seeking reference to arbitration. It cannot be that respondent 2 and 3 for the first time before the arbitral tribunal will file their statement of defense and would contest the arbitration proceedings. Therefore, the moment I filed what happens is the moment I file objections to their application, the arbitrator should have said, go before the referral court under section 11 and come back. This is my argument. This is my argument. Otherwise,
when apex court says, the referral court should not venture all that. And
none
they
of
should
the
leave it to the wisdom of the arbitral
no,
tribunal.
Cox and Kings is fully silent on this. Cox
Silent
and Kings is fully silent. No, it's
para 160.
no, that is if there is a reference. If
No.
there is a reference, if there is a referral petition under section 11,
Court will
what
not
is to be done? What is to be done? It says leave it to the arbitrators.
Means what?
It does not say that the arbitrators have the power to implead or do not have the power to implead.
No, what
There
is
it is
meant-
silent.
Mr. Basuraj.
Yes, Milord.
What is meant by leave that question to be decided by the
Your Lordship,
arbitral
sir,
tribunal?
A judgment cannot be read as a statute.
That's
It cannot be read as a statute. What the
It
Supreme
should be
Court
read
says is we
means-
will analyze 1 to 5 situations.
In other words, I will tell you.
Yes.
How we are going to take out the ratio decidendi of a decision. Reverse the proposition now. See the consequences. There are at least 2 famous tests as to how a judgment should be read. Justice Upendra Bakshi, Professor Upendra Bakshi wrote how not to read a judgment.
A judgment is an authority for what it decides
But
and
in
not what
number one,
logically follows from it.
That
This
is
is the
that is not
this is the
that
law.
simple. It is
I
not
tried to
that
make it
simple, I tell you. Which Rupert Cross in Precedent in English Law, which he discusses. Professor Lakshmikanta, Precedent in Indian Law, he also discusses it. We have 2 very popular tests. One is Professor Wamba's test, where a decision is rendered on one single point. And if you reverse that point, if the decision does not stand, then that point becomes the ratio decidendi. Where a decision is founded on multiple factors, if you reverse one factor, other points will remain, judgment remains. And you reverse next factor, the judgment remains. There, Wamba's test is not applicable.
It should have both. It should be like a sword with double edge. So
Ha.
you have to satisfy both the.
Number one, where a particular proposition is founded on too many points,
Yes, ma'am.
taking away 1 or 2 would not take away the structure at all.
It will not.
It will not.
It will
It
not.
still
should not.
remains. Therefore, Upendra Bakshi suggested his own test of discerning the ratio decidendi. He says, when you are working out ratio decidendi, apply your common sense to what the judge is saying. Then reverse what the judge is saying. See which will address the logic. Judge is saying like this. ಇದರಿಂದ ನಾವು ಡಿಸೈಡ್ ಮಾಡ್ಕೋಬಹುದು ಆಯ್ತಾ now reverse that reasoning. See the consequences. If consequences do not accord with rules of reason and logic, then leave it. The reverse of that would be the ratio decidendi.
I'll come to that. Now, para 12, the Supreme Court was analyzing different situations. One of the situation is what should happen if an application is filed under section 11 before the High Court.
Court should not decide that. Court should leave it to the arbitral
I know,
proceeding.
but I know. The moment section 11 petition is filed, an arbitration clause is shown, will the court automatically, with blindly, it cannot refer?
Cannot.
But that is my, I respectfully.
But once arbitration proceedings are constituted,
By what? But it is not by reference. For example, if there was a reference to arbitration by this court, my lord, I would have understood. It's by mutual consent of two persons, MDPL, sorry, CVPL and Gokul.
it
Now,
did
those
not
two
travel
persons,
to 11 at all.
therefore, there is no adjudication process by this honorable court.
You mean to say, we'll test the reasoning, the jurisprudential value of your submission now. Arbitrator can be appointed by the parties mutually. This is one scenario. Where parties disagree on on such appointment, then you will come to section 11. It is not that every case should start with 11 only.
Not necessarily.
Not necessarily.
Not necessarily.
If your argument is accepted, then it is on the premise that every arbitration proceeding should begin with 11 only.
No. If you are involving a third party to the proceedings, if you are
11
involving
does not give you any right at all. It empowers
no,
the chief
it's the other
justice
way.
to
It is the other way.
nominate.
I have a better right. For example, CVPL can take certain plea and my lord, the Gokul can certain plea. My rights are better than these two persons because I am not a signatory.
In other words, if we accept your contention, even when arbitral proceedings between A and B are going on, if you want to bring in rope in C,
You should come to 11.
You have to apply 11.
Yes. Who is not a party to the arbitration proceedings? This will be in a scenario where he is not a party. Of course, only the arbitration can only be between the signatories with the basic level. Because of Cox and Kings, it is expanded. If you want to apply Cox and Kings to a third party who is not a party to the arbitration proceeding, then 11 is the only remedy. This is my submission for your clerkship.
Because of reasoning of Delhi High Court.
Because the valuable right.
Bombay High Court decided.
Bombay High Court simply says 169, there is, just as we are referring to paragraph 12, it says if there is a reference, if there is a petition under section 11, you leave it to the arbitrators. But that is why at 11 stage, automatically, blindfoldedly, this court will not refer the matter parties to the arbitration tribunal. Even a party, this is most important, even a party to the arbitration proceedings can take certain plea to see that the referral is defeated. Now, I have a better right. I'm a third party who has absolutely nothing to do with this. The referral court would have had the opportunity to prima facie says, yes, you may come within the group of companies, but it requires evidence. But in ONGC case, the matter was remanded back, matter was remanded back because the tribunal did not consider the application for discovery and production of documents. Discovery stage, they rejected without considering the application. Therefore, the tribunal can record the evidence, go through the documents, and the oral and documentary evidence can be perused by the tribunal and it can take a call. But does not mean that my right under section 11 will be completely defeated because I have a better right than the parties to the arbitration proceedings. I have a better right because the moment a notice is issued under section 11, nobody will come and say, okay, refer the matter to arbitration. It is contested. Sometimes it is seriously contested.
May I just make one submission with my?
Yes, certainly, sir.
Just to bring to attention two facts. One is that the Honorable Delhi High Court's judgment by a subsequent judgment of the Honorable Delhi High Court has not been taken. So this is in the judgment.
Reversed.
Yes, they have. So
Basura
not
has not
another,
seen that.
yes, I will just share the citation. Another coordinate bench has in fact held, and I'll just pass on the judgment and reiterate, in fact, what the learned senior Mr. Raghavan presented on the previous date, that even in this exercise, what essentially potentially a section 11 court would-
This we wish diluted.
Yes, my lord. My lords may see the third.
This is of how many? One judge.
One judge, another coordinate bench of the Delhi High Court in a subsequent judgment.
Has he referred to
The
this?
paragraph based on Cox and Kings. I will just show that.
This was, this also refers to Cox and Kings.
My lord, before
Cox
I,
and King is referred by Delhi, the learned single judge also.
and now the judgment that my learned senior pointed to is pending in an SLP.
It is
which
pending in
Yes,
SLP.
which is in 252746 of 24.
There is a judgment of your lordship that unless the presidential value remain till it is reversed. Chamundi mopeds and all.
No, question is not that. Then we go to another dimension now.
My lord, before I just.
Arbitration Act is a central legislation. Yes, ma'am. Once a court interprets a particular provision, earlier it was persuasive. Kusum in what?
I know.
How could the Delhi High Court take so easily a different view from Bombay?
This aspect of section 21 notice was not considered by the Bombay High Court. They simply said you can be a party. The question in other way was whether in Cardinal was whether arbitrators had the power to implead at the stage of arbitration proceedings and maybe under Article Rule 10.2. The Delhi High Court says the section 21 notice, we had no opportunity to oppose. Suppose if there was a notice under section 21, obviously no notice was issued. Or me contesting.
That is the 25.1.
Yes, ma'am.
You are saying 25.
I'm of the view that section 21 notice and thereafter 11 petition do not raise any disputes against 2 and 3. The petitioner cannot be permitted to raise disputes subsequently by filing a statement of claim. I had no chance or opportunity to dispute the averments made by the petitioner either in the notice or in the petition seeking reference.
Now let us go to the facts of Cox and King.
Let us conclude this. My friend
Cox
wanted
and
to
King
show.
facts ಅಲ್ಲೇನಾಗಿತ್ತು ನೋಡ್ಬಿಟ್ರೆ ಆಯ್ತು.
ಎಲ್ಲಿ
Cox and King ನಲ್ಲಿ
Cox and Kings is a reference to because Chief Justice Ramana doubted the correctness of Flora control, whether claiming through or under it, whether it can be restricted to that. The traditional view of UK and Singapore. This court expanded horizontally. As I gave the example of vertical and horizontal. It's a reference. It goes back to the original code.
My lord, can I just interrupt my learned friend, my lord, without with his kind permission?
Yes.
If your lordship will permit me, my lord. Kindly see the judgment of Delhi High Court. What happened in that case, my lord, was that in the claim statement itself, they simply made the other party a party. That is what they said you cannot do. Please look at what happened in that case, my lord. If your lordship will kindly see the judgment, my lord, of Delhi High Court on which reliance is now placed.
Where is the fact matrix?
Yes, my lord. My lord, kindly see para 2, my lord. Learned counsel for the respondents applicants has vehemently argued that not only there are no arbitrable disputes between the parties, it is also manifestly clear that the claimant had not issued any notice under section 21 of the ANC Act 1993 to respondents 2 and 3, and as such invocation of arbitration against them is not sustainable. He also argues that in the petition under section 11 of the ANC Act, respondents 2 and 3 were not made parties even, and as such the disputes, if any, between the claimant and respondents 2 and 3 have not been referred to this tribunal by the High Court of Delhi while passing orders under section so and so. Learned counsel for the applicants relied upon 2 judgments of the High Court of Delhi in so and so. In these 2 judgments, it was clearly held by the High Court of Delhi that in the absence of an agreement to the contrary, a notice under section 21 of the Act by the claimant invoking arbitration and reference of dispute arbitration is mandatory to issue and serve a notice under section 21 of the Act on the opposite party, and the arbitration proceedings without a notice under section 21 are invalid. In the case of so and so, it was held that a notice under section 21 is mandatory, and without fulfilling the prerequisite of the notice under section 21 of the Act, arbitral proceedings shall be unsustainable. Learned counsel for the claimant, however, has relied upon a judgment of Delhi High Court in so and so to contend that knowledge of the proposed proceedings is sufficient compliance of section 21 of the Act. In this judgment, Honorable Court in Para 9 observed, the court in Alupro explained the relevance of Section 21 for filing a petition under Section 11 of the Act by holding that the trigger for the court's jurisdiction under Section 11 of the Act is the failure of the receiver to respond to the sender's communication invoking arbitration. On this basis, it is held that the requirement of notice under Section 21 is mandatory. However, the said judgment is distinguishable of the facts. In the said decision, there was no notice of invoking the arbitration proceedings at all. Whereas in the instant case, the facts demonstrate that the respondent certainly had due notice of the arbitration proceedings. In my view, the above judgment relied upon by learned counsel for the claimant is not applicable to the facts of the present case, as there is nothing on record to show that the respondents number 2 and 3 had due notice of the intention of the claimant to initiate arbitral proceedings against them also, and as it without notice to them under Section 21, the initiation of arbitration proceeding against them was illegal and non-maintainable. Then, my lord, if your lordships will permit me, my lord, I will take your lordship through the 8th line in Para 9. A non-signatory of the arbitral agreement. In Para 9, my lord, if your lordships are kind enough.
Para 9.
Yes, my lord, Para 9.
Of Delhi.
Of Delhi, my lord. Yes, my lord, of
The
Delhi.
parties had agreed to carry.
No, my lord, learned counsel for the claimant has also relied upon various judgments.
9 in the extracted portion, my lord.
That is, Blood, this Delhi High Court judgment refers to cardinal.
Correct.
Cardinal judgment. Blood, I think Blood, Para 13 and 14 is not read by my friend, senior counsel. There was an application.
I will read it, sir. I'll come to it, sir. I'll come to it, sir.
I'm sorry.
If your lordships will, I'm sorry to interrupt my learned friend. Please don't mistake me, sir.
Yes.
My lord, if your lordship will kindly see at the 10th line in that extracted paragraph number 9, a non-signatory of the arbitral agreement can be added in the arbitral proceedings if he has played a positive, direct and substantial role.
Sir, 1 minute.
I'm sorry, my lord.
If I may assist, my lord, it's on internal page number 3 of the judgment. My lord, see the page numbers at the bottom of the page?
Page 3.
Page 3, Para 9 is extracted.
Okay.
About
That other judgment it is.
Yes.
Cardinal.
Out of
Blood,
10
in this
10
case, there was an application for implement. Kindly similar Para 13.
No, I will show, my lord, how Delhi, there was no application for implement. Straight away, they made the non-party, a non-signatory as a party in the claim statement. That is what was found fault with.
Just to save the time, paragraph
I will show
13.
your lordship that one.
Just to save the time, paragraph 13. Blood. Just to save the time. Mr. Brar has drawn my attention to an order dated wherein the application for amendment was filed seeking implement of respondent 2 and 3 as parties. Same was allowed. Thereafter, respondent 2 and 3 appeared and filed application under section 16. Next, the sole arbitrator allowed the application for respondent 2 and 3 and deleted them from the array of the parties. There was an application for implement. It was implemented and thereafter they filed application under 16 questioning the jurisdiction. It was deleted.
Then they sought for deletion after implement.
Yes, there was. And Para 29 of the, kindly from Para 29, my lord, this may answer your lordship's question. Para 29. After referring to cardinal energy, the judgment of Cox and Kings categorically states that it is the referral court which would prima facie be required to rule on the existence of arbitration agreement and whether a non-signatory is a veritable party to the arbitration proceeding. In the present case, 2 and 3 were not made parties before the referral court and petitioner has restricted the claim only against respondent number 1. Petitioner before the arbitrator cannot seek to implead respondent 2 and 3 at the stage of filing statement of claim.
But that's the point, my lord.
At the stage
of filing the statement of claim.
Whatever it may be, you cannot drag me before the arbitrator. Only section 11 is the remedy. The question, we have to see the question of law. Question of law is that you cannot do it. Only the referral court would prima facie be required to rule on the existence of the arbitration agreement and whether a non-signatory is a veritable party to the what stage is totally immaterial. It may be at the end of the proceedings or it may be in the beginning. Doesn't really matter.
Well, on the written submission,
yes, we are preparing.
Nimdu written submission.
But we've already filed it.
Allah, this point
yes,
these are new points
yes,
which he has raised now.
Yes.
In the this is my first argument.
Yes.
Then, my lord, in the notes, my lord, notes of the
your notes.
Paragraph 12. Paragraph 12 gave rise to this discussion, which ultimately Delhi High Court judgment. In that, my lord,
At the referral stage, the referral
Ah,
court
adunna.
should leave
That
it for
is
the
interpret-
arbitral
yes.
tribunal.
That
ಅಂತ ನೀವು-
the Supreme Delhi High Court says it's only the referral court which would prima facie be satisfied and the arbitrators cannot implead. This is the latest judgment. Later,
ಅದನ್ನೆಲ್ಲ ಹೇಳಿರಿ ಇದ್ರಲ್ಲಿ. In your notes.
not in the arguments. This this is only the legal position. This is only legal position. The next matter, the legal position in Switzerland, it's not ours to impleading a non-signatory. England courts have categorically taken a conservative approach to binding non-signatory parties to arbitration proceedings. 82 of the Act says any person claiming under through party to the, this is a chloro control test. English law is
Any
explicitly
person claiming under
rejected.
a party is also a party.
Explicitly rejected.
Rest of the doctrines they reject.
Yes, they rejected it. They have adopted basically chloro control test. Then Singapore court has expressly rejected. United States has often used general principles of contract, as your lordship kindly pointed out, was pleased to point out that incorporation by reference, assumption, agency, veil piercing and alter ego and estoppel for binding non-signatory to the arbitration proceedings. This is extracted in Cox and King. Now, my lord, my submissions are this. Blood submission of the petitioner. Blood, unless, my lord, I hope that they are not very serious about the maintainability of the writ petition.
Of course we are, my lord. My learned friend, of course we are. Of course
Then,
we
my lord,
are.
I will be constrained to.
My first contention is that the writ petition should not be entertained.
Then, my lord, I will be.
Of course, my lord.
But
I am not on maintainability, my lord, I am on entertainability.
Yes. Then, my lord, if it is entertainability, then one has to go to the merits of the order of the arbitrators to establish the perversity and all that.
yes.
Now, kindly see, my lord, the first submission is Section 5 of the Act deals with the extent of jurisdictional intervention and bar jurisdictional intervention except so provided in Part 1.
But you did not answer my question.
Yes, my lord.
After effect of Kusum Ingot,
Yes, my lord.
how could Delhi High Court take a view different from Bombay High Court?
Lord Kusumi Gods, it was a case, my lord, where the provision was struck down and said, I was subject to.
But Kusum Ingot
Suppose a
is
particular.
operated by a coordinate bench of this court headed by Honorable Chief
It is
Justice
not
to
interpreted.
this effect.
If suppose a particular section is struck down,
Yes.
it is struck down all over the country.
Yes.
If it is unconstitutional in Kerala, it's unconstitutional in Jammu and Kashmir also.
If
Subject.
that is so,
Yes, my lord.
if a particular high court, now earlier we used to say other high court judgments are persuasive in that persuasive provided they have interpret not the central law. If they interpret some provincial law, that's all right. If a central law is interpreted by one high court, then readily other high court cannot take a view in variance with the first of the high courts.
The Delhi High Court was not considering the central law. It was interpreting the Cox and King's paragraph 169.
Cox and
That's all.
King referred to the arbitration law only.
There
It
is
did
no
not do
doubt. It
anything else.
refers to
Other, that is the reason why Honorable Justice Narasimha added that paragraph to bring it to 7.
Strictly speaking, the Delhi High Court or the Bombay High Court did not deal with the interpretation of the sections as such. Delhi High Court said, Bombay High Court said, having regard to paragraph 169, arbitrators have the power to implead at the stage of arbitration. The Bombay High Court says, the Delhi High Court says, no, they do not have the power for the simple
11
reason.
is a must, because at 11 also some rights are there, which are otherwise available to an ordinary party. Why it should not be
Yes, certainly, my lord.
parties?
Especially, my lord, especially when my assets are exposed. Section 17, I will come to section 17.
That Bombay, the Delhi High Court subsequent judgment.
Please,
I was waiting for that.
that's the judgment it's in volume 3, Indraprastha Power Generation Company Limited versus Solar Energy Private Limited.
Have you said that in your written submission?
My lord, I'll just hand over the volume and I'll extract this.
That the other judge has not agreed with the single judge.
They have not referred to each others, but they interpret Cox and Kings. My lords may see page number 60.
60.
No, if two judges
Yes.
if being ignorant of it, both they cannot be ignorant because same day it is not decided.
A few months apart, 2 months apart.
So time gap is there.
Yes.
If a subsequent judge does not have idea as to what the other judge has done, what is the Delhi High Court? We have High Court Act, High Court of Karnataka Act now.
Please.
Section 8, 7, 8, 9 ಇವೆಲ್ಲ ಇದಾವೆ. ಅಂಥದ್ದೇ ಅಲ್ಲಿ ಡೆಲ್ಲಿಯಲ್ಲೂ ಇದೆಯಾ?
My lord, in the Delhi High Court, they would have followed the original side rules because both of these were section 37 petitions there. I will only read out with.
ನಮ್ಮಲ್ಲಿ ಇರೋದು ಅಂದ್ರೆ
Para 24.
single judge cannot disagree, but if he disagrees, course is to refer it to the larger bench.
I'm not so, with greatest respect, my lord, I'm not so much on the point that the earlier judgment says, more about how the Delhi High Court has interpreted Cox and Kings. And if I may just read
No,
that.
if two
paragraph.
high courts, two benches of the same high court interpret the decision of the apex court differently, then what is the correct position? Correct position, as I understand, is what the first high court said, unless the second judge refers to this judgment. The second judgment will not have precedential value.
My
appears to be that
yes,
way.
my primary submission before reconciling any difference, if at all, is what the learned senior counsel, Mr. Raghavan, said, which is that even in the earlier judgment that was cited of the Delhi High Court, the issue was, can I directly bring someone in as a claimant without giving them an opportunity to make their case on whether they are a veritable party or not? This case, what has
No,
happened?
there also impleading application was filed.
Yes, yes.
No,
para
no.
13. In this case,
Well,
no.
Brar,
Para 13.
Mr. Brar.
Yes, yes.
Submit.
No, my lord, your lordship may kindly see, my lord. My lord, please be kind enough to see paragraph number 29 of the single judge's judgment. In fact, there is no divergence at all. They're all in the same line of reasoning, my lord. May I read para 28 and 29 and 30, my lord? That will clarify the whole thing. May I place it, my lord?
Sir, I will come to. Kindly clarify this one. Kindly
Yes.
come to paragraph number 13 of the judgment.
My lord, just before that, my lord, para 2, respondent 2 is Vishal Corporate, respondent 1 is Vishal Structures, respondent 3 is Chief Engineer. Then kindly see paragraph 13. 2 and 3 were sought to be impleaded. They were impleaded.
Mr. Raghavan,
I'm sorry.
My lord.
Kindly come to para 13 of Delhi judgment.
1-3.
Yes, my lord.
1-3.
Yes, yes, my lord.
Miss Brar has drawn my attention to an order dated 1/8/2013, wherein an application for amendment was filed seeking impleadment of respondent numbers 2 and 3 as parties. The same was allowed. Thereafter, the respondents appeared and sought for disarraying. Therefore, they were parties at the initial stage itself. May not be correct position.
Then they filed section 16 application and checkmated.
My lord, if your lordship will kindly see, my lord,
Yes.
what the judgment says at paragraph number 28 and 29. In fact, there is no divergence at all between Bombay and Delhi.
We'll relieve all your other colleagues to go for lunch and come back. They will have another 10-15 minutes at least.
Extra. Yes, sir.
Yes, sir.
May I trouble your lordship to kindly see para 28, my lord?
28. In cardinal.
Yes, my lord. Where the learned single judge of the Delhi High Court refers to the Bombay High Court judgment. In Cardinal Energy and Infrastructure Private Limited, the Bombay High Court was of the view that it is for the arbitral tribunal to decide whether the non-signatory is bound by the arbitration agreement, and the court should not decide the issue at the referral stage. In the present case, learned arbitrator, while impugned order dated 15/2/2024, has decided the issue and held that respondents 2 and 3 are not the proper party to the arbitration proceedings. The judgment of Cox and Kings categorically states that it is the referral court which would prima facie be required to rule on the existence of the arbitration agreement and whether non-signatory is a veritable party to the arbitration agreement. My lord, that statement, my lord, is not a complete enunciation of the law.
In the present case,
respondent number 2 and 3 were not made parties before the referral court, and the petitioner had restricted its claim only against respondent numbers 1. Hence, the petitioner before the arbitrator cannot seek to implead respondents 2 and 3 at the stage of filing of the statement of claim.
Correct.
But what they did was they filed a statement of claim impleading respondents 2 and 3. That they cannot do. We didn't do all that shortcut, my lord. We in fact made an application to implead MDPL. And para 169, my lord, categorically states that if there is even when there is a the reference which is required to be made under section 11, the referral court will not go into it. It is left to the arbitral tribunal to go into it. Therefore, go and make an application before the arbitral tribunal for impleading is the law laid down in para 169 of Cox and Kings. My lord, it makes logical sense in my respectful and humble submission. My lord, the arbitral tribunal has more facts before it. The arbitral tribunal will hear all the parties. In fact, in the referral stage, the court is only forming a very, very cursory view as to whether there is an arbitration agreement or not. The court is not going into the merits of the matter to find out as to whether on the basis of the documents on record, there is consent or no consent. These are all matters which require to be examined in detail, and therefore the arbitral tribunal is the best authority having regard to the principle of competence, especially, my lord, where section 16 says existence of an arbitration agreement. My lord, if the argument of my learned friend is accepted, section 16 will be rendered odious. Because section 16 gives a right to the arbitral tribunal to examine the question as to whether there is an arbitration agreement or not. If the submission of my learned friend, my lord, is accepted and that it can be done only under section 11, then I ask myself, then why is section 16 using the word existence? In a situation where, as in the present case, arbitration commences outside of section 11, then the arbitral tribunal, my lord, has all the power as envisaged under section 16. So therefore, my lord, we have to read the whole thing in a appropriate manner, though that no one section of the act becomes odious. That is my respectful submission, my lord. Because to say that is only in a section 11 that you can implead, then I ask myself, what happens to section 16? And very importantly, my lord, section 16 uses the word existence. This is exactly what is being contended by the petitioner before your lordship today, that there is no arbitration agreement in existence between me and respondents 1 to 4. On that, the arbitral tribunal, after examining, takes a view on facts. Remedy is available under section 34. This is the scheme of the act, my lord. Otherwise, if the submission of my learned friend is accepted, the scheme of the act will be put on its head. Arbitral tribunal is the master of the proceedings. The courts are incidental. Incidental. Even under section 34, even after the award is passed, the court interferes in a minimalistic way. In a section 11, before the arbitration, the court comes into the picture only in a very small area. Everything is left to the tribunal. That is why, my lord, 226, the uniform view of even in Cox and Kings is don't interfere. I pointed out to your lordships all those judgments, my lord. We have already put it in our submissions also.
Just idhar mele ondu give us a small write-up on
Yes,
Bombay
we
and
will.
Delhi, both judgments.
I'll only
Yes,
conclude.
we will.
If this is accepted, the list or the objection by a person who is sought to be who is sought to be dragged into the arbitration proceedings, though is an party to the arbitration proceedings, can be examined by the court under section 11, and not in respect of a person who has a better right. That means a person who is not a party to the proceedings, he'll say you go before the arbitrators. That means a person who is a party to the arbitration proceedings can raise objections, and 11 court can consider the objections to a limited extent, existence. Not a person who has a better right, who is not a party to the arbitration proceedings. The referral court will say, go before the arbitrator. Why should I go before the arbitrator? I'm not talking about the cost involved. Why should I go before the arbitral tribunal to establish the existence of the prima facie existence of the arbitration tribunal, the arbitration agreement, the validity of the arbitration agreement, legality of the arbitration agreement, or including the limitation, prima facie? I have a better right to say that I should not be dragged to the arbitration proceedings even at the referral stage. My right is better than the persons who are before the court under section 11. These persons who have a better right, they cannot be relegated to the arbitrators to be decided. At least to a limited extent. My question is, at least to a limited extent, the respondent in a section 11 application has a right to question. If that right is accepted, why not the right of a person who has a better right? That a person who is not a party to the arbitration, as I said, here in this case, it may be a holding company. Assume for a moment that is why, my lord, there is a clause in the JDA which says that the CVPL has a right to outsource the works to several other companies. Ultimately, CVPL is responsible. Now, the outsourcing of an electrical project, outsourcing of a water purifying project are outsourced. That means at the arbitral stage itself, all this person can be dragged into the arbitration proceedings without the examination by a referral court. My submission is, I have a better right when compared to two persons fighting before the referral court. Therefore, my rights cannot be relegated to the arbitration tribunal. Unnecessarily, I should go before the arbitrators, spend money, and only to establish that there could not have been reference under section 11. How can that be? I have to go back and question the order of the referral court, saying that the reference court was wrong in referring the dispute so far as I am concerned. But this is my first submission. But I was coming to maintainability of the petition. Now kindly see section 65 and 16 of the Act. 5, your lordships, is a universal rule that notwithstanding anything contained in any other law for the time being in force. But I am on the second aspect regarding the maintainability. In matters governed by this part, no judicial authority shall
Mr. Raghavan does not dispute maintainability at all. He
No,
disputes
that is
entertainability.
why I wanted to know. At least I can save some breath if they accept the maintain. What happens is this. If it is maintainable, then the next question is entertainability of the writ petition.
Correct.
Should I argue on the maintainability or leave it at that? My friend has to guide me. He's a senior, sir.
No, but you have argued that also.
No, I have not yet argued because the only challenge to the maintainability is 16. What they say is you wait till the award is passed. That section 16 read with 37 has absolutely no application to this case. This situation has not arisen.
ನಿಮ್ಮ submission ದಲ್ಲಿ ತೊಗೊಂಡ್ರೆ ಅದನ್ನ
ಹೌದು. ಇದರಲ್ಲಿ
consider.
kindly say paragraph 2, my lord, of my submission.
The 1637 do not apply to the facts
Do
of
not
this case.
apply
None
to the
of the
facts of the
respondents
case
including
since
petitioners
none of
have
the
questioned
respondents, including
jurisdiction
the
of
petitioners, have
arbitral
yet questioned the jurisdiction of the arbitration.
116.3.
I have, my lord, in the Delhi High Court, my lord, they filed application under 16 and get themselves checkmated. That could be filed under section 16. Therefore, the question of awaiting the final order under section 16(5) or filing under section 67 does not arise. The only remedy available to the petitioner is to question the order of the learned arbitrator in section 227 as indicated in the judgment of the Supreme Court in Deep Industries. I'll read paragraph 1 and 2. This will clear the doubt. I read section 15. Kindly say paragraph 3rd line. Section 16(2) of the Act, page 1, Millard.
Page 1.
Yes, page 1 only, 3rd line. I have summarized this. Section 16(2) of the Act mandate that the plea regarding the jurisdiction of the tribunal shall be raised at the earliest. A plea regarding the scope of the authority, there are two aspects. One is jurisdiction and scope.
Yes.
Can be raised under section 16(3). 16(5) of the Act says that where a tribunal holds that it has jurisdiction, it shall continue with the arbitral proceedings and make an arbitral award. I'll stop here for a moment. I go before the arbitrators and file the application that I need not be included in the party. Please delete me from the records. That is section 16(2) and 3. Or I can question scope of the, when the tribunal rules in favor of its jurisdiction, then I have to await. The only remedy available to the aggrieved person is section 34. That is why I wanted to read section 16 itself. Kindly see, it makes a very interesting
16(2).
reading.
A plea that an arbitral tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. However, a party shall not be precluded from raising such a plea merely because that he has appointed or participated in the appointment of an arbitral. A plea, the arbitral tribunal may sign. A party aggrieved by such an arbitral award is not passed on the name contention.
No. 2 and 3, both section 2 and 3 do not apply. 2 arises, I'll read section 2.
2 arises.
A plea that arbitral tribunal does not have jurisdiction shall be raised not. I have to raise the plea before the tribunal.
Correct.
I have not raised that plea before the tribunal.
Correct.
For example, the parties are bound by the arbitration agreement. One of the parties to the arbitration agreement files an application under section 16(2) or many reasons. For example, jurisdiction shall now, however, a party shall not be precluded from raising such a plea merely because that I have not raised this issue before the arbitral tribunal yet. Then 3, a plea that the arbitral tribunal is exceeding the scope of its authority shall be raised as soon as may be. 2, I'll read 2, my lord. A plea that the arbitral tribunal does not have jurisdiction My lord, it may be
Shall be
many
raised.
reasons. It may be many reasons.
Yes.
Shall not be raised later than the submission of the statement of defense. However, a party shall not be precluded from raising such a plea merely because that the
Appointed or participated.
he appointed or participated. There is no estoppel
Correct.
or participated in the appointment of arbitrator.
Correct.
This will not apply to me. A plea that arbitral tribunal is exceeding the scope of its authority, I may raise the issue now if I go back. Shall be raised as soon as the matter alleged to go beyond the scope of its authority is raised during the arbitral proceedings. Then, my lord, section 3, if it delay can be condoned, shall decide on the plea referred to in subsection 2 and 3, and where the arbitral tribunal takes a decision rejecting the plea. Suppose if the arbitration tribunal accept the jurisdiction and closes, says that I do not have the jurisdiction. Therefore, it comes to an end.
Continue with the arbitral proceeding
And
make an
then if the arbitration proceedings are closed, accepting my plea, then, my lord, it continues with the arbitration. Then section 37 comes. I'll come to section 37. If the arbitral tribunal accepts my plea and closes the arbitration proceeding, then section 37 comes. Then kindly the last part. A party agreed by such an arbitral award may make an application for setting
aside such an arbitral.
That means
Section 34.
this is not a situation where section 16.
Of course, this that will not arise.
It will not arise at all. Therefore, section 37, kindly similar, my senior counsel refers to section 37.
Appealable orders.
Yes, appealable order, otherly first and second, subsection 1 does not apply. An appeal shall also lie to a court from an order of arbitral tribunal accepting the plea under section 2 or 3. That means if the
Of
proceedings
section
are gone,
16.
or granting or refusing to grant interim measure. That's different. No second appeal lies. So 2 and 3, if the plea is accepted by the arbitral tribunal, the arbitration proceedings will come to an end.
Yes.
Nothing. If it is rejected, then the arbitration proceedings will continue. 2 and 3 have not even gone there. 2 and 3 does not arise. Therefore, 34, section 16(5), which says that I have to avoid till the arbitration tribunal is award is passed.
That
is why this is a sui generis case where your lordship will have to decide whether section 16 applies in a matter like this. Section 16 has absolutely no application. Therefore, section 37 does not apply. This is an entirely different scenario where arbitrators have implicated me in the proceedings. Therefore, I suppose if this honorable court upholds the order of the tribunal, for example, I can make an application under section 16(3), challenging the scope. Then, Lord, if it is rejected, then appeal lies. If my plea is rejected, I have to await the award and
Passing of the award.
If they accept and they keep me out of the arbitration proceeding, section 37 comes.
It's the end of the matter.
Yes. Now I am neither these 16 or 37 has no application. Therefore, now the question is maintainability of the writ petition cannot be considered in the light of section 16 or 37. This is very clear. Then, my lord, if it is maintainable, then I have to attack the order on merits. That how perverse it is, whether the arbitrators had the power to implead at all without reference to section 11. And then your lordship will have the power to interpret, interfere with the order of the arbitral tribunal.
Him writing written submissions kodi.
Yes, ma'am.
Reserve ಮಾಡ್ತೀವಿ. ಅದನ್ನ ಓದ್ಕೊಂಡು ಆರ್ಡರ್ ಮಾಡಿ.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಎರಡು ಇದೆ. Notice under section 2, the paragraph 3 ಬೇಗ ಓದ್ಬಿಡ್ತೀನಿ ನಾನು. I will not take much time. Paragraph 3, notice under 21 is silent. Then without invoking section 11, they cannot do it. I had no opportunity to reply under section 21. Paragraph 3, 4, 5, one line ಅಷ್ಟೇ ಹೇಳ್ಬಿಡ್ತೀನಿ. 3 ನಲ್ಲಿ 21 does not make any claim against me. Then 4 ಅಲ್ಲಿ without invoking section 11, hitherto I argued. Then 5, I had no opportunity to. Then, my lord, this is most important. Paragraph 7. Once the arbitration proceedings are initiated, so far as I am concerned, my right to approach the civil court is gone. Kindly similar paragraph 7, my lord. Para 7. Yes, my lord.
Your
Lord, this is each one of these submissions, my lord, according to me, are fundamental. Para 6 may kindly be seen for a moment. My assets are sought to be exposed under section 17. They have the power to appoint a receiver. They have the power to attach the property. They have the power to restrain me from dealing with the property. My assets for the first time are exposed before the arbitration. This is exactly what, my lord, the learned members of the bar were addressing before the Supreme Court, that you cannot expose the property of a third party because of the group of companies doctrine. Because right to property is a human right as on today. Then paragraph 7, my lord, my right to approach the civil court cannot be taken away the moment the arbitration proceedings are hoisted against me. My lord, there is a judgment of the Honorable Supreme Court, that is South Delhi Municipal Corporation, have extracted that there is an inherent right to approach the civil court. Now, this right cannot be taken away. My lord, I understand by a statute, your lordships are aware that the power of the civil court can be taken away. Now, because of the two persons whom I have no connection, my right to approach the
No,
civil
you
court is
can't
gone.
say no connection. Because you are the guarantor.
No, that is because of Cox and Kings. Otherwise, if we apply chloro control, I will not be there. Then group of companies doctrine, Millard, I have extracted how the Cox and Kings, some of the paragraphs say since the company is in a group company, separate legal entity, then Millard, such incidental involvement in the contractual performance is insufficient. This is what the Cox and Kings says in paragraph 131. Imposition of liability on a non-signatory company within the group of the companies merely on the basis of the fact that they belong to single economic entity will ride roughshod over the principles of regarding the corporate guarantee. Blood, corporate guarantee is concerned, my lord, there are two things. There are two things. There is a clause in the agreement which say that it is only for the purpose of pyramid finance loan. Number one. Second one is there is a clear understanding that if there is an award against CVPL, it will be bound by that. Third, most important is to invoke this guarantee, there should be
Defaults by CVPL.
Yes, it's a premature. They cannot drag me now because not a single allegation is made against CVPL that it has committed the default or I have committed default. If then last one, my lord, it's a premature this one, therefore it cannot be. And this clause, this guarantee 39/2020 itself has an arbitration agreement that they have not invoked. This 39/2020 on which they are harping itself has an arbitration agreement. They have not invoked. Section 21 notice they have not issued. There is no default by CVPL to invoke the corporate guarantee as on today. Therefore, to drag me to the arbitration proceeding based on the corporate guarantee, they should have issued notice under section 21.
That you have said, yes, because that you said because of Delhi judgment, para 25.1. That reasoning we have understood. Now, only one thing you have to clarify is if there is arbitration clause in your agreement, whether that excludes invocation of doctrine of group of companies.
No, it will not.
It will not.
It will not, certainly not. It will not. What I am saying is, this is to my argument that the implement is premature. They have to establish the breach committed by CVPL or MDPL. As on today is premature. They can impede me if cause of action arises.
Have you referred to Delhi judgment?
Yes, but I have referred to Delhi judgment.
Which paragraph it is?
That in paragraph 4, I referred to both Cardinal and
Bombay and
yes.
Delhi both?
Yes.
No, the
Paragraph
one
4.
which you have mentioned.
Yes, that is not here, my lord. I will place it in a written submission.
Not Indraprastha.
Indraprastha.
I have a submission to make. Paragraph 24, as your lordship pointed out, two judges of the same court taking such a plea. That's paragraph 24. I think my friend is referring to paragraph 24 in Indraprastha. Straight away, contrary to what the earlier judge said. In all probability, my lord, I will not say more than this. They should have been referred to a larger bench.
Small paper padi.
Yes, we will.
Yes. Okay. Thank you.
Mr. Raghavan.
Can I just take 1 minute, my lord?
Yes, sir. Yes, sir.
My lord, all that I want to point out, your lordship, is the core of the controversy in this case is as to whether there is a arbitration agreement between the proposed party and the claimants. That is exactly, my lord, what section 16 contemplates an arbitral tribunal can decide. If that is so, my lord, then under the scheme of section 16, they have the right to challenge the award if at all it is passed against them, taking this as one of the grounds, saying, I should not have been made a party because there is no arbitration agreement in existence. This is the scheme, my lord, of the Act. That is one submission, my lord. And in so far as, my lord, the Delhi High Court judgment is concerned, the entire case, my lord, in Delhi High Court was because of a reference under section 11. Not in our case. In our case, section 11 was not attracted at all. Therefore, the question of anybody losing any right doesn't arise. And then, my lord, kindly see another issue, my lord. Insofar as Delhi High Court is concerned, another bench has taken a different view. A division bench has taken a different view, maybe, my lord, not referring to it. But the fact remains that every judgment of every other High Court is only persuasive so far your lordships are concerned, excepting in a situation where it is struck down. If it is a question of interpretation, my lord, it is always persuasive. So ultimately, my lord, if there is a judgment of the single judge, there's a division bench judgment which takes a different view. Both of them are persuasive so far your lordships are concerned, it is not binding. They don't involve, my lord, the striking down of any central enactment or any rule. Therefore, my lord, ultimately, your lordships, it is my respectful submission, decide this case on the basis of what Cox and King's Supreme Court has said, independent of whatever any other High Court might have said, whether it is Bombay High Court or Delhi High Court, one judge or another judge. This is my respectful submission, my lord. We will place a written submissions on the judgment of Delhi High Court separately, my lord. I am grateful. I am grateful.
Assume the case of a collusion. Two persons go to the arbitration referral under section 11. Both of them agree. Then come back to the arbitrators and impeach somebody who has thousands of crores of assets. Now, this collusion between two persons at the arbitral referral level. Now, I will be bound because I cannot go before the arbitrator. I did not have the opportunity before the tribunal. Even if it is a collusive contract, where the referral, both the parties agree to refer the matter to arbitration. Subsequently, they can come and drag anybody else.
There is a enormous risk anta ನೀವು ಹೇಳೋದು.
How? Suppose if there is a total collusion between two persons to bring third party into the arbitration proceeding, who has thousands of assets. Because
You can point out to the court,
which court?
tribunal.
That is the question. According to me, 11.
Let us see.
Okay.
Very
Would
interesting.
my lords only consider stating in the order that we may be permitted to file written sub so that we can file it in the counter then? Otherwise, they'll request us to mention it again.
ಇಲ್ಲಿ ಕೊಡಿ ನಮಗೆ. ಕೊಟ್ಟಾರ್ಸರಿ ಕೊಡಿ.
Okay.
ಅವ್ರು ಕೊಟ್ಬಿಡಿ.
And one other submission, my lord. My learned friend agreed last time that the award would be binding against his client.
His submission.
Normally, it is recorded by your lordship.
That's what.
With leave of this court, my
Your
lord,
lordship,
my lord, serial
small
number
Bhagwan
37, my lords.
Bhagwan is waiting since morning.
We are so deeply obliged.
Your
lords.
lordship, one mentioning
Serial number 37, my lords.
Bhagwan, Mr.
May I
Bhagwan.
request? 37, my lords.
Please wait. They are here.
I
He is
apologize.
a
ma'am.
very
Apologize.
elderly person is here. And all young people are outside. Yes. And young people do not have patience. Yes.
By 2 weeks.
2 weeks. Got it. Call after 2 weeks at the request of. Entry order will continue. Any entry order was there?
No.
No. Okay. Very well. Okay. Yes, madam.
My lords, serial number 37, day after tomorrow, my lords. Today, I am in the Kalburgi High Court, my lords.
37. We'll call it
37, my lords. My
Next
lords,
week we'll call this.
there
Next
is
week we'll call
urgency in that, my lords.
Therefore, we'll have
Service matter is on Thursday,
Next.
my lords. It may be listed on.
next.
May
your
I-
lordship, serial number 27, your lordship.
27.
Yes, your lordship, 15 days time can be granted, your lordship.
Well, 21 matter.
Yes, your lordship. Actually, prosecution is pending in this matter, your lordship.
All right. Kindly fix a date.
Okay, your lordship. no
Yeah,
issue.
tell one date of your choice.
After 15 days, your lordship, second week of April will be.
9th of April, finally. This date is fixed as chosen by learned counsel appearing for the assessee.
My lords,
Okay.
20th.
No, your lordship. SSC. Yes. Much obliged, your lordship.
Lordship, serial number 25. Lordship, serial number 25.
Court officer, sir. Court officer, sir. Court officer. Sir, next week date ಯಾವ್ದು ಕೊಟ್ರಾಗ sir? Court officer. Court officer. Court officer. Serial number 37 ಗೆ ಡೇಟ್ ಏನಾದ್ರು ಕೊಟ್ರಾ?
With my lordship's permission, my lord, serial number 27, my lord. It has got adjourned to 9th, my lord. Some difficulty on that date, my lord. Any other date? Any
Time ಕೊಡ್ತೀವಿ ಇನ್ನೊಂದ್ಸರಿ ಟರ್ಮ್ ಮೆನ್ಷನ್ ಮಾಡಿ. That's a serious matter, na?
Oh, the serial, because it has to be argued separately, my lord. It'll take some time.
All right.
My lord, I seek leave of the court to move a memo. Is there a DRHT matter, my lord, that we have imposed the condition of depositing 4 crore. I'm ready with 1 crore, which has been rejected to extend the time, my lord. I'm doing a memo. It is the education institution. About 1,200 children are studying, my lord. And they have, even the magistrate court has issued a warrant.
Day after thought.
Tomorrow, my lord, if it is correct.
Tomorrow. ನಾಳೆ ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟರ್. ಟ್ಯಾಕ್ಸ್ ಇದೆ ಅಲ್ಲ? Thursday.
Much.
Okay.
Lord, serial number 26, my lord, I'm told it's covered.
26. Mr. Chaitanya. Covered. Covered in favor of the assessee or against assessee? Good. Good.
The question is in page number 29.
Allah, do you dispute that it is covered?
Because what has happened, my lord, the order of assessment is barred by limitation. My lord, the assessing authority should have passed, my lord, within 1 month of the end of the day, my lord, on which he has received the order of the dispute resolution panel. Obviously, it has not been done.
ಯಾವುದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಆ ರೀತಿ ನಾವೊಂದು ಬರೆದಿದ್ದೆ ಯಾವುದೋ ಒಂದು. Do you remember who argued that matter?
Recent past gave a decision on Srimati Preeti V. Limitation. And also one Umesh Shetty, my lord. 2 decisions with my lord render where limitation is sacrosanct. There is no discounting of time in limitation. It runs.
Once it starts, it runs. And it cannot be halted by subsequent this one.
Here on
Appears to be covered by the judgment.
and various
My lord, reasoning given by the tribunal is, my lord, the AO did not have any, my lord, once the AO assessing officer gets the direction of the dispute resolution panel, he has to simply, my lord, pass an order. So even if it is beyond time, my lord, it would not have
Premise ಮೇಲೆ
cost.
proceed.
That reasoning is, my lord, page number 35. One sentence I'll read, my lord.
Can I have this matter,
It-
or shall I say both the sides agree?
About this.
Okay. We'll call this matter next week ಹಾಕೋಣಂತೆ.
tomorrow.
Tomorrow we have difficulty. Next call next week. We just look it. If you agree, we'll pass that order. If you do not agree, because the department may not be happy. If you agree, that's it. Okay.
My lord, serial number 25, I'm appearing.
25. Next week? Next week. Yes.
My lord, it's a short issue, very
And
old.
other matters, so please wait. We have other. 13 and 21. Yes.
It's a gold matter actually. That's a mistake.
Set-up box matter. Sorry.
Previous year, the same.
On ಮಾಡ್ಕೊಳ್ಳಿ mic ಅನ್ನ.
Yeah, in the previous year, 12-13, I was dealing with only STBs. In the year 13-14, I was dealing with modems and routers, which are given for Wi-Fi connection. It's the same issue only.
Otherwise also covered by the judge.
And otherwise also covered by, it's in favor of revenue only, my argument.
Amount of these movable goods is exactly the same. And again, activation charges I have calculated as the exigible amount.
I want only that to be appeared in the judgment. Even those.
ಯಾವ್ದು ವಿಲ್ ಸೇ ದಟ್ ಕವರ್ಡ್ ಬಿ ದಿ ಜಜ್ಮೆಂಟ್ ಅಂತ ಎಲ್ಲ ಬಂದು ಹೋಯ್ತು ಅದೇ ಬರುತ್ತೆ ಇದು ಬರಲ್ವಾ ಬರ್ಕಡೆ ದಿಸ್ ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್
13
and 21. STRP 24 of 25.
Serial number. 24.
13 and 21. These two petitions lay a challenge to the order dated so and so made by the state appellate tribunal, another
Yes, my lord.
state appellate tribunal. First up. Next paragraph. Learned counsel AGA on request appearing for the respondent revenue points out that the subject matter of this petition is substantially similar to the one in so and so. Judgment kodi. So and so, wherein this court has the coordinate bench of this court has upheld the order of the tribunal. First up, he further submits that in view of the said judgment, law having been clarified, no relief can be granted to the petitioner. First, we agree with this. Next part, in view of that, the petition being devoid of merits is liable to be and accordingly rejected. Courts having been made easy. Same order. Yes. Court next. Please pause. Yes. Yes, sir. Which section authorizes the government?
Please, Manoj.
To issue these norms, binding norms?
That's 22A.
22A. Padi. Stamp Act.
No, Registration Act.
Karnataka Registration Act.
Please, Manoj. Registration Act, Manoj.
Indian Registration Act.
Indian, but Karnataka rules are also there.
Karnataka Registration Act ಇದೆ no?
ಇಲ್ಲ ಬರೇ rules.
Rules ಅಷ್ಟೇ.
Rules ಅಷ್ಟೇ. Lords, may I just clarify this? Under the provisions of the Registration Act or the registration rules, it does not specifically say that these are the documents that have to be produced at the time of registration, failing which the registration will be refused. That is a settled position, my lords. I have checked up the law and even I have spoken to the department. There is no specific provision. One provision, my lords, in the Registration Act, my lords, is section 21, where the description of the property has to be provided for in such a manner, my lords, where you show the
identity should be established.
Identity should be established, including boundaries and a number. Thereafter, my lords, 22A says, documents, the state government may by notification in the official gazette declare that the registration of any document or class of documents is opposed to public policy. Notwithstanding anything contained in this act, the registering officer shall refuse to register any document to which a notification is issued under subsection 1 is applicable. Therefore, my lords, exercising powers under 22A.
Where is the notification?
We issued a circular.
Circular is not notification.
Lords, that is struck down. Lords, that has
Section
been...
itself is.
No, section was struck down, rule was, the circular was struck down. Supreme Court has stayed the judgment of the division bench and therefore, my lords, circular is in operation. Now, my lords, circular continues to be in operation.
No.
22A striking down is not stayed.
No.
It is only circular.
The circular that I had issued in pursuance of 22A, my lords, was struck down by a division bench of this honorable court. In the Supreme Court, my lords, Supreme Court has stayed the order of the division bench and the circular, my lords, continue to be enforced, my lords, it is being operated.
Where is the question of circular? It should be by notification.
No, my lord, circular notified in the official gazette. This circular was notified in the official gazette. I'll just pass on. Lords, this circular
Let us read section 22 rule.
Lords, section. Lords, I'll read 21 for a moment, my lords.
21. Description,
Rule 21,
no, illa section. Registration Act,
21 of Registration Act.
please, my lords.
Registration Act. Registering a document,
Please, my lords.
is it a administrative, ministerial administrative act as distinguished from quasi-judicial, or is it a quasi-judicial act?
My lords,
How courts have viewed what Sanjeev Rao says in his commentary on the Registration Act?
please,
If it is administrative act,
please, my lords.
there is some scope for argument that the officers are bound by the government's instructions.
Please, my lords.
If it is a quasi-judicial,
Please, my lords.
then no interference. Only the designator will decide the issue. This is how Apex Court said in Sri Krishna Cinema versus so and so.
Lords,
Therefore,
there
how
are-
courts have viewed
my lords, there
the
are,
registering.
please, my lords. There is two aspects to that. One, a document is presented for registration. He registers the document. So when he registers the document, then, my lords, in my respectful submission, my lords, it partakes the nature of an administrative act. Suppose he refuses to register, there is a separate provision under the act where he has to refuse to register under particular circumstances. There, my lords, certain, it could partake
How
in the
courts
nature of
have viewed this point?
on judicial, quasi-judicial, my
Ah.
lords, and administrative.
ಇದು ನಿಮ್ದು argument ಆಯ್ತು. Registration Act is there since 1908.
Please, my lords.
How courts have viewed this?
I'll just,
Act of registering a document.
please.
How courts have viewed it? Is it a quasi-judicial act or it is simply an administrative act? Even that difference has disappeared. Is what Mr. Jaikumar Patil said last year in one matter, AK Kripak versus Union of India. Even difference between Justice K.S. Hegede's judgment, perhaps. Difference between quasi-judicial and administrative orders has also withered away. There even principles of nature, many other things will follow. That's another thing. You are reading section 21 now.
21, my lords.
Read.
Description of property and maps or plans. No non-testamentary document relating to immovable property shall be accepted for registration unless it contains a description of such property sufficient
Sufficient to
identify the same. 2. Houses in towns shall be described as situated on the north or on the other side of the
So
street.
modalities are these.
Allala, to which they and by their existing and former occupancies and by their numbers. Kindly note this, my lords.
Yes.
And by their numbers, if the house in such a street are numbered. Then 3 shall be described by their name, my lords. Other houses shall be described by their name, if any, as being in the territorial division in which they are situated, and by their superficial contents and the roads and other properties on which they abut, and their existing occupancies, and also whenever it is practicable by reference to a government map or survey. No non-testamentary, this might not be relevant, my lords. 4, no non-testamentary document
Map
containing
under the things that will not
Now,
apply.
my lords, kindly see 22A. Lords,
This
I
is a, one second.
Please.
Section 21 addresses whom?
Addresses, my lords,
Where is the person who receives the document for when it is presented for registration?
presented for
So
registration
sub-registrar.
for sub-registrar.
Let us,
Please,
this
please.
does not say anything.
And it refers to, I'll also put it out here, my lords, because I made a submission that neither the Registration Act nor the registration rules specify that these are the documents at the time of registering an instrument. When you present it, you have to produce the XYZ document along with that for a particular purpose. So 21 actually refers to the description of the property in the instrument itself.
What is required is
Please.
identity.
Identity.
Of the
Aste.
property.
Aste.
That's all.
Astes.
Beyond that, section
Beyond that.
21 has no.
Please,
options. Yes,
22 excising powers under 22A. I've issued a circular.
22A.
Please, my lords. Capital M, lords.
ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ.
It's a Karnataka amendment, my lords. May I just pass on?
ಓದಿ.
Documents registration of which is opposed to public policy. The state government may, by notification in the official gazette, declare that the registration of any document or class of documents is opposed to public policy. Notwithstanding anything contained in this act, the registering officer shall refuse to register any document to which a notification issued under subsection 1 is applicable. So
Read again.
the state government may, by notification in the official gazette, declare that the registration of any document or class of documents is opposed to public policy.
So accomplished registration of a document. If government can say this registration is opposed to policy.
Illa. What is being presented?
What
Not
is being- Not accomplished transaction.
not
Executory, executory act.
Declare that the registration of any document or class of documents is opposed. For example, I say a particular document, nature of a
In
document
other words, it prohibits from registration.
prohibits from registration. Now, my lords, what we have said, exercising powers under 22A. Now, 22A, my lords, with all due respect, the circular that I have issued was struck down by this honorable court, a division bench of this honorable court in a public interest litigation.
Correction.
Matter is
One correction, in Ramachar's case, blood circular came to be struck down, matter is pending before Supreme Court, it is stayed. But this 22A itself is struck down by the Supreme Court in another Basant Mehta's case.
22A.
Why is
my
they
lords,
referring
this
to
is a-
Basant Mehta's case? Is referred to in Ramachar's case also.
Lords,
22A itself is struck down.
22A.
Which is that striking down judgment.
Yeah.
versus state of Rajasthan, my lord.
Put it.
22A itself is, my lord, struck down as unconstitutional.
Like 20
If, my lord, government says that invoking section 22A, my lord, this circular is issued, we are in a better footing than, my lord.
Allala, put here, judgment put here. Which, my lord,
Ramachar
See
case
that.
ಇದೆಯಾ?
no, no,
Cases refer ಆಗಿದೆ.
Let us, let us.
ನೀವು ಕೊಟ್ರಲ್ಲ ಸಾಹೇಬ್ರು ಕೊಟ್ಟಿದ್ದ judgment.
No,
ಅವ್ರಿಗೊಂದು ಕೊಡಪ್ಪ.
Copy
see
ಕೊಡಿ.
that. Where is, hold on,
Para
copy. put.
22, my lord, in Ramachar's case, para 22 refers that, my lord, section 22A itself is struck down as unconstitutional by the Supreme Court in, my lord, the state of Rajasthan versus Basant Mehta.
ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ ಅಂತ.
ಆ judgment
Because, Lord,
2005.
22A is a Karnataka, it has been inserted by Karnataka Act 55 of 1976 insofar as Karnataka is concerned.
Identical to this.
Identical provision if it's, but Supreme Court has stayed this judgment.
Circular.
This whatever they have, this entire judgment is.
The Punish versus state law, the very provision is examined, struck down. It is reported judgment. The Punish versus state of Karnataka, 2006 flood, ILR.
But that is before the apex court.
No, no.
It is not.
This is before the apex court.
It has attained minority.
This judgment is before the apex court.
That is Ramachar's case.
This
not
circular.
the Punish case.
No, ಡಿಪೌನೇಶ್ ಮ್ಯಾಟರ್ ನೋಡಿರಾ ಕೊಡಿ ಅವ್ರಿಗೊಂದು ಕಾಪಿ.
ನಿಮ್ ಕಾಪಿ ಕೊಡ ನನ್ನ ಹತ್ರ ಇರೋದು.
Sorry, sir.
ಕೊಡಿ. If that has attained finality.
In the operative portion, two circulars, two notifications have been passed.
Impute notification is struck down ಅಂತ. In the result, foundationally.
Yes, ma'am.
The
Tara.
impute notification at Annexure A dated 23/4/2005.
Page 874. In that para 4 there.
Referring, my lord, the Basant
State of
Mehta.
Mehta AR 2005-3401, that is referred to, then it is quoted in para 7.
ನಮ್ಮ ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್ ಅವ್ರಂಗೆ
ಅದೇ
ಇಲ್ಲ ಇದರಲ್ಲಿ ಇದೆ. Para 12 onwards, it is identical, similar provision.
that makes no sense. That makes, apex court said that makes no sense.
ಅಲ್ಲಿ page 885. This entire thing is extracted. It is squarely covered by the aforesaid decision of the apex court. The entire Basant Mehta's case is referred to, and the court holds it is covered. Any consequential act is also struck down.
No, sir.
ಅಲ್ಲ Karnataka Act ಅಲ್ಲಿ they say that reasoning applies to Karnataka also, and then holds that the circular is bad because it is already struck down.
Circular is struck down.
No, ಅದರಲ್ಲಿ page 885 note.
What was challenged in that act?
The circular was challenged.
Circular was challenged.
The court holds the circular is bad because an identical provision 22A is struck down. That is the reasoning.
No, a pari materia provision is struck down is a reasoning for the striking down of the circular.
ಅಲ್ಲ
Or
para
notification.
13 ಅಲ್ಲಿ
No, what was your prayer before the court? Did you seek quashment of the provision? That is not.
ಇದರಲ್ಲಿ ಇಲ್ಲ, but the court holds, having given our anxious consideration to the entire matter in issue, we find that the question involved in the instant writ petition is no longer res integra. On the other hand, it is squarely covered by the aforesaid decision of the apex court. Having regard to the law laid down with the Supreme Court in the above decision, impute notification annexure A, consequent circular dated annexure B cannot be sustained. That
So
is reason.
the section is not struck down.
Section, my lord, your lordship, have a look at the judgment, my lord. The court holds that such a guideline cannot be issued at all.
No, we are asking you whether section in so many words is struck
In
down.
respect of
Striking
Karnataka,
down of a legislative instrument is a
respect of-
serious matter.
in respect of very same Karnataka Act, as your lordship says, we do not find it here. But the
Some other,
some other pari-material.
no,
Oh.
that will not.
No, kindly see, my lord. Now, the question is, in that Basant Mehta's case, court says, such kind of circular cannot be issued at all.
ಅದ್ correct. Circular ನೋಡೋಣ. ಅದ್ನ
Now,
but,
we are only concerned with circular, we are not going into the validity.
the
But if they place reliance on 22A, that circular also becomes bad, that similar circular has been set aside, that 22A, you cannot interfere with the quasi-judicial functioning of the authority. In fact, my lord, that Basant.
the act of registering the document, is it
Is a
quasi-judicial?
quasi-judicial appeal, subject to appeal. And reasons have to be given, Rule 171. And an appeal can be filed against an order of refusal, recording of reason is a must.
Therefore, my lords, I said refusing,
And
171 is
the lordships are
refusing
aware of-
registration,
Not registering.
not registering. When you just register a document,
If it is registered, no appeal. Which is that section which gives the right of appeal?
That is Rule 171. If it is done, there is no need. Then Rule 171.
Section 72, my lords.
Read.
Section 72 of the Registration Act,
Read
appeal to
the rule.
register from orders of sub-register refusing registration.
That is right to, that is a right of appeal accrues on refusal to register the document.
Please, my lords.
Not registering the document.
Registered, you go to
No,
civil.
registering, my lord, it does not arise because and it is not like a third party getting aggrieved. Now, a person goes before the registration, it is done, there is no question of an appeal.
But, lords, on the basis of this,
The state government had initiated inquiry against about 28 sub-registrars. Alleging that they have violated these circulars. The inquiry was held. Retired district judge was appointed as inquiry officer. Reports are submitted more than 28 cases. The charges are held to be not proved, holding that it does not
Circular.
amount to a misconduct. And those sub-registrars are exonerated.
And circular finding is
There are-
circular has no
Cannot-
sanctity at all.
It does not override, these circulars does not override Rule 171 of the registration rules and 71 of the Act. All those sub-registrars are exonerated, holding that it does not amount to misconduct. If
And
it
they
is-
accepted the report.
No,
Allah,
the
they
state has exonerated us.
Okay.
no, that was prior to the impugned, sir. This is in
No,
respect.
no.
Alla, my lords,
Is
Also the same
circular,
circular.
Another circular.
no. The circular that I am placing before my lords is a 22A circular. The circular on the basis of which I have taken action is a government order where I have said without e-khata mapping in the software, you don't on the basis of a manual khata do it. That's a September 2024 government order. These are all older orders. This circular, my lords, is different. And secondly, my lords, the answer to them is straight away, my lords, under the G.J. Fernandez case says, my lords, what has statutory force? Even assuming, my lords, an instrument does not have statutory force, violation of that administrative instructions is amount to, will amount.
Provided you have power to issue binding administrative instruction.
No, the 22A. 22A is the, my lords, the only thing is this.
Court copy.
I have insisted under the circular issued under 22A that without a khata, khata is one of the documents on the basis of which you have to check RTC or a khata extract that is issued has to be checked whether the executant has his name in the khata before you can execute a document. September 2024, my lords, Bhumi, my lords, is a software in respect of the agriculture lands. I have eSottu and other softwares, my lords, where I have BBMP Khata software is integrated to the registration software in September 2024. And I've said in BBMP limits, don't register any document unless there is mapping of the BBMP e-Khata in your software. What they have done is they have overridden the software, registered more than 100 documents during that time period. And that is the misconduct I'm alleging.
Cannot
Now,
be
22A circular.
Nobody can override the software.
Others are that is my lords, the wherewithal here. Override in the sense it has to be with option A ಕೊಡ್ಬೇಕು ಅನ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ others ಅಂತ ಏನೋ ಮಾಡಿ they take a manual khata without an e-khata registered. It is a government order.
Let us understand how registration is done. This is ಇರ್ಲಿ ಯಾವುದು ಇದೆಯಾ ಕೊಡು ಕೊಡು ಇದು ಇದರಲ್ಲಿ how it is done, my lord, entire thing is a software created by the government. Now, until all the formalities are done, it is not uploaded at all. Now, ದಯವಿಟ್ಟು page ಎಲ್ಲಿದೆಯಾ ನಿಂದ್ರಲ್ಲಿ
Page 27.
page para 8.2 ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. Page 27. Now, in respect of 8.2 on the top, non-agricultural e-swattu. Now, this software says what type of document. Click clear to select non-agricultural property. Then, my lord, at the bottom, first is BBMP, second is e-swattu, UPOR, e-asti, BDA, others. Now, some of the people, my lord, will opt for others. Now, then after this is uploaded, it will come before the registrar. The entire thing is an automated program. There is nothing for the sub-registrar to receive and do anything. Now, my lord, recently this commissioner himself has given a paper statement. Your lordship may have a look at how this software works. May I just pass on, my lord, this article which came in the newspaper where ಇದರಲ್ಲಿ in this article ಕಾನೂನಿನ ದುರ್ಬಳಕೆ
ಇದು ಹೆಂಗಿದೆ ಹಂಗ ಇದು ಯಾವ್ದೋ
ಅಲ್ಲ ಅವರ ಆರ್ಟಿಕಲ್ ರಿಟರ್ನ್ ಬೈ KA ದಯಾನಂದ ಕಮಿಷನರ್. He himself has written the article.
ಅಲ್ಲ if he writes it is maybe personal is it
ಅಲ್ಲ it will only give an indication as to how this is being done. That is all. There is nothing else. I am not proving anything. ಅದರಲ್ಲಿ ಕಾನೂನಿನ ದುರ್ಬಳಕೆ ಅನ್ನೋ ಪ್ಯಾರಾದಲ್ಲಿ ಒಂದ್ಸರಿ ಓದ್ತೀನಿ. How it is this software is being done. ಈಗಾಗಲೇ ಕಾವೇರಿ 2 ತಂತ್ರಾಂಶದೊಂದಿಗೆ ಭೂಮಿ ತಂತ್ರಾಂಶವು ಸಂಯೋಜನೆಗೊಂಡು 16 ವರ್ಷಗಳೇ ಆದರೂ ಕಾವೇರಿಯಲ್ಲಿ ಅನಿವಾರ್ಯ ಪ್ರಕರಣಗಳಲ್ಲಿ ಬಳಸಲು ಕಲ್ಪಿಸಿದ್ದ ಇತರೆ ಎಂಬ ಅವಕಾಶ ಅದರ್ಸ್ ಅನ್ನೋದರಲ್ಲಿ ಅವಕಾಶವನ್ನು ಬಳಸಿಕೊಂಡು ನಿಯಮಬಾಹಿರವಾಗಿ 11 ಇಲ್ಲದೆ ಸುಳ್ಳು ಪಹಣಿ ಸೃಷ್ಟಿಸಿಕೊಂಡ ದಾಖಲೆ ಮೇಲೆ ನೋಂದಣಿ ಮಾಡಿಸಿಕೊಂಡ 106 ಪ್ರಕರಣಗಳು ನಮ್ಮ ಕಣ್ಣ ಮುಂದಿದೆ. ನಮ್ಮ ಜಮೀನು ಅಥವಾ ನಿವೇಶನ ನೋಂದಣಿ ಮಾಡಿಸಬೇಕೆಂದ್ರೆ ನಿವೇಶನಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಒಂದು ದಾಖಲೆ ಗುರುತಿನ ಚೀಟಿಯೊಂದಿಗೆ ಕಾವೇರಿಯಲ್ಲಿ ಸಿಟಿಜನ್ ಲಾಗಿನ್ನಿಂದ ನೋಂದಣಿಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ರಾಯಿತು. ನೋಂದಣಾಧಿಕಾರಿಗಳು ಪರಿಶೀಲಿಸಿ ನೋಂದಣಿ ಮಾಡುತ್ತಿದ್ದರು. ಸುಳ್ಳು ದಾಖಲೆ ಸೃಷ್ಟಿಸಿಕೊಂಡು ಸರ್ಕಾರಿ ಜಾಗವನ್ನು ಲಪಟಾಯಿಸುವುದು ಹಾಗೂ ಅನುಮೋದಿತವಲ್ಲದ ನಿವೇಶನಗಳನ್ನು ಮಾರಾಟ ಮಾಡುವ ಮೂಲಕ 45% ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಬೇಕಾದ CA ನಿವೇಶನ, ಪಾರ್ಕ್ ಮತ್ತು ರಸ್ತೆಗಳನ್ನು ಲಪಟಾಯಿಸುವುದು. ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಒಂದು ಕೇಸು ತಗಲಿ ಅವಶ್ಯವಿದ್ದರೆ ನೈಜ ವ್ಯಕ್ತಿಯ ವಿರುದ್ಧ ಪೊಲೀಸ್ ದೂರು ಸಲ್ಲಿಸಿ ಆಸ್ತಿಯ ವಿಷಯದಲ್ಲಿ ಗೊಂದಲ ಸೃಷ್ಟಿಸಿ ನಂತರ ಸಂಧಾನಕ್ಕೆ ಆಹ್ವಾನಿಸುವುದು. ಬರೆದಿದ್ದರೆ ನ್ಯಾಯಾಲಯ ಅಲಿಯುವಂತೆ ಮಾಡುವ ಮೂಲಕ ಕೆಲವು ಹಣ ಮಾಡುವುದು ಕೆಲವು ಜನರ ದಂಧೆ. ಎಲ್ಲ ಸಮಸ್ಯೆಯ ಮೂಲದಲ್ಲಿ ಆಳುವ ಮತ್ತು ಆಳಿಸಿಕೊಳ್ಳುವವರ ಪಾತ್ರ ಸಮಾನವಾಗಿದೆ ಎಂಬುದಷ್ಟೇ ಮುಖ್ಯ. ಇವುಗಳಿಗೆ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳುವ ನಿಟ್ಟಿನಲ್ಲಿ ಸರ್ಕಾರ ಕೈಗೊಂಡ ಒಂದು ನಿರ್ಣಯ ಐತಿಹಾಸಿಕವಾದ ಮತ್ತು ದೇಶದಲ್ಲಿ ಪ್ರಪ್ರಥಮವಾಗಿ ಮಾದರಿಯಾದದ್ದು. ಅದೇ ಕಾವೇರಿ 2 ತಂತ್ರಾಂಶದೊಂದಿಗೆ BBMP ಖಾತೆ ನಿರ್ವಹಿಸಲು ಬಳಸುವ ಈ ಆಸ್ತಿ. ಕರ್ನಾಟಕದ ಎಲ್ಲ ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳು ಖಾತೆ ನಿರ್ವಹಿಸಲು ಬಳಸುವ ಈ ಆಸ್ತಿ, ಬಿಡಿ ಆಸ್ತಿಗಳ ಖಾತೆ ನಿರ್ವಹಿಸಲು ಬಳಸುವ ULMS, ಕರ್ನಾಟಕದ ಎಲ್ಲ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಗಳು ಖಾತೆ ಬಳಸುವ ಈ ಸ್ವತ್ತು ತಂತ್ರಾಂಶಗಳನ್ನು 2024 ಸೆಪ್ಟೆಂಬರ್ನಿಂದ ಹಂತವಾಗಿ ಸಂಯೋಜನೆಗೊಳಿಸಿ 24ರಿಂದ ಅಕ್ಟೋಬರ್ 30ರಿಂದ 100% ಕಡ್ಡಾಯಗೊಳಿಸಲಾಯಿತು. ಪ್ರಸ್ತುತ ನೀವು ಒಂದು ನಿವೇಶನ ಮಾರಾಟ ಮಾಡಿ ಅಥವಾ ಖರೀದಿಸಿ ನೋಂದಣಿ ಮಾಡಬೇಕೆಂದರೆ ಸಂಬಂಧಿಸಿದ ನಿವೇಶನ ಗ್ರಾಮ ಪಂಚಾಯತ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿದ್ದರೆ ಈ ಸ್ವತ್ತು, ನಗರ ಆಡಳಿತದ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಟ್ಟ ಈ ಸ್ವತ್ತು ತಂತ್ರಾಂಶದಲ್ಲಿ ಈ ಖಾತೆ ಹೊಂದಿರಬೇಕು. ಅದರಿಂದ ನಿವೇಶನಕ್ಕೆ ಒಂದು PID ನಂಬರ್ ಸೃಜನೆಗೊಂಡಿರುತ್ತದೆ. ಆ PID ನಂಬರನ್ನು ಕಾವೇರಿ 2 ತಂತ್ರಾಂಶದಲ್ಲಿ ನೋಂದಣಿ ಮಾಡಿಸಲು ಕ್ರಯದಾರರು ಸಿಟಿಜನ್ ಲಾಗಿನ್ನಲ್ಲಿ ನಮೂದಿಸಿದಾಗ ಕಾವೇರಿ 2 ಮತ್ತು ಈ ಸ್ವತ್ತು ಈ ಆಸ್ತಿ ತಂತ್ರಾಂಶಗಳನ್ನು ಒಂದನ್ನೊಂದು ಸಂಯೋಜಿಸಿರುವುದರಿಂದ ಅವುಗಳು ಪರಸ್ಪರ ಪರಿಶೀಲಿಸಿಕೊಂಡು ಈ ಖಾತೆಯ ಮಾರಾಟಗಾರನ ಹೆಸರಿನಿಂದ ಖಚಿತಪಡಿಸಿಕೊಂಡು ಮೇಲೆ ನೋಂದಣಿ ಪ್ರಕ್ರಿಯೆ ಮುಂದುವರಿಯಲು ಅವಕಾಶ ನೀಡುತ್ತದೆ. ಎಲ್ಲ ಸಾಫ್ಟ್ವೇರ್ ಅಲ್ಲೇ ಬರುತ್ತೆ. Is only say whether registered or not, refuse to register. That is all. Now in the notice that is given to us, Lord, he says ಆಧಾರ್ ಕಾರ್ಡ್ ಅನ್ನ ನೀವು ನಾಟ್ ಅಪ್ಲೈಡ್ ಅಂತ ಹೇಳಿದ್ದೀರಾ. whereas they have produced other ID documents. ಆಧಾರ್ ಕಾರ್ಡ್ itself is not the only document. Then secondly they say ನೀವು ಈ ಆಸ್ತಿ ಈ ಸ್ವತ್ತು ತಂತ್ರಾಂಶದಿಂದ ಈ ಖಾತಾ ಪಡೆಯದೆ ಇಂಟಿಗ್ರೇಷನ್ ವಿಧಾನ ಅನುಸರಿಸದೆ, ಆವಾಗ ಮುಂಚೆ ಅದರ್ ಅಂತಿತ್ತು, ಈಗ ಅದರ್ಸ್ ಅನ್ನು ತೆಗೆದುಹಾಕಿದ್ದಾರೆ. ಎಂಟೈರ್ ಥಿಂಗ್ ಇಸ್ ಡನ್ ಬೈ ಸಾಫ್ಟ್ವೇರ್. ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಡಸ್ ನಾಟ್ ಡೂ ಎನಿಥಿಂಗ್. ಸಿಟಿಜನ್ ಲಾಗಿನ್ ಅಲ್ಲೇ ಬರುತ್ತೆ.
ಈಗ ನೋಟಿಫಿಕೇಶನ್ ಸರ್ಕ್ಯುಲರ್ ಇಶ್ಯೂ ಮಾಡಿದಾರಲ್ಲ, ಅದೇ ರೀತಿಯ ಸರ್ಕ್ಯುಲರ್ ನ ಸ್ಟ್ರೈಕ್ ಡೌನ್ ಮಾಡಿತ್ತ ಕೋರ್ಟ್.
ಸ್ಟ್ರೈಕ್ ಡೌನ್ ಮಾಡಿದ್ದಾರೆ.
ತೋರಿಸಿ.
Answer is no.
Similar provision was made that these are the documents which are opposed to public.
This is a three judgment
Yes, sir.
decision,
Division bench.
division bench.
Just
The government order that I've issued now is only a government order saying that in BBMP limits, there is integration of software that has happened. So without,
Our question is.
it is
whether,
not,
it has, you have power to do it is the question.
Millards, power,
Where is that power?
Millards.
Because such a notification is already struck down
But-
by a division bench of, coordinate bench of this court.
but stayed in the Supreme Court.
That notification is stayed.
That judgment is stayed,
No, this, not this judge, Pawnesh is stayed.
not published. The letter, no, which is,
Judgment
please,
has
Millards.
attained finality. See, this judgment came in, this was in which year? In January, 3rd January 2006.
My lords are referring to the other one. Millards.
B. Pawnesh versus State of Karnataka. Identical notification is struck down.
I'll just point out, Millards. I'll just clarify that. Lords, in B, D. Pawnesh
Pawnesh.
matter,
This notification was issued under which section, Mr. Harnett?
Well, this earlier notification,
Yeah. 22A
this
only.
was issued under 22A.
On
In
what?
Pawnesh case, at
On-
page 866.
Very well. On what ground?
They said that such power cannot be issued contrary to rule of law prevailing in, you cannot say that converted land, non-converted land cannot be registered and other things it cannot issue. Such a notification cannot be issued. There is no authority of law to issue such a circular.
Lords, relying on this judgment, the subsequent judgment also, my lords, relying upon the other case where 22A, my lords, of Rajasthan was struck down, and this judgment, this honorable court struck down my extant 2016 circular. But we are not on the violation of 2016 circular. 2016 circular, I bought it out, my lords, because my lords asked me.
No, whether
on-
you duplicated the same circular, we are asking that.
No, I
If
can
if an act is found fault with by a court, by a
duplicate,
constitutional
please, my
court,
lords, I,
you cannot, and it is struck down, you cannot duplicate that act.
without removing the basis.
Ah.
I bought on, my lords, to that proposal.
Okay, whether that, this is the duplication?
I'll just clarify, my lords.
Yes.
Lords, 2016 I bought up only for the sake, because my lords asked a query specifically on where is the power for you to insist that the sub-registrar has to look into the following documents before registering, only for the purpose.
No, we are asking simple question.
Please. Lords,
Whether the notification circular, whatever you said now,
please,
whether that document or instrument
please.
is matchable to the one which is struck down by the coordinate
Please.
bench.
I will just get this tomorrow morning. Lords. I'll
Yes,
please-
sir.
No, my lords, Pawnesh, my lords, if my lords,
Idrilla
if
ide.
it is stuck, my lords, if it's a similar instrument, I'll just put it this way, my lords.
If it is struck down,
If it's a similar instrument,
you cannot replicate it.
I cannot replicate it, my lords, and on that basis, my lords, one more thing, my lords, this is a suspension matter. December 2024, my lords, we suspended them. And my lords, they did not have the benefit of an interim order, my lords.
That's another thing.
Please,
Now we have heard everything.
it is 3 months
See,
more now.
It may be 6 months.
Please, my lords,
Question is not that.
please. I will place those
No,
circulars.
we are a very limited government, doctrine of limited government.
Please, my lords.
Means you should govern us minimum. You should govern us minimum. That is the PhD thesis of D.D. Basu. Doctrine of limited government. His book itself is limited government. The idea is government cannot do anything which the law does not authorize it to do. Man can do everything which the law does not prohibit him from doing. That's the law.
Please, my lords.
Therefore, if your circular is matchable to the one which has been struck down by the coordinate bench, then you cannot,
My lords, I will
you
place those
can't
two,
go on
I will
replicating it.
place those two circulars before my lord tomorrow morning, and my
Alright.
lords can, I will leave it.
Idrilla ide.
10ವರೆಗೆ ಬಂದ್ಬಿಡ್ರಿ
ಆಯ್ತು, 10 first matter.
ಇದರಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ,
circular.
copy of the
ರೆಫರ್
circular,
ಮಾಡಿದ್ದಾರೆ.
I'll place it on-
Circular is, you cannot register certain type of lands. That is the issue,
I will
that if
place
it is
those
not
circulars, my
converted,
lords, tomorrow
it cannot be
first
registered.
matter.
ನಾಳೆ ನಾಳೆ
I'll place those circulars on it.
ನಾಳೆ ತಗೊಂಡ್ಬರ್ಬೇಕು.
ಅಲ್ಲ, ನಾವಾಗ್ಲೇ ನಾಲ್ಕು ಸಾರಿ
ಎಲ್ಲ ರೆಡಿ
ಬಂದಿದ್ದು.
ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟು.
Please, I'll place it at 10:30.
ಅಲ್ಲ, ಈಗ
Order of that is struck down. You
Then
cannot
I
replicate.
will leave it at that. I will place it because those two circulars, my lords, may.
ಆಮೇಲೆ ಅವ್ರ ಮೇಲೆಲ್ಲ ಆಕ್ಷನ್ ಮಾಡ್ದ ರಿಪೋರ್ಟ್ ತಗೊಂಡು ಅವ್ರನ್ನೆಲ್ಲ ಎಕ್ಸಾನ್ರೇಟ್ ಬೇರೆ ಮಾಡಿದ್ರು.
ಅಲ್ಲ, ಇವ್ರು ಏನಿಲ್ಲ,
ಅಲ್ಲ, that
ಸಸ್ಪೆಂಡ್
is
ಮಾಡೋದು,
earlier
ಎಕ್ಸಾನರೇಟ್ ಮಾಡೋದು ಅಷ್ಟೇ ಮಾಡೋದು.
2016 circular ಮೇಲೆ.
ಇದು
Similar circulars was issued in the year 2013-14. But my learned friend may not be right in saying that At that time, there was no circular, but the executive order was existed at that time, Lord, in the year 2013 to 2019. But allegation was, we have violated those executive order. But the state government says that those.
No misconduct.
It does not amount to misconduct for the reason that, Lord, executive order has to yield to the rules. Rule 171, it has an overriding effect.
Kindly just make some research. What is the nature of?
I'll do that. I'll do that.
When he registers.
Please.
And when he refuses to register, automatically it is
Please.
available, as Mr. Harnally said, then we have no much difficulty.
Please. But if he registers it,
If he registers it, the act of registering a document,
please.
is it quasi-judicial or administrative? Okay.
Grateful.
Kumar, for further hearing. Furthermore hearing. Yes. Huh? Sorry.
This is that KPSC matter.
Yes, sir.
AW recruitment matter.
Yes, sir.
Let's AG also. AG is appearing for the state minutes. I am appearing for the KPSC. Let's insofar as the recruitment in question is concerned. Let's we had the three recommendations that were made. The principal recommendations is for commission to take steps to cancel the selection of the tainted candidates as shown is para 66 of the report. That is one thing, my lords. Second thing is commission shall authorize secretary to initiate criminal action against the tainted candidates by lodging complaint to the police. The commission to request government to order investigation through CID to unravel the truth. Lords, my lords, that report of the committee. Spiral bind.
Spiral bind ಇದೆ ಕೊಡಿ.
report ನಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅದನ್ನು at least I must have benefit of reading those.
That is only
ಯಾವ್ದನ್ನು ನಿಮ್ಮ against ಉಪಯೋಗಿಸಲ್ಲ immediately. Great. ಆಮೇಲೆ ಉಪಯೋಗಿಸಬಹುದು ನಾವು.
Notes page 88 minutes. Top of the page, page numbers.
88. ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕು. ಅವ್ರಿಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗೋದು? You are keeping them in darkness and you are arguing. So that we can make effective order applicable to them also. ಒಂದು ಕಾಪಿ ಅವರಿಗೂ ಕೊಡ್ಬೇಕು.
But since it was a report of the which were I will.
ಎಂತದ್ದು ಈಗ ಇದ್ರಾಗ ಇರೋದು ಅಷ್ಟು ಪಬ್ಲಿಕ್ KR ಮಾರ್ಕೆಟ್ನಾಗ ಇರೋರಿಗೂ ಗೊತ್ತಿದೆ. ಇದ್ರಾಗಿಂದ ಮುಚ್ಚಿಡುವಂತದ್ದು ಏನಿಲ್ಲ. ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗ್ಬಿಟ್ಟಿದೆ, ನಿಮ್ಗೂ ಗೊತ್ತಾಗಿದೆ, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಿದೆ ಏನ್ ಎಲ್ಲಿದೆ, ಏನ್ ನಡೆದಿದೆ. ಪೀಪಲ್ ಅಷ್ಟು ದಡ್ರಿದ್ದಾರೆ ಅಂತ ಅನ್ಕೋಬೇಡಿ. ಅವರು ಬೇರೆ ವೆಜಿಟೇಬಲ್ ವೆಂಡರ್ಸು ಅಥವಾ ಹಾಕರ್ಸು, ಸ್ಟ್ರೀಟ್ ಹಾಕರ್ಸು, ಅವರು ಮರ್ಚೆಂಟ್ಸ್ ಅವ್ರಿಗೇನು ತಿಳಿಯಲ್ಲ, ರೈತರು ಅವ್ರಿಗೆ ತಿಳಿಯಲ್ಲ, ಲೇಬರರ್ಸ್ ಅವ್ರಿಗೆ ಹಂಗೆ ಅನ್ಕೋಬೇಡಿ. ಎಲ್ಲರಿಗೂ ಒಂದ್ ಭಗವಂತ ಏನೋ ಒಂದ್ ಲೆವೆಲ್ ಬುದ್ಧಿ ಕೊಟ್ಟಿರ್ತಾನೆ.
88
ಏನ್ ನಡೆದಿದೆ ಅಂತ ಗೊತ್ತಾಗ್ತದೆ.
Karnataka knows.
ಇಲ್ಲ, even other states also.
Other state ಇಲ್ಲ, abroad ಇಂದಲೂ ಕಾಲ್ ಬಂದಿದೆ.
ಒಂದು ಥಿಂಗ್ ಅಂದ್ರೆ 1943 ಅಲ್ಲಿರ್ಬೇಕು. DVG ಅವರ ಒಂದು ಮಂಕುತಿಮ್ಮನ ಕಗ್ಗದಲ್ಲಿರುವಂತಹ ಒಂದು ಮುಕ್ತಕ ಅಂತಾರ, ಸ್ಟ್ಯಾಂಜಾ ಅಂತ ಅನ್ಕೋಬಹುದು ನೀವು. ಮುಕ್ತಕಕ್ಕೆ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಇಕ್ವಲೆಂಟ್ ಇಲ್ಲ. ಸರಕಾರ ಹರಿಗೋಲು, ಸೆರೆ ಕುಡಿದವರು ಹುಟ್ಟು ಹಾಕುತ್ತಿಹರು, ಬಿರುಗಾಳಿ ಬೀಸಿಹುದು, ಜನರೆದ್ದು ಕುಣಿಯುತ್ತಿಹರು, ಮುಳುಗದಿರುವುದಚ್ಚರಿಯೋ ಮಂಕುತಿಮ್ಮ ಅಂತ. ಯಾವಾಗಿದ್ದು? ಅವಾಗೆ ನಿಮ್ಮೇಲೆ ಹೇಳಿಲ್ಲ, ಅವರು ಬಹಳ ಹಿಂದೆ ಹೇಳಿದ್ದು. ಸರ್ಕಾರ ಹರಿಗೋಲಂತೆ, ಸೆರೆ ಕುಡಿದವ್ರು ಅದ್ ನಡೆಸ್ತಾ ಇದಾರಂತೆ, ಬಿರುಗಾಳಿ ಬೀಸಿದೆಯಂತೆ, ಜನ ಎದ್ದು ಕುಣಿತಾ ಇದಾರಂತೆ, ಮುಳುಗದಿರುವುದಚ್ಚರಿಯೋ. ಅದು ಯಾಕೆ ಮುಳುಗಿಲ್ಲ ಅನ್ನೋದೇ ವಿಚಿತ್ರ ಬ್ರಹ್ಮ. Anyway,
88.
ಇದು this is the report of whose report?
Lords, this is the report of a
5-member committee.
5-member committee of the commission, consisting of 5 members of the commission, which has been accepted by the commission and forwarded to the state government also.
One second. What is the date of this report?
23/1/2025.
When this report is submitted to the government?
Lords, this report
2025.
Huh?
2 February 25.
2/25.
Correct.
23/1 is date.
Date of the report. 31-1.
ಐದು ಜನ ಯುನಾನಿಮಸ್ ಆಗಿ ಕೊಟ್ಟಾರೋ ಡಿಸೆಂಟರ್ಸ್ ಇದ್ದಾರೆ?
ಇಲ್ಲ, unanimous.
It's a unanimous.
Unanimous report.
Okay.
Accepted by the commission in the meeting on 31-1-25.
31-1.
31st January 25.
And my lords,
ಏನು ರೆಕಮೆಂಡೇಶನ್ ಏನೇನಿದೆ?
88, page 88. Lords, recommendation.
31-1 ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರಾ?
Accept ಮಾಡಿದ್ವಿ sir.
ಯಾರ್ಯಾರಿದ್ರು ಮೀಟಿಂಗ್ ನಲ್ಲಿ?
Please, my lords, in the meeting of the commission.
ಯಾರ್ಯಾರು ಮೆಂಬರ್ಸ್ ಎಷ್ಟು ಜನ ಇದ್ರು? ಯಾರ್ಯಾರಿದ್ರು?
I'll just play.
ಹೇಳಿ.
ಅಲ್ಲ, proceedings, ಅಲ್ಲ, commission in record.
ಬರ್ಕೊಂಡು ರೈಟ್. The 5-member committee wide report dated, wide voluminous report dated 23 January 2025.
125 ಅಲ್ವಾ ಲೆಟರ್?
Submitted its recommendation to the chairman of KPSC. ಏನಂತ ಹೇಳಿದ್ರು ರಿಪೋರ್ಟ್?
Lords, para 88, page 88, my lords. First three recommendations are with regard to the present recruitment.
ಈ ಎಲ್ಲಾ ಸೆಲೆಕ್ಷನ್ ಅನ್ನ
ಅಲ್ಲ, tainted candidates.
tainted candidates as shown in para number 66 of the report.
10 candidates have been shown.
Page 80 may be kind.
10
Page 80.
80
80 man.
80. ಓದಿಬಿಡಿ.
Please, my lords. The commission, I'm reading recommendation, my lords.
ಹಾ.
The commission shall cancel the selection.
Learned Advocate General said we should read page 80.
880, my lords.
Para 65 or 6?
66, my lords.
66. Okay.
As such, the subcommittee has found the following candidates guilty of malpractice, unfair practice for the purpose of the selection. RPC list, my lords, 9 candidates.
ಹೆಸರುಗಳನ್ನು ಓದೋದು ಬೇಡ.
Please, my lord, 9 and 1.
ಏನೋ ನಮ್ಗೆ ಗೊತ್ತಲ್ಲ.
Total.
ಅದಿರ್ಲಿ. ಮಾಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಏನಿದೆ? ಏನ್
Please.
ಮಾಲ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ್ರಿ ಇವ್ರು?
Lords, this is pertaining to their OMR sheets were tampered, my lords. It was found that the OMR sheets, my lords, that were available in the commission, on the basis of which valuation was done, in respect of these 10 candidates, was found to be tampered in terms of the FSL report, the Forensic Science Laboratory report.
FSL ರಿಪೋರ್ಟ್ ಟ್ಯಾಂಪರ್ ಆಗಿದೆ ಅಂತ
ಹೇಳ್ತಾರೆ.
ಅದನ್ನು 31-1 ಹೇಳ್ತು.
ಅದು 31-1 ಹೇಳ್ತೀವಿ.
ನೀವು ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಅನ್ನ ಕಳಿಸಿದ್ದೆ ಅವಾಗ?
ಅದು ಒಂದು ವರ್ಷದ ಹಿಂದೆ. It was 1 year back.
1 year back.
This is 25 minutes.
This is 31-1-2025.
25 minutes.
That select list was
31st January 2024.
ಇದು ಈ ಹೆಸರುಗಳಲ್ಲಿ ಪಿಟಿಷನರ್ಸ್ ಯಾರ ಇದಾರ?
ಎಲ್ಲ petitioner, only petitioner.
Only petitioners.
ತಾವು ಓದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ ಈ ಕಾಮೆಂಟ್ಸ್ ಏನಂತ ಟೆಂಪರಿಂಗ್ ಅಂತ ಹೇಳೋದಲ್ಲ. ತಾವು ಓದಿ ಗೊತ್ತಾ?
No, my lord.
Factual statement.
ನನಗೆ
We'll come back.
ನನಗೆ ಕಾಪಿ ಇಲ್ಲದೆ ನಿಮ್ಗೆ ಹೇಳಲಿಕ್ಕೆ ಆಗಲ್ಲ.
ಇಲ್ಲ
ಕೊಟ್ಬಿಟ್ಟು ಹೇಳ್ಬಿಡ್ತೇನೆ ನಮ್ಗೆ.
Lords, not only that, kindly note the timing. Lords, when the final appointment orders were issued, there was a condition that it is a conditional appointment order. They keep quiet, they accept the condition, but they come to know of this.
Why by the time you sent that final select list,
Please, my lords.
the committee was functioning.
3-member committee was functioning.
There was a committee.
There was a committee, my lords.
The committee was looking into all these
Please,
things.
please. Committee was looking into that, and the committee, my lords, was not able to, there was some issue with the functioning of the committee.
ಎಷ್ಟು ಮೀಟಿಂಗ್ ಆಗಿತ್ತು?
My lords, total meetings as on that day.
ಕಮಿಟಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿದ್ದು ಕೆಪಿಎಸ್ಸಿನೇ
Committee
by resolution.
by resolution.
It's a unanimous resolution. Is it a unanimous resolution? ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನ ಆಗಿತ್ತ?
Unanimous, please, unanimous.
ಸರ್ವಾನುಮತದಿಂದ.
I'll place those resolutions on record.
ಇದರಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಆಗ್ಲೇಬೇಕು.
ಹೌದು ಸರ್.
ಆ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಲಿಕ್ಕೆ 3 ಜನರದ್ದು ಒಂದು ಸಮಿತಿಯನ್ನು ನಿರ್ಮಾಣ ಮಾಡಬೇಕು.
Please.
ಆ ಪ್ರಕಾರ ಸಮಿತಿ ನಿರ್ಮಾಣ ಆಯಿತು.
Please.
ಅಲ್ಲಿರುವಂತ 3 ಜನ ಸದಸ್ಯರು
Please.
ಕೆಪಿಎಸ್ಸಿ ಸದಸ್ಯರೇ
ಹೌದು ಸರ್.
ಅಲ್ವಾ?
ಹೌದು.
ಯಾರ್ಯಾರು ಅವರು?
Lords, ಶಾಂತಾ ಹೊಸಮನಿ, ಗೀತಾ ಬಿವಿ, ಮುಸ್ತಫಾ ಹುಸೇನ್, page 8. First instance.
ಶ್ರೀಮತಿ ಶಾಂತಾ
ಹೊಸಮನಿ,
Page number 8, para 12 man.
ಗೀತಾ ಬಿವಿ,
ಶ್ರೀಮತಿ ಅಂತ ಅನ್ಬೇಕು.
ಗೀತಾ ಬಿವಿ, and
PV and
Shri
Shri
Mustafa Hussain, SA.
ಇವರು ಇವ್ರದ್ದು ಇದು ಏನು ಡೆಸಿಗ್ನೇಷನ್ಸ್
Members, they are all members of the commission.
ಅಲ್ಲ ಅದಾಯ್ತು.
ಇದರಲ್ಲಿ
ಎಜುಕೇಶನಲ್ ಕ್ವಾಲಿಫಿಕೇಶನ್
Shanta Hosmani is chairperson in this.
Can I request page number 8 in the report is given?
ಅಲ್ಲ ಸ್ವಲ್ಪ ಎಲ್ಲ ಗೊತ್ತಾಗ್ಲಿ ಅಂತ.
Oh, I'm sorry.
We want people
sorry.
to know.
I'm sorry, madam. I didn't.
ಪೀಪಲ್ಸ್ ಕೋರ್ಟ್ ಅಂತಿರಲ್ಲ ಈಗ ಹಂಗ ಪೀಪಲ್ಸ್ ಕೋರ್ಟಿಗೆ ಹೊಂಟೇವ್ ನಾವು ಈಗ ಕೋರ್ಟ್ ನಿಂದ
I'm sorry.
ಎಲ್ಲ ಗೊತ್ತಾಗ್ಲಿ. ಇದೇನ್ ಬೇರೆ ಉದ್ದೇಶ ಅಲ್ಲ ಇಷ್ಟ. ಏನು ಅಂದ್ರೆ ಜನ ಕ್ರಾಂತಿ ಮಾಡಬಾರ್ದು ಅನ್ನೋದಕ್ಕೆ ಇಷ್ಟು ಪ್ರಯತ್ನ. ಇಲ್ಲ ನಾವ್ ಇದನ್ನೊಂದು 6 ವಾರ 8 ವಾರ ಮುಂದೆ ಹಾಕಿದ್ರೆ ಕ್ರಾಂತಿ ಆಗ್ಬೋದು.
ಇಲ್ಲ madam. We'll assist your lordship. Just read in detail. Read it.
This committee was constituted, white resolution dated
Lord's White resolution dated
8/12/23.
8/12/23.
ಎಷ್ಟು ಜನ ಇವರು ಮೆಂಬರ್ಸ್ ಇದ್ರು KPSC ಅಲ್ಲಿ ಅವತ್ತು?
Lord's that I have to get the meeting proceedings. I'll get yours.
ಫೋನ್ ಮಾಡ್ಕೆ ನಿಮ್ಮ ಇವ್ರು ಇರ್ತಾರೆ ಕಳಿಸ್ಕೊಳ್ಳಿ, ಅವ್ರ ಮಗ್ಲಲ್ಲಿ ಕೂಡಿಸ್ಕೊಳ್ಳಿ, ಅವ್ರನ್ನ ಕೂಡಿಸ್ಕೊಳ್ಳಿ, ಅವ್ರಿಗೊಂದು ಸೀಟ್ ಕೊಡಿ, ಅವ್ರನ್ನ ಕೂಡಿಸ್ಕೊಳ್ಳಿ. ಎಷ್ಟು ಜನ ಇದ್ರು?
Lord's 15 members.
All 15 members?
Please, my lords.
ನಮ್ಮಲ್ಲಿ 15 ಜನ ಇದ್ದಾರೆ KPSC ಮೆಂಬರ್ಸ್. ಚೇರ್ಮನ್ ಕೂಡಿಕೊಂಡು ಚೇರ್ಪರ್ಸನ್ ಕೂಡಿಕೊಂಡು 15 ಜನ.
16 ಸ್ವಾಮಿ.
16. 15 + 1. ಬೇರೆ ರಾಜ್ಯಗಳಲ್ಲೂ ಇದೆಯಾ? Anyway.
Education in the country, my lords.
Huh?
More than UPSC, madam.
More than
I'm very fine.
So 16 persons were there that day. 16 ಜನ ಇದ್ರ ಈ ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಆಗುವಾಗ.
Lords, that is we're not. We'll get it. I'll get it.
ಫೋನ್ ಮಾಡ್ತೀವಿ ಕಾನ್ಸೆಪ್ಟ್.
Please, my lords.
Anyway, it's a unanimous resolution.
Please.
ಅಲ್ವಾ? ಈ ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಏನ್ ಕಾರಣದಿಂದ ಮಾಡಿದ್ರಿ? ಯಾಕೆ ಕಮಿಟಿ ಮಾಡ್ಬೇಕು ಅಂತ ತಲೆಯಲ್ಲಿ ಬಂತು ನಿಮ್ಗೆ?
Lords, when after the provisional select list was published,
ಅದೇ ಹೊತ್ತು
Lords, the provisional select list was published on 22/9/23.
22/9/2023.
Complaint was received
ಯಾರಿಂದ?
from one Anand S. Siddha Reddy on 25/9/23.
ನೀವು ಕುತ್ಕೊಳ್ಳಿ, ನಮ್ಗೆ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತದೆ. ನಮ್ದು ಆ ರೀತಿ ಇಂಟರ್ಫಿಯರ್ ಆಗೋದು ಲೈಕ್ ಆಗಲ್ಲ ಅದಕ್ಕೆ. 22/9/2023 ಫೈನಲ್ ಪ್ರೊವಿಷನಲ್ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್.
25/9/23 ಗೆ
ಕಂಪ್ಲೇಂಟ್
/objection.
ಅವ್ರು ಯಾರು? ಈಸಿ ಒನ್ ಆಫ್ ದ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್.
Please, my lords. Aggregate. He is one of the non-selected candidates.
Non-select.
Anand S. Siddha Reddy.
They can push. 24.
He was not selected.
He was not selected.
Is a non-selectee candidate.
Please, my lords.
He gave the complaint on
25/9/23.
ಆ ಕಾಪಿ ಇದೇನು ಇದರಲ್ಲಿ?
Please, my lords.
ಎಲ್ಲಿದೆ ಅದು?
Annexure A, page number 94. And the covering email 96.
ಎರಡನೇ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅನ್ನು ಓದಿ.
ಅದರಂತೆ
ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿರುವ ಕೆಲವು
ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಓದಿಬಿಡಿ, ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗಿ. ಪಾಪ ಬಹಳ ಜನ ನೋಡ್ತಿರ್ತಾರೆ.
ಅದರಂತೆ ತಾತ್ಕಾಲಿಕ
complaint
ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿರುವ ಕೆಲವು ಅಭ್ಯರ್ಥಿಗಳು ಇತ್ತೀಚೆಗೆ ಆಯೋಗದಿಂದ ನಡೆಸಿದ ಯಾವುದೇ ಪರೀಕ್ಷೆಗಳಲ್ಲಿ
ಮೈಕಿಗೆ ಬನ್ನಿ, ಮೈಕ್ ಹತ್ರ ಬನ್ನಿ. We want this to people should know everything. That is the only way to control you people. It is impossible to do anything. All right, read it now.
ಅದರಂತೆ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ
ಪಾಪ ಅವ್ರಿಗೊಬ್ಬರಿಗೆ ಸೀಟ್ ಕೊಡಿ. Please give seat to officer of the KPS. He is standing, the retired judicial officer. ಅವ್ರ ಹತ್ರದಲ್ಲಿ ಕುಡಿಸ್ಕೊಳ್ಳಿ, ಮುಂದ್ಗಡೆ ಕುತ್ಕೊಳ್ಳಿ. ಇನ್ಫಾರ್ಮೇಶನ್ ಎಲ್ಲ ಕೊಡ್ಬೇಕು ನೀವು. ಹಾ, ಅದರಂತೆ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿರುವ ಕೆಲವು ಅಭ್ಯರ್ಥಿಗಳು ಇತ್ತೀಚೆಗೆ ಆಯೋಗದಿಂದ ನಡೆಸಿದ ಯಾವುದೇ ಪರೀಕ್ಷೆಗಳಲ್ಲಿ ಇದೇ ಇಲಾಖೆಯ ಅಸಿಸ್ಟೆಂಟ್ ಇಂಜಿನಿಯರ್ ಮತ್ತು ಜೂನಿಯರ್ ಇಂಜಿನಿಯರ್ ಹುದ್ದೆ ಒಳಗೊಂಡಂತೆ ಕನಿಷ್ಠ 1:3 ಅನುಪಾತದ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿಯೂ ಕೂಡ ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಕೆಲವು ಪರೀಕ್ಷೆಗಳಲ್ಲಿ ಕನಿಷ್ಠ 30% ಅಂಕಗಳನ್ನು ಕೂಡ ಪಡೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. ಆದರೆ ದಿನಾಂಕ 2/7/2023 ನಡೆಸಿದ ಗ್ರಾಮೀಣ ಕುಡಿಯುವ ನೀರು ಮತ್ತು ನೈರ್ಮಲ್ಯ ಇಲಾಖೆಯ ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು ಗ್ರೇಡ್ 1 ಹುದ್ದೆಯ ಲಿಖಿತ ಪರೀಕ್ಷೆಯು ಇಲಾಖೆಯಿಂದ ನಡೆಸಲಾದ ಲಿಖಿತ ಪರೀಕ್ಷೆಗಳಲ್ಲಿ ಅತ್ಯಂತ ವಿಭಿನ್ನ ಮತ್ತು ಕಠಿಣವಾಗಿದ್ದಾಗ್ಯೂ ಕೂಡ ಸದರಿ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಪ್ರತಿಶತ 70% ಅಂಕಗಳನ್ನು ಪಡೆಯುವ ಮೂಲಕ ಈ ಹಿಂದೆ ಆಯೋಗದಿಂದ ನಡೆಸಲಾದ ಎಲ್ಲಾ ಲಿಖಿತ ಪರೀಕ್ಷೆಗಳಿಗಿಂತ ಅತಿ ಹೆಚ್ಚಿನ ಅಂಕಗಳನ್ನು ಪಡೆದುಕೊಳ್ಳುವ ಮೂಲಕ ಮೇಲ್ನೋಟಕ್ಕೆ ಅಕ್ರಮವೆಸಗಿರುವ
ಅನುಮಾನಗಳಿಗೆ ಎಡೆಮಾಡಿಕೊಟ್ಟಿರುವುದಲ್ಲದೆ ಪ್ರಾಮಾಣಿಕ ಅಭ್ಯರ್ಥಿಗಳಲ್ಲಿ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಯ ಪಾರದರ್ಶಕತೆಯ ಬಗ್ಗೆ ಆತಂಕವನ್ನು ಸೃಷ್ಟಿಸಿದೆ. ಆದುದರಿಂದ ಮಾನ್ಯರಾದ ತಾವುಗಳು ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿರುವ ಉಳಿಕೆ ವೃಂದದ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿನ ಕ್ರಮ ಸಂಖ್ಯೆ 1, 2, 3, 4, 6, 7, 8 ಮತ್ತು 9ರಲ್ಲಿ ಆಯ್ಕೆಯಾಗಿರುವ ಹಾಗೂ ಹೈದರಾಬಾದ್ ಕರ್ನಾಟಕ ವೃಂದದ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿನ ಕ್ರಮ ಸಂಖ್ಯೆ 1ರಲ್ಲಿ ಆಯ್ಕೆಯಾಗಿರುವ ಅಭ್ಯರ್ಥಿಗಳ OMR ಪ್ರತಿಗಳನ್ನು ಹಾಗೂ ಲಿಖಿತ ಪರೀಕ್ಷೆಯ CCTV ವಿಡಿಯೋಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಸೂಕ್ತ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳುವ ಮೂಲಕ ಪ್ರಾಮಾಣಿಕ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ನ್ಯಾಯ ದೊರಕಿಸಿಕೊಡುವಲ್ಲಿ ಹಾಗೂ ಆಯೋಗದ ನೇಮಕಾತಿ ಪ್ರಕ್ರಿಯೆಯ ಪಾರದರ್ಶಕತೆಯನ್ನು ಮತ್ತಷ್ಟು ದೃಢಪಡಿಸಿ ಅಭ್ಯರ್ಥಿಗಳ ನಂಬಿಕೆಯನ್ನು ಬಲಪಡಿಸುವಲ್ಲಿ ಸೂಕ್ತ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳುತ್ತೀರಿ ಎನ್ನುವ ಅತೀವ ನಂಬಿಕೆ ಮತ್ತು ವಿಶ್ವಾಸದೊಂದಿಗೆ ಈ ಪತ್ರವನ್ನು ಮಾನ್ಯರಾದ ತಮ್ಮಲ್ಲಿ ನಿವೇದಿಸಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ.
ಈ ಪ್ರಕಾರ ಇದನ್ನ ಸೀರಿಯಸ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರಿ, ಯುನಾನಿಮಸ್ ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡಿ ಆಯ್ತಾ?
ಪ್ಲೀಸ್
OM ಅದನ್ನ ಅವರು CCTV ನೋಡ್ರಿ ಗೊತ್ತಾಗತ್ತೆ ಅಂತ. ಏನು CCTV ಅಲ್ಲಿ ಇದೆ?
ವಾಟ್ ಹ್ಯಾಪನ್ಸ್ ಇಸ್ ದಿಸ್,
ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ಬಿಡಿ.
CCTV ಕ್ಯಾಮ್ರಾ ಫುಟೇಜ್ ಅಲ್ಲಿ ಇಫ್ ಅಲ್ಲಿ ಕ್ಯಾಂಡಿಡೇಟ್ ಏನಾದ್ರು ಕುತ್ಕೊಂಡಿದ್ರೆ ಆ ಫುಟೇಜ್ ನಮ್ಮ ಹತ್ರ ಏನಾದ್ರು ಇದ್ರೆ ಅವರು ಎಷ್ಟು ಆನ್ಸರ್ಸ್ ನ ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ ಅವ್ರ ಬಾಡಿ ಲ್ಯಾಂಗ್ವೇಜ್ ನ ನಾವು ಗಮನಿಸಬಹುದು. ಆ ಬೇಸ್ ದೆನ್ ಅದನ್ನ ನಾವು OMR ಶೀಟ್, ಹಿಸ್ ಫೈನಲ್ OMR ಶೀಟ್ ವಿಚ್ on the basis of which Milord's evaluation is conducted if you compare, if the marks is more. And in fact, ಕೆಲವೊಂದು candidates ವಿಷಯದಲ್ಲಿ there is a finding that we were able to, in CCTV footage is clear, where I can, where we can see what he has actually, whether he has answered some questions. In respect of other candidates, there could be, it could not be a clear CCTV footage. But there is also a finding by the committee that a candidate has not answered as many questions where his footage is available to us. But that is again, my lords, a matter of once FIR is lodged, investigation where OMR. Now, my lords, this report says OMR tampering has happened. Kindly note, my lords, one thing: it is the commission itself which has decided to get into this. This is the first case where commission recommends that there has to be an FIR, there has to be a CID inquiry into this. The FIR has to, that investigation has to be handed over to CID. So, therefore, my lords, in so far as there is a conscious effort by the commission, my lords, to bring to book, my lords, if any
clean and
please
some action has
action. Because now, my lords, what had happened was, when I in fact pointed out on the last date of hearing, after the HOTA committee report came about, my lords, certain reforms were brought about, my lords, in the commission. Earlier, my lords, in 98 and 99, the of gazetted probationers recruitment, the main allegation was with regard to the interview marks. Written examination marks were published, and it is known to the candidate what is his written examination marks. So therefore, he knows how much he requires in the interview for the purpose of securing. So therefore, there could be some play that could happen where somebody would try to game the whole thing to approach something. So thereafter, my lords, it was interview marks were reduced. Now it has been reduced, my lords, to almost 50 marks. And in some cases, even I think the state government is contemplating removing interview marks in toto. But thereafter, but that is interview marks, my lords. Please.
ಇದು 25/9 ಬಂತು ಕಂಪ್ಲೇಂಟ್.
ಹೌದು ಸರ್.
ನೀವು 8/12/23
ಹೌದು
3.5 ತಿಂಗಳು.
ಎಸ್ what happened?
ಹಾ
3
ತಿಂಗಳು ಬೇಕಾಗ್ತದೆ ಇದನ್ನೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ.
ಇಲ್ಲ 3/10/23 ಗೆ
3/10/23
commission
ಏನಾಯ್ತು?
takes up this complaint
ಹಾ
in its additional agenda number 5 in the meeting.
3/10/23 ಅದು ಆ ಅಜೆಂಡಾದಲ್ಲಿ ಏನ್ ಡಿಸೈಡ್ ಆಯ್ತು?
Commission requests the secretary to re-examine the objections raised by Siddhareddy and submit a report for the same.
ಅಲ್ಲಿ ಸೆಕ್ರೆಟರಿನ
Secretary ಕೇಳಿ.
ಯಾರ್ಯಾರು ಫಂಕ್ಷನರೀಸ್? 15 ಜನ ಪ್ಲಸ್ ಒಬ್ರು, ಒಬ್ಬ ಚೇರ್ಮನ್
and members.
15 ಜನ ಮೆಂಬರ್ಸ್.
Please.
ಬೇರೆ ಮತ್ತೆ ಯಾರ್ಯಾರು ಫಂಕ್ಷನರೀಸ್ ಇದ್ದಾರೆ?
Milords, in the KP.
ಬ್ಯೂರೋಕ್ರಸಿಯಿಂದ ಯಾರ್ಯಾರು ಇದ್ದಾರೆ?
Please, Milords. Earlier, Milords, we had what is called as a secretary. Secretary, Milords, is an IAS officer, Milords, sent on deputation by the state government. He is appointed. He functions as a secretary of the commission. Milords, for all purpose of litigation, he is the officer, Milords, on the basis of which who will defend a litigation, and he signs all the correspondences, Milords. He is responsible for the purpose of carrying out the decisions of the commission also. Then, Milords, after Hota committee report came about, it was found that for the purpose of examination section, and all confidential work has to be segregated and a separate wing has to be created. For that, Milords, a recommendation was made that an office called the controller of examinations has to be created, similar to register.
ಸೆಕ್ರೆಟರಿ ಇರ್ಲಿ, ಒಬ್ಬ ಸೆಕ್ರೆಟರಿ ಇದ್ದಾರೆ, ಕಂಟ್ರೋಲರ್ ಆಫ್ ಎಕ್ಸಾಮಿನೇಷನ್.
Controller of examination is.
ಅವ್ರು ಯಾರು ಹೆಸರು ಕೊಡಿ
Please, Milords.
ಯಾರ್ಯಾರು ಅವರು?
The then secretary, Milords.
ಅಲ್ಲಿ ಇರೋರು 15 plus 1 members.
Milords, as on that day, we had only 10 plus 1 as on 8/12/2023.
10 plus 1.
Avattu 10 plus 1 ittu. When the when we accepted the report, Milords, it was 15 plus 1.
ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡುವಾಗ ಎಷ್ಟು ಜನ ಇದ್ರು?
ಅದು ತರಿಸ್ತಾ ಇದೀವಿ ಸರ್. 10 plus 1 ಅಂತ ಹೇಳ್ತಾ, but we have to see who was absent, Milords. ಅದವರು
ಅಲ್ಲ, ಸೆಕ್ರೆಟರಿ ಹೆಸರೇನು?
Secretary as on, Milords, as on that day.
Lata Kumari. She lodged a complaint on 12/1/24 before the governor. That letter, Lord, last occasion, Lord has directed them to fetch.
ಲತಾ IAS?
IAS.
ಸೆಕ್ರೆಟರಿ ಇರ್ತಾರೆ. ಆಮೇಲೆ ಮತ್ತೆ
Controller
of
examination who is also an IAS officer.
ಅವರು ಕಂಟ್ರೋಲರ್ ಆಫ್ ಎಕ್ಸಾಮಿನೇಷನ್.
And recommendation is direct IAS ಅಂತ ಹೇಳಿದ, so direct IAS is appointed, not a promoter.
ಅವ್ರ ಹೆಸರೇನು?
As on that day, I'll get the name. Now the present person who is there was not there. I'll get the name. I'm getting it. On the 5 minutes and please.
ಈ ಸದ್ಯ ಇರೋರ ಹೆಸರೇನು? ಇರುವಂತ ಸೆಕ್ರೆಟರಿ ಹೆಸರೇನು? ಈಗಿರುವಂತ ಕಂಟ್ರೋಲರ್ ಹೆಸರೇನು? ಅದಕ್ಕೆ ನೀವು ಮಗ್ಲಲ್ಲಿ ಕೂಡ್ಸ್ಕೋಬೇಕು ಅವ್ರನ್ನ. ಆಫೀಸರ್ ನೀವು ಮಗ್ಲಲ್ಲಿ ಕೂಡ್ಸ್ಕೋಬೇಕು. ಎಲ್ಲ ಡೀಟೇಲ್ ಬೇಕು ನಮ್ಗೆ. ಯಾಕಂದ್ರೆ ಇದ್ರಲ್ಲಿ ನಾವು ಏನ್ ಮಾಡ್ಬೇಕು, ಯಾವ ರೀತಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿಸ್ಬೇಕು, ಸ್ಟೇಟ್ ಪೊಲೀಸ್ ಇಂದ ಮಾಡಿಸ್ಬೇಕು, CBI ಇಂದ ಮಾಡಿಸ್ಬೇಕು, ಅಥವಾ NIA ಇಂದ ಮಾಡಿಸ್ಬೇಕು, ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಇನ್ನು. ಪ್ಲೀಸ್, ಯಾಕಂದ್ರೆ ನಿಮ್ಗೆ ಒಂದು ಖುಷಿ ವಿಷಯ ಅಂದ್ರೆ KPSC ಅವರೇ ಬಂದು ಬಹಳ ಹೊಲ್ಸಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದೀರಲ್ಲ, ಒಂದು ಅಪ್ರಿಷಿಯೇಬಲ್. ಅದೇನ್ ಮಾಡ್ಬೇಕು ಹಿಂಗೆಲ್ಲ ಆದಾಗ ಅಲ್ವಾ? ಮೊದ್ಲೆಲ್ಲ KPSC ಮೇಲೆನೆ ಅಲಿಗೇಷನ್ ಇರ್ತಿತ್ತು ಹೀಗೆ ಅಂತ. ಈ KPSC ಮೆಂಬರ್ಸೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಇಷ್ಟೆಲ್ಲ ಆಗ್ತಾ ಇದೆ, ಹಿಂಗಾಗ್ತಾ ಇದೆ ಅಂತ ಅಲ್ವಾ? ಈಗ ಪೇಜ್ 85 ಹೇಳಿದ್ರ ರೆಕಮೆಂಡೇಶನ್?
ಹೌದು, 88.
ಓದ್ರಿ, ಒಂದೊಂದೇ ರೆಕಮೆಂಡೇಶನ್ ಓದ್ಬಿಡಿ, ನಿಧಾನವಾಗಿ ಓದಿ.
The commission shall cancel the selection of tainted candidates as shown in para 66 of the report.
ಏನ್ ಹಂಗಂದ್ರೆ?
Lord sir, we have to take steps.
ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ಬಿಡಿ.
ಫೈನಲ್ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರನ್ನ
ಯಾರ್ಯಾರನ್ನ ನೀವು ಈಗಾಗಲೇ ಆಯ್ಕೆ ಮಾಡಿದ್ದೀರೋ,
ಪ್ಲೀಸ್,
ಆ ಆಯ್ಕೆ ಮಾಡಿದಂತ ಕಲುಷಿತಗೊಂಡ ಅಭ್ಯರ್ಥಿಗಳನ್ನ ತೆಗೆದು ಹಾಕಬೇಕು.
ಹೌದು,
ಕರೆಕ್ಟಾ?
66ರಲ್ಲಿ ಹೇಳಿರುವಂತ
ರದ್ದು ಮಾಡಬೇಕು. ಕ್ಯಾನ್ಸಲ್ ದ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಅಂತ,
ಪ್ಲೀಸ್.
ಕರೆಕ್ಟಾ?
ಇನ್ ಸೋ ಫಾರ್ as those candidates.
ಅವ್ರು ಎಷ್ಟು ಜನ?
10 out of 24.
ಎರಡನೇ ರೆಕಮೆಂಡೇಶನ್ ಏನು?
The commission shall authorize secretary to initial criminal action against the tainted candidates.
ಯಾಕೆ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ? ಕಮಿಷನ್ ಕನ್ನಡದಲ್ಲೆಲ್ಲ ಬರ್ಕೊಳೋದ್ ಬೇಡವಾ? ಮತ್ ನಾವು ಕನ್ನಡ ಪ್ರೀತ್ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ಏನು ಕನ್ನಡ ಪ್ರೀತ್ ಮಾಡ್ತೀವಿ? ನೀವೆಲ್ಲ ಇಂಗ್ಲಿಷ್ ನ ಬರ್ಕೊಂಡ್ರೆ ಲ್ಯಾಟಿನ್ ಬರ್ಕೊಂಬಿಡಿ, ಯಾರಿಗೂ ಗೊತ್ತಾಗ್ದಂಗೆ. ಕನ್ನಡದಲ್ಲಿ ಯಾಕಿಲ್ಲ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ? ನಿಮ್ಮ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಫ್ ಬಿಸಿನೆಸ್ ರೂಲ್ಸ್ ನಲ್ಲಿ ಯಾವ ಭಾಷೆಯಲ್ಲಿ ಇರ್ಬೇಕು ಅಂತಿದೆ?
No, our commission proceedings are recorded in Kannada.
ಕನ್ನಡ.
Kannada.
ಮತ್ತೆ
Commission,
ಇದು ಇಂಗ್ಲಿಷ್ ನಾಗ ಯಾಕೆ ಮಾಡಿರಿ?
this is a report, ma'am,
by the committee.
committee, my lords. It's a technical report sometimes, maybe.
ಅಂದ್ರೆ ಆದಷ್ಟು ಕಡಿಮೆ ಜನರಿಗೆ ತಿಳಿಲಿ ಅಂತ.
ಅಲ್ಲ ಸ್ವಲ್ಪ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ವರೆಗೂ ಹೋದ್ರೆ ಇದು ಅಕಸ್ಮಾತ್
ಅವಾಗ ಇಂಗ್ಲಿಷ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಕೊಡಕ್ ಬರಲ್ವಾ? ಇಂಗ್ಲಿಷ್ ಬರಲ್ವಾ ಕರ್ನಾಟಕದಲ್ಲಿ ಯಾರಿಗೂ? ಬಿಡಿ ಮತ್ತೆ ಏನಾರ ಒಂದು ಕಾರಣ ಹೇಳ್ಬಿಡಿ. ನಮ್ಮಲ್ಲಿ ಕನ್ನಡ ಬರುವಂಥವ್ರು ಇದ್ದಾರೆ, ಇಂಗ್ಲಿಷ್ ಬರುವಂಥವ್ರು ಇದ್ದಾರೆ, ಬೇಕಾದಷ್ಟು ಜ್ಞಾನಿಗಳಿದೆ. ಎನಿವೆ ಆದಷ್ಟು ಇಂಥವ್ರು ನಮ್ಮ ಕನ್ನಡ ಈಗ ಅದು ಒಂದು ಫೈನಲ್ ಆಸ್ಪೆಕ್ಟ್ ಅದು. ಪ್ಲೀಸ್ ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಡೌಟ್ ಮಾಡ್ತಾರೆ ಜನ, ಇಂಗ್ಲಿಷ್ ಅಂದಾಗನೇ ಡೌಟ್ ಮಾಡ್ತಾರೆ ಈಗ ಜನ. ಹಂಗಾರೆ ನಮ್ಗೆ ಇದು ಏನು ಗೊತ್ತಾಗ್ಬಾರ್ದು ಮಾಡಿರ್ಬೋದು ಅಂತ ಅದಕ್ಕೆ ಆಸ್ಪದ ಕೊಡಬಾರ್ದು. ಕನ್ನಡದಲ್ಲಿ ಮಾಡ್ಬೇಕು. ಎಷ್ಟು ಸುಂದರ ಭಾಷೆ ಅಂತ. ಎಸ್, ಎರಡನೇದು ಹೇಳಿ.
The commission shall authorize secretary to initiate criminal action against tainted candidates by lodging complaint.
ಏನದು?
My lords,
ಅವ್ರ ಮೇಲೆ ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
lodge ಮಾಡಿ
ಅವ್ರಿಗೆ ಅವ್ರ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಮೇಲೆ.
ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಮೇಲೆ.
ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಬೇರೆ ನಿಮ್ KPSC ನಲ್ಲಿ ಯಾರ ಆಫಿಷಿಯಲ್ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಇಲ್ದಂಗನೆ ಮಾಡ್ತಾರ ಇಷ್ಟೆಲ್ಲ?
ಇಲ್ಲ ಆಫಿಷಿಯಲ್ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ವಿಷಯದಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಎಲ್ಲಾಗಿದೆ ಟ್ಯಾಂಪರಿಂಗ್ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಾಗಿದೆ ಇನ್ ದ ಬೇಸ್ ಆಫ್ ದಿಸ್ ಈ ರಿಪೋರ್ಟ್ ಮೇಲೆ. ಎಲ್ಲಿ ಟ್ಯಾಂಪರಿಂಗ್ ಆಗಿದೆ, ಎಲ್ಲಿ ಟ್ಯಾಂಪರಿಂಗ್ ನಡೀತು ಅಂತ ಅದನ್ನ ಪತ್ತೆ ಹಚ್ಚಕ್ಕೆ CID ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಪಾಯಿಂಟ್ ನಂಬರ್ 3. ಈಗೇನ ಎಕ್ಸಾಮಿನೇಷನ್ ಕಮಿಷನ್ ಮೂರನೇದು ಕಮಿಷನ್ ಟು ರಿಕ್ವೆಸ್ಟ್ ಗವರ್ಮೆಂಟ್ ಟು ಆರ್ಡರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಥ್ರೂ CID ಟು ಅನ್ರಾವೆಲ್ ದ ಟ್ರೂತ್.
ಎರಡನೇ ಪ್ರಕಾರ ಕ್ರಿಮಿನಲ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕ್ರಿ ಅನ್ಕೊಂಡ್ ಹೇಳಿದ್ರಲ್ಲ, ಸೆಕ್ರೆಟರಿ ಹೇಳಿದ್ರಿ. ಹೌದಾ? ಹೌದು. ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ರಾ? ಇಲ್ಲ, ಹಾಕ್ಲಿಲ್ಲ. ಯಾರ ಮೇಲೂ ಹಾಕಿಲ್ಲ.
ಸೆಕ್ರೆಟರಿ ಗವರ್ಮೆಂಟ್ ಬರೀತಾರೆ, ರಿಪೋರ್ಟ್ ಫಾರ್ವರ್ಡ್ ಮಾಡ್ತಾರೆ. ಇದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಸ್ಟೆಪ್
ಕಮಿಷನ್ ಅಥರೈಸ್ ಮಾಡಿಬಿಟ್ರಿಲ್ಲ?
ನಾವು ಮಾಡಿದೀವಿ.
ಸೆಕ್ರೆಟರಿ ಕಂಪ್ಲೇಂಟ್ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳಿ.
ಹೌದು.
ನೀನು ಯಾಕೆ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿಲ್ಲ ಅಂತ ಕೇಳಿದ್ರ ಅವನ್ನ? ಕೇಳಿಲ್ಲ.
ಕೇಳಿದ್ವಿ.
ಓಕೆ, ಯಾವತ್ತು ಕೇಳಿದ್ರಿ?
ಐ ವಿಲ್ ಗೆಟ್ ದಟ್ ಇನ್ಫಾರ್ಮೇಶನ್. ನಾನು ಹೇಳಿ
ದಟ್ ಐ ನೀಡ್.
ಐ
ನೀಡ್ ದಟ್. ಮೂರನೇದಕ್ಕೆ ಬನ್ನಿ. ಈ ಕಂಪ್ಲೇಂಟ್ ಹಾಕೋದಲ್ದೆ ಬೇರೆ ಇನ್ನೊಂದು ರೆಕಮೆಂಡೇಶನ್ ಇದೆ, ಅದನ್ನ ನೋಡಿ.
ಟು ರಿಕ್ವೆಸ್ಟ್ ಗವರ್ಮೆಂಟ್ ಟು ಆರ್ಡರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಥ್ರೂ CID. ಗವರ್ಮೆಂಟ್ ನ CID ಥ್ರೂ ಇನ್ವೆಸ್ಟಿಗೇಷನ್, ಕ್ರಿಮಿನಲ್ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲ CID ಥ್ರೂ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಸಕ್ಕೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡೋದು.
ಏನಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ನವರು?
No, we have written to the government.
ಯಾವಾಗ?
2/2.
ಪೂರ ಹೇಳಿ, ಕನ್ನಡದಲ್ಲಿ ಪೂರ ಹೇಳಿ.
2
ಫೆಬ್ರವರಿ 2ನೇ ತಾರೀಕು
2025
ಇಸ್ವಿ. ಆಲ್ರೈಟ್. ನೀವು ಫೈನಲ್ ಲಿಸ್ಟ್ ಇದ್ರ ಮೇಲೆ ಕೊಟ್ಟಿದ್ನಲ್ಲ, ಅದು ಕಳಿಸಿದ ತಾರೀಕು ಯಾವುದು ಗವರ್ಮೆಂಟಿಗೆ?
ಗವರ್ಮೆಂಟ್ 31/1/24.
31/1/24. By that time already committee ಫಾರ್ಮ್ ಆಗಿಬಿಟ್ಟಿತ್ತು.
ಕಮಿಟಿ ಫಾರ್ಮ್ ಆಗ್ಬಿಟ್ಟಿತ್ತು.
Okay.
But concrete agi avaga at that point in time there was no concrete finding. This 3-member subcommittee proceedings madak ಆಗ್ತಿರ್ಲಿಲ್ಲ because there was some non-cooperation by
ನಿಮ್ಮ KPSC ಎಲ್ಲ ರೆಸಲ್ಯೂಷನ್ ಗಳು ಸರ್ಕಾರಕ್ಕೆ ಹೋಗ್ತಾವ? ನಿಮ್ಮ KPSC ಯಾವ ಆಕ್ಟ್ ಕೆಳಗೆ ಫಂಕ್ಷನ್ ಮಾಡ್ತದೆ? ಕಾನೂನು ನೀತಿ ಶಾಸನ ಇದೆಯಾ?
No, we have functions to act and rules.
Act ಬಿಡಿ. How it functions?
Acts and rules.
How transaction of business ಹೆಂಗಾಗತ್ತೆ KPSC ಅಲ್ಲಿ? ಬಿಸಿನೆಸ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ರೂಲ್ಸ್ ರೆಗ್ಯುಲೇಷನ್ಸ್ ಏನ್ರ ಇದೆಯಾ?
We have
ಅದರದೊಂದು
I'll just get it. Conduct of business manual and Additional Functions Act 1959.
ಆಕ್ಟ್ ಇದೆಯಾ?
Act is.
ಪಡಿ.
ಅಲ್ಲ
ತರ್ಸಿ. ಒಂದದ್ರದ್ದು ಒಂದು ಕಂಪನಿಯಲ್ಲಿ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಕೊಡಕ್ಕಾಗ್ತದ? ಆ ಆಕ್ಟ್ ಹೆಂಗಿದೆ, ರೂಲ್ಸ್ ಹೆಂಗಿದಾವು, ಯಾರ್ಯಾರು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮಾಡ್ತಾರೆ, KPSC ಪರವಾಗಿ ಡಿಸಿಷನ್ ಯಾರು ತಗೋತಾರೆ?
Shall I pass on this?
ಒಂದ್ ಸ್ವಲ್ಪ ಹಂಗೆ ಹೇಳಿ ಸಾಕು.
This act relates to procedure for performance of functions of the commission.
Correct.
Commission the functions ಹೇಗೆ ನಡೆಸಬೇಕು ಅಂತ this act.
Commission ಅಂದ್ರೆ ಯಾರು ಇವರೆಲ್ಲ ಮೆಂಬರ್ಸ್ ಎಲ್ಲ
Only the members of the commission.
Commission.
Only the members of the commission and the chairman is what is called the commission.
Commission.
The other staff, including the secretary, my lords, and commissioner, controller, are other officers. They are different officers. First, section 4, decision of questions. All questions arising for decision by the commission shall be decided either at a meeting of the members of the commission. Majority.
Next.
Then agenda for meeting shall be prepared by the secretary.
Okay.
Decision by majority of votes. Procedure during absence of chairman, the senior most person,
Will be the chairman.
Chairman.
Pro tem chairman.
vacancy not to invalidate proceedings. Then quorum shall, minimum is 4.
ಅದು 10 ಯಾವಾಗಿಂದ 15 ಆಯ್ತು ಇದು 16 ಆಯ್ತು. ಯಾವ ಇಯರ್ ನಿಂದ 16 ಆಯ್ತು?
No, my lords.
ಜೂನ್ 2024.
No, no. The,
ಜೂನ್ 24 ಮೊದ್ಲು ಎಷ್ಟಿತ್ತು?
ಇಲ್ಲ, ಇಲ್ಲ. My lords,
ಯಾವಾಗೂ 16 ಆಯ್ತು.
ಅಲ್ಲ, 10+1 my lords were the members.
Correct.
ಅಲ್ಲಿ vacancies ಇತ್ತು, then it became 15+1. 15+1, the other members got appointed.
How many members shall be there ಅನ್ಕೊಂಡು ಯಾವ ಆಕ್ಟ್ ನಲ್ಲಿ ಇದೆ?
My lords, it's the, in 320, my lords, article 3.
That is, does not say member, perhaps members may not say the number of persons. I'm not sure, but it may not say. Not content.
Please, my lords. Then, my lords, quorum, recording of decisions shall be recorded by the secretary in the manner as directed by the commission. Then communications to be signed by the secretary or assistant secretary. That is the other thing. Then, my lords, interviews, it talks about interviews and additional functions, conduct of service examination. This is, my lords, the Functions Act. Then we got the KPSC functions rules, where, my lords, how recruitments have to be done is provided for.
ಸೆಕೆಂಡ್ ಓದಿರಿ ಏನೋ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರು.
ಹೌದು.
ಅವರಿಗೆ ಸೆಕ್ರೆಟರಿ ಅವ ಹಾಕ್ಲಿಲ್ಲ. ಅವಾಗ ಕೇಳಿದ್ರ ಇದನ್ನ ನೀನು ಕಂಪ್ಲೇಂಟ್ ಹಾಕುವಂತ ರೆಸಲ್ಯೂಷನ್ ಇದೆಯಲ್ಲ ಮಾಡಿ ಏನಪ್ಪಾ ಇದನ್ನ ಯಾವತ್ ಕೇಳಿದ್ರಿ? ಯಾರು ಕೇಳಿದ್ರು?
Lords, in the next meeting,
ವಿಚ್ ಇಸ್ ದಟ್ ಡೇಟ್? ಬಡಿ.
Lords, I'll get the commission proceedings, lords. Information is in the, he is also signatory to the.
ಮೊದ್ಲೇ ಹೇಳಿದ್ವಿ ಎಲ್ಲಾ ಇನ್ಫಾರ್ಮೇಶನ್ ತಂದಿಡಬೇಕು. ಇಡೀ ರಾಜ್ಯದ ಜನ ಎಲ್ಲರೂ ದಿಗ್ಭ್ರಮೆಗೊಂಡಾರೆ. ಅಲ್ಲಿ ನಾವ್ ಹಿಂಗೆ ನಾಳೆ ಕೊಡ್ತೀವಿ ನಾಳೆ ಕೊಡ್ತೀವಿ.
I'll put. Lords, the information is this. In the next meeting of the commission, this.
ಇದು ಪಿರಿಯಾಡ್ ಎಷ್ಟು ಮೀಟಿಂಗ್ ಹೋಲ್ಡ್ ಮಾಡಬೇಕು ಅಂತದೆ ಕಾನೂನಲ್ಲಿ ಮಿನಿಮಮ್?
Please.
ಪಿರಿಯಾಡಿಕ್ ಮೀಟಿಂಗ್, ಪಿರಿಯಾಡಿಸಿಟಿ ಆಫ್ ದ ಮೀಟಿಂಗ್ ಏನಿದೆ ನಿಮ್ ಸ್ಕೀಮ್ ಆಫ್ ದಿ ಆಕ್ಟ್ ನಲ್ಲಿ?
Weekly ones.
In law. ಎಷ್ಟು ದಿವಸಕ್ಕೆ ಒಂದ್ಸರಿ ಮೀಟಿಂಗ್ ಆಗ್ಬೇಕು?
So manually weekly once.
Lords, they are holding a meeting weekly once.
ವೀಕ್ಲಿ ಒನ್ಸ್.
Please.
ನೆಕ್ಸ್ಟ್ ಮೀಟಿಂಗ್ ಅಂದ್ರೆ ಯಾವ ಡೇಟಿಗೆ? ಒಂದು ಇದನ್ನ ಸರ್ಕಾರಕ್ಕೆ ಕಳಿಸಿದ್ರಲ್ಲ, ವಿಚ್ ಲಾ ರಿಕ್ವೈರ್ಸ್ ಯು ಶುಡ್ ಸೆಂಡ್ ಇಟ್ ಟು ದಿ ಗವರ್ಮೆಂಟ್?
Lords, in fact,
ಲೀಗಲ್ ಫ್ರೇಮ್ವರ್ಕ್ ಹೇಳಿ.
legal framework, my lords, in so far as the constitutional setup is concerned, my lords, we did not send it to the state government for the purpose of, the secretary has, my lords, decided to send it to the DPR.
ಒನ್ ಸೆಕೆಂಡ್. ಈ ಟೈಮ್ ನಲ್ಲಿ ಯಾರು ಸೆಕ್ರೆಟರಿ ಇದ್ದವ್ರು ಕಂಪ್ಲೇಂಟ್ ಹಾಕ್ಬೇಕು ಅಂತ ನೀವು ರೆಸಲ್ಯೂಷನ್ ಮಾಡಿದ್ರಲ್ಲ,
Please,
ಅವಾಗ ಯಾರು ಹೆಸರು ಹೇಳಿ?
Ramandeep Chaudhary.
ರಮಣದೀಪ್ ಚೌಧರಿ.
Please.
Ramandeep Chaudhary. He was in the commission meeting. He was signature to the questions.
ಮೀಟಿಂಗ್ ನಲ್ಲಿ ಅವರು ಇರ್ತಾರಾ?
Irtar.
ಅವರು ಇರ್ತಾರೆ.
He signs, in fact, the proceedings are
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆರ್ ಡ್ರಾನ್ ಬೈ
him.
ಓಕೆ. ಯಾವ ಮೀಟಿಂಗ್ ನಲ್ಲಿ ಯು ಆಸ್ಕ್ಡ್ ಹಿಮ್ ವೈ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಲಾಜ್ಡ್ ಕಂಪ್ಲೇಂಟ್ ಅಂತ ಎಲ್ಲಿ ಕೇಳಿದ್ರಿ?
Lords, orally.
ಯುನಾನಿಮಸ್ ರೆಸಲ್ಯೂಷನ್ ಆಗಿದೆಯಾ?
ಹೌದು.
ಆ ರೆಸಲ್ಯೂಷನ್ ಪ್ರಕಾರ ವೈ ಆರ್ ಯು ನಾಟ್ ಒಬೇಯಿಂಗ್ ಅಸ್? Why you should, action should not be taken against you? Why you are not doing, implementing our resolution? We are a constitutional body. Why you are not implementing our resolution? Why complaint should not be lodged against you? ಅದೆಲ್ಲಿದೆ? ಯಾವತ್ ಕೇಳಿದ್ರಿ?
Lords, in the next meeting, lords, I'll just get the details.
ಡಿಸ್ಕಷನ್ ಆಗಿದೆಯಾ? ಈ ಸೆಕ್ರೆಟರಿ ನಮ್ಮ ರೆಸಲ್ಯೂಷನ್ ಅನ್ನು ಒಬೇ ಮಾಡ್ತಾ ಇಲ್ಲ ಅನ್ನೋ ಬಗ್ಗೆ ರೆಸಲ್ಯೂಷನ್ ಡಿಸ್ಕಷನ್ ಕಮಿಷನ್ ದಲ್ಲಿ ಆಗಿದೆಯಾ?
It has happened.
It has happened.
It has happened.
ಏನಂತಾಗಿದೆ? ಯಾವತ್ತಾಗಿದೆ?
No, that's the next meeting itself, lords. We'll get.
ಹಂಗೆ ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು ನಿಮ್ಮ ತಗೊಂಡು? ನಮಗೆಲ್ಲದನ್ನು ಕೊಡಿ. ಯಾವ ಡೇಟಿಗೆ ಏನಾಯ್ತು, ಏನ್ ಬೇಕಲ್ಲ ನಮಗೆಲ್ಲ, ನೀವೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ಮೀಟಿಂಗ್ ಆಗಿದೆ, ಅದು ಅಲ್ಲಿದೆ, ಇದಿಲ್ಲ, ಅದೆಲ್ಲ ನಮ್ಗೆ ನಡೆಯಲ್ಲ. ಯಾಕಂದ್ರೆ ನಾವು ಸೀರಿಯಸ್ಲಿ ಥಿಂಕ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ, ಇದರಲ್ಲಿ ಏನಾಗಬೇಕು, ಬಹಳ ಸೀರಿಯಸ್ಲಿ ಥಿಂಕ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಯಾಕೆ ವೈ ಹಿ ಡಿಡ್ ನಾಟ್ ಒಬೇ ದಿ ರೆಸಲ್ಯೂಷನ್ ಆಫ್ ದಿ ಕಮಿಷನ್? ಯಾಕೆ ಒಬೇ ಮಾಡಲಿಲ್ಲ ಅವನು? ನೀವೇನ್ ಮಾಡಿದ್ರಿ? 15 ಜನ 16 ಜನ. ಸಿಂಪಲ್ ವಿ ಆರ್ ಆಸ್ಕಿಂಗ್ ಯು. 16 ಜನರ ಕಮಿಟಿ, ಯುನಾನಿಮಸ್ ರೆಸಲ್ಯೂಷನ್. ಹಿ ಡಸ್ ನಾಟ್ ಒಬೇ ಯು. ವೈ? ಯಾಕೆ ಕೂಡಿ ಹಾಕ್ಲಿಲ್ಲ ಒಂದು ರೂಮ್ ನಲ್ಲಿ ಆ ಮನುಷ್ಯನ? ವೈ ಆರ್ ಯು ನಾಟ್ ಒಬೇಯಿಂಗ್ ದಿಸ್? ಒಬೇ ಇಟ್ ಫಸ್ಟ್, ದೆನ್ ವಿಲ್ ಓಪನ್ ದ ಡೋರ್ ಅಂತ ಯಾಕೆ ಒಳಗೆ ಹಾಕ್ಲಿಲ್ಲ?
So he chose to write to the state government.
State government, you chose.
What authority?
You are a constitutional body.
Please. No, my lords, he is also the secretary of the commission.
What happened? Secretary, he is secretary. He is secretary.
Please.
He is not Maharaja of Mysore.
Please.
If he does not obey,
Please.
what you will do? Secretary does not obey. And he wants you to obey his orders.
Please.
Then how constitution will function? Institutional integrity, grandeur ಏನಾಗ್ತದೆ ಮುಂದೆ?
Please, my lords, the only option, my lords, the commission will have is to write to the state government that this is what has happened. Please take action against the secretary. And then,
ಬರ್ದಿರಾ?
please, my lords.
ಬರ್ದಿದ್ದೀರಾ?
My lords, that was done, my lords, in respect of the earlier secretary. About this secretary, I'll just verify.
ನೀವು ಯಾವ ಸೆಕ್ರೆಟರಿ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಕಳ್ಸೋ ವಿಷಯದಲ್ಲಿ ಇಶ್ಯೂ ಬಂತಲ್ಲ, ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದ ಅರ್ಲಿಯರ್ ಸೆಕ್ರೆಟರಿ ಲತಾ ಕುಮಾರಿ.
ಲತಾ ಕುಮಾರಿ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಳ್ರಿ ಅಂತ ಬರ್ದ್ರಿ.
ದ ಕಮಿಷನ್
ಅವ್ರು ಯಾವ ಪೀರಿಯಡ್ ನಿಂದ ಯಾವ ಪೀರಿಯಡ್ ವರೆಗೆ ಇದ್ರು? ಎಲ್ಲಿವರೆಗೆ ಇದ್ರು ಅವ್ರು? ಬೇಕಲ್ಲ ಮತ್ ನಮ್ದು.
I think it's better they come back with all the information.
ಅದೇ ಮತ್ ಕಮ್ ಬ್ಯಾಕ್ ಮತ್ ಮುಂದೆ ಹೋಗ್ತದೆ.
ಅಲ್ಲ ನಾಳೆ
ಜನ ತಮಾಷೆ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ
ಅಲ್ಲ ನಾಳೆನೆ
ಬೇರೆ ಏನಿಲ್ಲ.
ಅಲ್ಲ ನಾಳೆನೆ
ಮೊದ್ಲೇ ನಮ್ಮ ಮೇಲೂ ಸಹಿತ ಈಗ ಕೋರ್ಟ್ ಮೇಲೂ ಸಹಿತ ನಂಬಿಕೆ ಕಡಿಮೆ ಆಗ್ತಾ
ಇಲ್ಲ ನಾಳೆನೆ let them
ನಾವ್ ಏನು ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಅಂದ್ರೆ ನಮ್ ಕೈಲೇ ಆಗ್ಲೇದಂತ ನ್ಯಾಯಾಧೀಶರು ಇದ್ದಾರೆ ನಮ್ಮಲ್ಲಿ ಫೀಲಿಂಗ್ ಇದೆ.
will come back
ಅದಕ್ಕೆ ಒಪ್ಪಲ್ಲ ನಾವು.
tomorrow itself. I think with the files.
Some more questions.
No, not that. Just trying to postpone it. I just thought.
ಸರ್ಕಾರದಿಂದನೂ ಅನೇಕ ಪ್ರಶ್ನೆಗಳಿಗೆ ಉತ್ತರ ಕೊಡಬೇಕಾಗ್ತದೆ. ನಂತರ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಅನ್ನು ಕಳಿಸಿದವ್ರು ಯಾರು?
ದ ಸೆಕ್ರೆಟರಿ.
ಅವ್ರಿಗೆ ನೀವು ಹೇಳಿದ್ರ ಹಿಂಗೆಲ್ಲ ಕಮಿಷನ್ ನಡೆದಿದೆ, ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಕಳಿಸಬಾರ್ದು, ಎನ್ಕ್ವೈರಿ ಆಗ್ತಾ ಇದೆ ಅಂತ ಹೇಳಿದ್ರ?
The very committee chairman not find the final list.
On the day, my lords, the select list was approved by the commission. There was a dispute regarding the commission meeting itself because the chairman was absent. So immediately, my lords, chairman says it's an illegal meeting of the commission that was held in my absence. And thereafter the list was sent, though there was no quorum.
ಯಾರು ಕಳಿಸಿದ್ರು ಲಿಸ್ಟ್ ಅನ್ನ?
ಲತಾ ಕುಮಾರ್.
So immediately next day, he writes to the chief secretary stating that this is what the secretary has done. Without authorization, the list has been sent to us. And list is published on the same day and sent to the government on the same day.
ಗವರ್ಮೆಂಟ್ ನಲ್ಲಿ ಏನಾಯ್ತು? ಅದು ಗವರ್ಮೆಂಟ್ ಗೊತ್ತಿತ್ತ ಈ ರೆಸಲ್ಯೂಷನ್ ಕಳಿಸಿದ್ರಲ್ಲ ನೀವು, ಅದು ಬಹಳ ಲೇಟ್ ಆಗಿ ಕಳಿಸಿದ್ದ, ಆಮೇಲೆ ಕಳಿಸಿದ್ರು.
ಇಲ್ಲ ಕಳಿಸಿ
ಅಲ್ಲ, ರೆಸಲ್ಯೂಷನ್ ಅಪಾಯಿಂಟ್ ದ ಯುನಾನಿಮಸ್ ರೆಸಲ್ಯೂಷನ್ ಅಪಾಯಿಂಟಿಂಗ್ ದ 3-member committee
please
to investigate into these things,
please,
and one of the members is retired district judge, correct?
Correct.
Principal district judge.
One is an advocate, one is a doctor, one is a retired
district judge. ಇವರೆಲ್ಲ ಯುನಾನಿಮಸ್ ರೆಸಲ್ಯೂಷನ್ ಆಮೇಲೆ 5 ಜನರ ಕಮಿಟಿ ಆಗ್ತದೆ.
ಪ್ಲೀಸ್
ಅವ್ರಿಬ್ರು ಯಾರು?
ಇನ್ 5-member ಕಮಿಟಿಯಲ್ಲಿ ಅರ್ಲಿಯರ್ ಕಮಿಟಿ ರೀಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗುತ್ತೆ. ನಾಟ್ ದ I'll just give the names. The 5-member committee is consisting of Vijay Kumar, R. Girish, M.B. Heggannavar, Geeta Bibi, Mustafa Hussain. So ಅದರಲ್ಲಿ Geeta Bibi ಮತ್ತೆ Mustafa Hussain, they are the same. The Shanta Osmani was the chairperson, gets replaced, and 3 other members are inducted. And Milords Vijay Kumar is becomes the chair. So Mustafa Milords continues the district judgment.
You said Srimati Lata Kumari is not obeying the order ಅಂತ ಹೇಳಿದ್ರಾ?
No, the report ಅಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟಿದೀವಿ. In the report also they say, I'll just read those paragraphs. So I'll just point out.
ಆಯ್ತು, 3 ಆಯ್ತು ಈಗ. Commission requested government to order investigation through CID.
Also
government ಏನ್ ಮಾಡ್ತು?
No, Milords, The FIR is not at large, my lords. FIR.
Government, FIR ಬೇರೆ, CID.
Oh, the FIR
investigation
the file is with the DPR.
with the DPR.
DPR authorized.
So it will be there only in DPR.
No, that's what I said on the last date of hearing. If my lords recollect, I said further action ತಗೋಬಹುದು ಅಂತ ತಾವು.
Why you did not do ಅಂತ?
Please.
Why it went to which? You are a constitutional.
We can directly, we could have registered an FIR straight
Why
away.
you did not?
Lords, the commission members cannot go and register an FIR. It's the secretary who has to do the, has to register an FIR.
Correct.
Please.
Ali. Anyway, anybody can set the criminal law in motion.
Please.
This is the judgment which you quoted 6 months ago, 7 months ago.
Please.
84 Supreme Court.
But in an institutional scheme, in a personal capacity, my lords, anybody can set. But in an institutional scheme, my lords, he has to function under the scheme itself, how the institution functions. Because a direction has been issued to the secretary to lodge an FIR.
The secretary does not obey you at all.
That's,
Well, we're asking you.
that
Secretary does not obey you.
the facts speak for themselves. So I'll just put it that.
And you don't want to take action against her,
No, my lords, we have written to the chief secretary
Chief Secretary,
to take action against.
to take action.
And she has written in turn against the members. That is what they wanted to rely upon.
Okay. ಅವ್ರ ಮೇಲೆ ಏನ್ ಆಕ್ಷನ್ ಇದೆ ರಿಪೋರ್ಟ್ ನಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್ ಬನ್ನಿ.
My lords, the next point.
Secretary to assist the police for CID investigation for taking appropriate action against tainted candidates and all those persons who are responsible for the malpractice. ಈ malpractice candidates ಇಷ್ಟೇ ಜನರಿಂದ ಆಗಿದೆಯೋ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ನಿಮ್ಮ ಅಲಿಗೇಷನ್ ಮೇಲೆ ಇವ್ರು ಮಾತಾಡೋದು. They may not be there, maybe all clean fellows also. We don't. Anyway, 5 ಜನರ ಕಮಿಟಿ ಯುನಾನಿಮಸ್ಲಿ ಹಿಂಗ್ ಹೋಲ್ಡ್ ಮಾಡಿದೆ.
ಹೌದು.
ಅಲ್ವಾ? ನಿಮ್ಮ KPSC ಒಳಗಡೆನೆ ಇರುವಂತ ಅಫಿಷಿಯಲ್ಸ್ ಯಾರಾದ್ರೂ ಇನ್ವಾಲ್ವ್ ಆದ ಬಗ್ಗೆ ಇದೆಯಾ ರಿಪೋರ್ಟ್ ನಲ್ಲಿ?
The report al bandila because they cannot, where tampering happened of the OMR sheets, my lords, they are not able to find out. Tampering could have happened at the examination centers during the transit or in the controller establishment. Tampering agide. Ella agide adake investigation beku. FSL report says I have custody, my lords, of the OMR sheets, original OMR, which I placed before my lords. We have called
custody of documents officially.
Controller of examination.
Controller of examination.
And even my lords.
ಯಾರವರು ಹೆಸರೇನು? Controller of examination ಹೆಸರೇನು?
Jnanendra.
Jnanendra.
No, my lords, there is also one.
Also IAS?
He is also IAS. There is one other aspect I want to bring to the notice, my lords. When the Office of Controller of Examination was created, he was made the custodian of all confidential process, and any confidential process information should be shared with the secretary and the chairman only on need to know basis anta madbitru. So therefore I made a submission on the last date of hearing. Literally, my lords, insofar as the functioning is concerned, adonthara island tara agobidide. Insofar as they function because even controller establishment kelagade any information, confidential information is there, even sharing it with the secretary and the chairman itself is on need to know basis. No other member comes to know. Here, why I wanted to put it out this way is this, my lords. We have, let us say, a controller of examination establishment of the KPSC, a secretariat of that is the secretary establishment, and I have the members here. But alleno, if suppose at official level something is happening, it looks, my lords, I know, my lords, we have to live with our history. We have to, the Public Service Commission has to live with our history, litigative history, as well as what has happened in the related. But fingers are pointed out to the members of the commission, because commission means for everybody it consists of the members of the commission. But here the way it is, the way, my lords, the entire way it is set up now, the system is set up, and the members will not, in fact, there was one, I want to bring to the notice of the court one incident where, my lords, in respect of gazetted provisions 2015 recruitment, the secretary was directed to, the commission was directed to file an affidavit as to how information was received from a third party vendor regarding some marks. Controller was the custodian of the information. Controller said, I will not give the marks. Secretary had to come before this court and make a submission, please make controller a party. Controller was made a party. Then from that time, my lords, controller started giving the information. So
controller controls you. Better that at least instead of FDC controlling all members.
Correct.
Some IAS officer is controlling. Then I come to 5(1).
Please, lords. Recommend to the government to issue shall recommend the government to issue posting orders in favor of non-tainted candidates.
But by that time, my lords,
ಯಾರ ಮೇಲೆ ಟೆಂಟಿಂಗ್ ಇಲ್ಲ, ಯಾರ
there are 14 jana, 20 out of 24 my lords, 10 people were found to be indulging malpractice. The remaining 14 persons you can, but in fact, this recommendation by that time appointment orders are already issued.
they were issued.
But issued 1 year back, I think 6 months back it got issued.
Posting orders, not appointment orders, posting orders.
Posting.
Yeah?
It's posting orders.
Posting orders.
Posting appointment.
Please,
Posting is after appointment.
After
order.
appointment.
After appointment. So therefore, they acknowledge the fact that posting appointment orders have been issued. Here, my lord, they were only in training, my lord. So therefore, probably that is why they used the word
I think so, I think so.
posting orders.
Why government, government, they had sent that resolution to you.
They're not.
ಜನರದ ಕಮಿಟಿ,
ಇಲ್ಲ, ಇಲ್ಲ,
3 ಜನರ ಕಮಿಟಿ ರೆಸಲ್ಯೂಷನ್ ಏನು ಕಳಿಸಿಲ್ಲ.
ಕಳ್ಸಿಲ್ಲ.
ಗವರ್ಮೆಂಟ್ ಕಳಿಸಿಲ್ವಾ?
ಕಳ್ಸಿಲ್ಲ.
We have sent on 2/2/25, my lord.
ಅದು
Earlier it,
ರೆಕಮೆಂಡೇಶನ್
ಹೌದು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಮುಂಚೆ letter
ರೆಸಲ್ಯೂಷನ್ ನಿಮ್ದು ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಆಗತ್ತಲ್ಲ, ಅದನ್ನ ಯಾರಿಗೆ ಕಳಿಸ್ಬೇಕು ಏನು ಇವೆಲ್ಲ ಏನ್ ಪ್ರೊಸೀಜರ್ಸ್ ಏನಿಲ್ಲ.
We my lords,
ಗವರ್ಮೆಂಟ್ ಕಳಿಸಿದ್ರ ರೆಸಲ್ಯೂಷನ್?
resolutions my lords, as a matter of
ವಾಂಟ್ ಟು ನೋ
Please.
ನಿಮ್ಮ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಹೆಂಗಿರುತ್ತೆ, ನಿಮ್ ಟಪಾಲ್ ಹೆಂಗಿರುತ್ತೆ, ಯಾವ ರೀತಿ ಮೂವ್ಮೆಂಟ್ ಆಗ್ತದೆ,
please.
ನಿಮ್ ಟಪಾಲ್ ರಿಜಿಸ್ಟರ್ ಹೆಂಗಿದೆ, ವೆದರ್ ಇಟ್ ವಾಸ್ ಸೆಂಟ್ ಆರ್ ವೆಬ್ ಹೋಸ್ಟೆಡ್.
No, no, we have a topal register. We'll have a manual register my lords now. Wait.
ಕೇಳಿ ನಿಮ್ಮ ಅವ್ರನ್ನ, ನಿಮ್ಮ ಅವ್ರು ಕಳಿಸಿದ್ದು ಗವರ್ಮೆಂಟ್ ಗೆ ಒಂದು ಕಾಪಿ ಆಫ್ ದಿ ರೆಸಲ್ಯೂಷನ್ ಕಳಿಸಿದ್ದು ಗವರ್ಮೆಂಟ್ ಗೆ ಸೆಕ್ರೆಟರಿ
Admittedly,
ಡಿಪಾರ್ಟ್ಮೆಂಟ್.
resolution is not sent, my lord.
Sir.
ಕಳ್ಸಲ್ಲ.
resolution ಹೋಗೋದಿಲ್ಲ ಸ್ವಾಮಿ.
Lords, as a matter of course, my lords, not about this resolution. Any resolution of the commission, my lords, will not
Be sent to the
be sent to the government. It thereafter report will be made, and I think it will be placed before the house through the government. Regarding the functioning of the commission. That is how, my lords, the scheme works.
How government, then how government issued appointment order saying that subject to outcome of et cetera.
Because we wrote to them, my lords.
On-
Not
Therefore, government was in the know of the things.
it was.
Government knew it because you issued the appointment order.
And condition number 8, what?
Therefore, you should not have incorporated the condition. ಆ ಕಂಡೀಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಇದು ಗೊತ್ತಿರ್ಬೇಕಲ್ಲ.
No,
ಹಾಗಾದ್ರೆ
that,
ನಿಮ್ಗೆ ಗೊತ್ತಿತ್ತು ಅಂತ ಆಯ್ತು.
no. Fact that there's a letter dated 22nd February saying that there's something wrong, there's a fact. But none of these, the 3-member committee, 5-member committee has been constituted.
ಸರ್ಕಾರಕ್ಕೆ ಏನು ಗೊತ್ತಿಲ್ಲ.
They have not communicated to us, my lord. And
ಅವ್ರು ಬಿಡಿ, ಅವ್ರು ಕಳ್ಸಿಲ್ಲ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಬಟ್ ನಿಮಗ್ ಗೊತ್ತಿಲ್ವಾ?
no, my lord, what has happened is here, my lord, there are 20, the post is for assistant executive engineer, 24 posts, my lord. At the same time, my lord, what were being filled up for the post of AE.
ಸಿಂಪಲ್ ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ ಇದ್ದೀವಿ ಮಿಸ್ಟರ್ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್. ನೀವು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡುವಾಗ ಇಂಪ್ಯೂನ್ಡ್ ಕಂಡೀಷನ್ ಇದೆ.
Condition number 8, we knew something, inquiry was there, but not.
ಕೇಳೋದ್ ಬೇಡವಾ? ನೀವು ಈ ರೀತಿ ಹೇಳಿದಿರಿ, ಏನಂತ ಹೇಳಿದ್ರಲ್ಲ ನಿಮ್ ಕಳಿಸುವಾಗ ಕಮಿಟಿ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಯಾವ ರೀತಿ ಹೆಂಗ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರಿ, ಇವ್ರ ಹಿಂಗಾಗಿದೆ ಅನ್ಕೊಂಡು ಆ ಕಂಡೀಷನ್ ಹಾಕುವ ಅಗತ್ಯ ಬೀಳಿಕ್ಕೆ?
So
How you interacted with the government?
Just one letter had come, my lord.
Page 105
105.
and page 126.
Page 102. A9.
What is this was sent to the chief secretary.
Please, my lords, by the chair,
1/2/2024.
please, my lords. And
ಏನಂತ ಅದರಲ್ಲಿ ಏನಂತ
ಅಲ್ಲ,
ಇದೆ?
page 109 ಅಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ.
ಹಾ.
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ. ಗ್ರಾಮೀಣ ಕುಡಿಯುವ ನೀರು ಮತ್ತು ನಿರ್ಮಲ ಇಲಾಖೆಯಲ್ಲಿ
ಗ್ರಾಮೀಣ ಕುಡಿಯುವ ನೀರು ಮತ್ತು ನೈರ್ಮಲ್ಯ ಇಲಾಖೆಯಲ್ಲಿ
ಅಲ್ಲಿ ಮೈಕ್ ಹತ್ತಿ ಬರ್ರಿ, ಎಲ್ಲರೂ ಕೇಳಿ, ಅಷ್ಟು ಕೇಳಿಸ್ಕೊಳ್ಳಿ, ಜೋರಾಗಿ ಓದಿ, ಇಲ್ಲ ನಾವೇ ಓದಿ ಬಿಡ್ತೇವೆ ನಿಮ್ಗಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ. ದಪ್ಪದನೆಯಲ್ಲಿ ಓದ್ರಿ, ಏನ್ ಖುಷಿಯಿಂದ ಓದೋದಲ್ಲ.
ಗ್ರಾಮೀಣ ಕುಡಿಯುವ ನೀರು ಮತ್ತು ನೈರ್ಮಲ್ಯ ಇಲಾಖೆಯಲ್ಲಿನ ನೇಮಕಾತಿಯಲ್ಲಿ ಅಭ್ಯರ್ಥಿಗಳು ಅಕ್ರಮ ನಡೆದಿರುವ ಬಗ್ಗೆ ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿದ್ದು, ಸದರಿ ವಿಷಯವನ್ನು ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸಿ ವಿಚಾರಣಾ ಉಪಸಮಿತಿಯನ್ನು ರಚನೆ ಮಾಡಿ 3 ಜನ ಮಾನ್ಯ ಸದಸ್ಯರನ್ನೊಳಗೊಂಡ ಉಪಸಮಿತಿಯನ್ನು ರಚನೆ ಮಾಡಿ ಒಬ್ಬರು ಸದಸ್ಯರಾದ ಡಾಕ್ಟರ್ ಶಾಂತಾ ಹೊಸಮನಿ ಅವರ ಸಮಿತಿ ಅಧ್ಯಕ್ಷರನ್ನಾಗಿ ಮಾಡಿದ್ದು, ಸದರಿ ವಿಚಾರಣೆಯು ಆರಂಭಿಕ ಹಂತದಲ್ಲಿದೆ. ದಿನಾಂಕ 31/1/2024 ನಡೆದ ಅನಧಿಕೃತ ಕಾನೂನು ಬಾಹಿರ ಸಭೆಯಲ್ಲಿ ಅಜೆಂಡಾದಲ್ಲಿ ಇಲ್ಲದಿರುವ ವಿಷಯವಾದರೂ ಸೋ ಉಪಸಮಿತಿಯ ಸದಸ್ಯರೊಂದಿಗೆ ಚರ್ಚಿಸದೆ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಗೆ ಅನುಮೋದನೆ ನೀಡಿರುವುದು ಅಕ್ರಮವಾಗಿದ್ದು, ವಿಚಾರಣಾ ಹಂತದಲ್ಲಿರುವುದನ್ನು ಏಕಾಏಕಿ ಅನುಮೋದನೆ ಮಾಡಿರುವುದು ಅಕ್ರಮವಾಗಿರುವುದು ಮತ್ತು ಕಾನೂನು ಬಾಹಿರವಾಗಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡುಬರುತ್ತಿದ್ದು, ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿದ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಅನ್ಯಾಯವಾಗುವ ಸಾಧ್ಯತೆಗಳಿವೆ.
Once, Mr. Advocate General,
Please,
this was sent to the Chief Secretary.
please, my lord.
You can't say that government did not know all these things.
My lord,
Chief
what,
Secretary is informed.
please, my
ಈ
lord.
ರೀತಿ ಅಕ್ರಮಗಳಾಗಿದೆ, ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸುತ್ತಿದ್ದೇವೆ.
Please, my lord.
ಮೂರು
What-
ಜನರ ಉಪ ಸಮಿತಿಯನ್ನು, ಹಾಗಾಗಿ ಗವರ್ಮೆಂಟ್ ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ಹಂಗೆ ಹೇಳ್ಬೇಡಿ ನಮ್ಗೆ.
ಹಂಗಲ್ಲ, my lord. ನಾನು ಏನ್ ಹೇಳ್ತಿದ್ದೀನಿ ಅಂತಂದ್ರೆ, the appointment order is issued by the respondent.
This is January 2024.
No, no, correct, my lord.
February 24.
The appointing authority in this is, my lord, Rural Development and Panchayat Raj, my lord. This letter is written to the Chief Secretary, my lord. The
ಹೌದು.
chief, the communication has not come to the appointing authority, that is the RDPR, my lord.
No, Chief Secretary, under your transaction of
Correct,
business,
I'm not on that.
Chief Secretary happens to be the secretary of all departments in the
No,
government.
no, that's true, my lord. Under
ಹಂಗಾಗಿ
transaction-
ಅದು ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ, ಇವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಹಂಗ ಹೇಳಿದ್ರೆ ಹೆಂಗೆ? ಇದು ಇಷ್ಟೆಲ್ಲ ಆಗಿದೆ, ಇಷ್ಟೆಲ್ಲ ಹೊಲಸಾಗಿದೆ, ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ
ಅಲ್ಲ,
ಹೆಂಗೆ?
no, going by
Yeah.
condition number 8, my lord, that goes to show that we had knowledge about it, my lord. In fact, wherever we go back, my lord, the appointing authority has taken note of this aspect and put condition number 8, even though.
ವೈ ಕಂಡೀಷನ್ ನಂಬರ್ ಹಿಂಗೆಲ್ಲ ಆದಾಗ ಎನ್ಕ್ವೈರಿ ಆಗ್ತಾ ಇದೆಯಪ್ಪ, ಸ್ವಲ್ಪ ಇರೀರಿ, ಬೇಗ ನೀವು ಎನ್ಕ್ವೈರಿ ಮುಗಿಸಿ ಒಳ್ಳೆಯವ್ರು ಇದ್ದವ್ರಿಗೆ ಅಪಾಯಿಂಟ್ ಮಾಡೋಣ, ಕೆಟ್ಟಿರೋರ್ನ ಹೊರಗೆ ಹಾಕೋಣ ಅಂತ ಹೇಳಿಕ್ ಬರ್ತಿತ್ತು ಒಂದು ಲೆಟರ್ ನಲ್ಲಿ. ಇದೆಲ್ಲ ಹೆಂಗಾಗ್ತದೆ?
My lord, ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, there was an acute shortage of assistant executive engineer.
ಸೆಲೆಕ್ಷನ್ ಮಾಡೇಬಿಡಿ, ಡೈರೆಕ್ಟ್ ಎಲ್ಲ ಅಲ್ಲಿ ಮಾರ್ಕೆಟ್ನಾಗ ಇರೋರು ಕರ್ಕೊಂಡ್ಬಂದು ಕೂಡಿಸಿಬಿಡಿ. ಅಕ್ಯೂಟ್ ಶಾರ್ಟೇಜ್ ಇದೆ, ಫಂಕ್ಷನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಹಂಗಾಗಿ ಎಲ್ಲರನ್ನು ಆಯಾ ಪೋಸ್ಟ್ ನಲ್ಲಿ ತಂದು ಕೂಡಿಸ್ಬಿಡ್ರಿ. ನಮ್ಗೊಂದು ಸೆಲೆಕ್ಷನ್ ಪ್ರೊಸೆಸ್ ಇದೆ, ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಮ್ಯಾಂಡೇಟ್ ಅದು. ಸೆಲೆಕ್ಷನ್ ಹೆಂಗ್ ಮಾಡ್ಬೇಕು, ಯಾರು ಮಾಡ್ಬೇಕು, ಇಟ್ಸ್ ಎ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಬಾಡಿ. ಹಂಗಂದ್ರೆ ಬೇಡ ಯಾರು ಬೇಕಾಗಿಲ್ಲ. ವೈ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಡಿಡ್ ನಾಟ್ ಟೆಲ್ ಇಟ್ ಟು ದಿ ಕನ್ಸರ್ನ್ powers that be.
Let's just,
Whichever, we do not.
I don't want to say that they have not told, I'll get the correct information and tell, my lord, what was pursuant to.
They should have taken. ಈ ರೀತಿ ಬರ್ದಿರಪ್ಪ. The chief secretary is a very prominent bureaucrat, very prominent official, first of the officials in the state.
Correct.
ಅವ್ರು ಕೇಳಿ ಹಿಂಗಾಗ್ತಾ ಇದೆ, ನೀವು ಈ ರೀತಿ ಲೆಟರ್ ಬರ್ದಿರಿ, ನಿಮ್ಮ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಯಾವಾಗ ಮುಗೀತದೆ, ರಿಪೋರ್ಟ್ ಯಾವಾಗ ಕಳಿಸ್ತೀರಾ, ಮತ್ತು ಅದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗೋಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲಿ ನಾವು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕೋ ಬೇಡೋ?
Because in fact, they have not.
ಎಲ್ಲಿದೆ ಅದು? ಅಕ್ಯೂಟ್ ಶಾರ್ಟೇಜ್ ಇದೆ, ಹಂಗಾಗಿ ಇವೆಲ್ಲ ಇದ್ರೂ ಸಹಿತ ನಾವು ಅಪಾಯಿಂಟ್ ಮಾಡಬೇಕು ಅನ್ನೋ ಬಗ್ಗೆ ವೆರಿ ಸಮ್ ನೋಟ್ ಶೀಟ್?
There's
No note sheet. There are only arguments.
No. What I sought for information, why it was done, Taveldange, 1st of February 2024, the.
2024.
2024, June 2024 appointment issue ಮಾಡಿದೆ. That is, the gap is around 4 months during that period of time. ಅವಾಗ ಮಾಡಿದ್ ಯಾಕೆ ಏನಾಯ್ತು ಅಂತ ತಾವು ಕೇಳ್ದಂಗೆ, they say that.
What's the chief secretary needs to ask? He is the chief executive of the government, actually. In Shankara Narayanan case, what the apex court said.
ಏನಾಗಿತ್ತು ಅಂತಂದ್ರೆ, ಇನ್ನೊಂದು JE ಮತ್ತೆ AE, ಜೂನಿಯರ್ ಇಂಜಿನಿಯರ್ ಮತ್ತೆ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್, ಅವಾಗ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗ್ತಿತ್ತು ಆನ್ ದ ಸೇಮ್ ಡೇ, ಮಲೋತ್.
Affidavit ಹಾಕ್ಸಿ. ನಿಮ್ಮ chief secretary ಇಂದ affidavit ಹಾಕ್ಸಿ. Why the appointment orders have been issued.
I'll get back on that.
It's a serious matter. Kindly take things seriously.
Please don't.
Perhaps many will shed tears. Many will shed
21st June
tears, I tell you. ಇನ್ನು ಹಂಗೆ ಬಿಡಲ್ಲ ನಾವು, ಯಾರಿದ್ರು ಹಂಗೆ ಬಿಡಲ್ಲ. ನಮ್ಗೆ ಸಾಕಾಗಿ ಅದ್ರ ಸಲುವಾಗಿ ಇಷ್ಟು ಹಿಂಗೆಲ್ಲ ಆಗಂಗಿದ್ರೆ, Chief Secretary, who was Chief Secretary at that time? Please tell the name. Who was the Chief Secretary?
As on June 2024, my lords.
ಏನೇ ಮಾಡಿದ್ರು ನಡೆದು ಹೋಗುತ್ತೆ ಅನ್ನುವಂತ ಆಟಿಟ್ಯೂಡ್ ಯಾರು ನಮಗೆ ಕೇಳಬಾರ್ದು. ನಾವ್ ಏನು ಮಾಡಿದ್ರು ವಿ ಆರ್ ಲಾ ಅಂಟು ಅವರ್ ಜೆಲ್ಸ್ ಅನ್ನೋ ಆಟಿಟ್ಯೂಡ್. ಹಂಗ್ ನಡೆಯಲ್ಲ, ಹಂಗ್ ಬಿಡಲ್ಲ ನಾವು, ಹಂಗ್ ನಡೆಯಕ್ಕೆ. ಅದನ್ನ ತಲೆಯಿಂದ ತೆಗೆದು ಹಾಕು ಅಂತ ಹೇಳ್ಬೇಕು ನೀವು. ನಾವು ಹಂಗ್ ಬಿಡಲ್ಲ. ಅವಾಗ ಯಾರು ವಾಸ್ ದಿ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ?
This was communicated on in the month of February 2024.
Whether he held any discussion with the powers that be in the government. Very important issue. ಇಷ್ಟೆಲ್ಲಿಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಈ ರೀತಿ ನಡೆದಿದೆ. ಕನ್ಸರ್ನ್ಡ್ ಮಿನಿಸ್ಟರಿಗೆ ಅಥವಾ ಇನ್ನು ಎತ್ತರದವರಿಗೆ ಈ ರೀತಿ ಆಗ್ತಾ ಇದೆ. ನಾವು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಬೇಕೋ ಬೇಡ? ಆ ರೀತಿ ಡಿಸ್ಕಷನ್ ಏನಾರ ಆಗಿದೆಯಾ?
I'll get back. Pursuant to that, because what insofar as the appointing authority is concerned, Manoj, there was only one communication, not on 1st February, on 22nd February, there was a communication, Manoj. Insofar.
Just speak, Chief Secretary.
Hello, Chief Secretary Taveldenge, it's on 1st February 2024. So the.
Sufficient.
Was only the one of the major reasons is, Manoj, where during the same day, Manoj, AE 272.
Mr. Advocate General, you cannot feign ignorance.
No, condition number 8,
Cannot feign ignorance, not condition. This letter.
Not only this letter, probably the fact that we have put condition number 8 itself.
Goes that you knew everything.
Therefore, Manoj, assuming this is, I'm not on technical, Manoj, the fact that we have put condition number 8 goes to show that we are the appointing authority.
Reason for putting the condition number 8?
Condition number 8 is, Manoj, by chance, it's like this, Manoj.
Save the skin of your officers.
ಆಮೇಲೆ ಯಾರ ಮೇಲೂ
For example, Manoj, nothing comes out of this, Manoj. For example, Manoj, nothing, because the appointment order is in the month of January, February of 2024. Nothing has happened till June, Manoj.
You should ask them. ಈ ರೀತಿ ನೀವು ಕಮಿಟಿ ಮಾಡಿವಿ ಅಂತ ಹೇಳಿ 5 ವರ್ಷ ಕಾಯಕ್ಕಾಗಲ್ಲ. ಪಂಚವಾರ್ಷಿಕ ಯೋಜನೆ ಅಲ್ಲ ಅದು. ಒಂದು ತಿಂಗಳಲ್ಲಿ ಎಲ್ಲ ರಿಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡು ಇಮಿಡಿಯೇಟ್ಲಿ ಕೊಡ್ಬೇಕು ನೀವು.
For 6 months, for 6 months, no report had come. There were shortage, Manoj. Assistant engineer, junior engineer appointments were done. There was a lot of pressure to appoint assistant executive, saying that they have already been appointed. These people have not been appointed.
ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಹಿಂಗಾಗಿದೆಯಪ್ಪ, ಎಲ್ಲ ಹೊಲಸಾಗಿದೆ, ಹಂಗಾಗಿ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಉತ್ತರ ಕೊಡ್ಬೇಕಿತ್ತು. ಅಲ್ಲಿ ಏನು ಆಗಿರ್ಲಿಲ್ಲ, ಮೊದ್ಲಿಗೆಲ್ಲ ಬಹಳ ಸುಸೂತ್ರ ನಡೆದಿದೆ ಅಷ್ಟು ಅಂತ ಹೇಳ್ಬೋದು. ಈಗ ಶುರುವಾಗಿದೆ ಅಂತ ಎಲ್ಲರಿಗೂ ಗೊತ್ತಿದೆ ಏನೇನು. ಇಷ್ಟೆಲ್ಲ ಬಂದ್ರು ಸಹಿತ ನೀವು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೊಡ್ತೀರಿ ಅಂದ್ರೆ ಏನಿದು ಮುಂದೆ ಹೆಂಗೆ ಹಿಂಗಾದ್ರೆ?
Ultimately, out of 24, Manoj, what is found out is only 10, Manoj. Insofar as 14 people, Manoj, there's absolutely nothing against those.
All right, what action you have taken against the secretary?
That
ಬರ್ದು ನೋಡಿ, ಈ ರೀತಿ ಇದೆ, secretary is not obeying us and they have sent. How the ordinarily select list ಅನ್ನ ಫೈನಲೈಸ್ ಮಾಡೋ ಪ್ರೊಸೆಸ್ ಹೆಂಗಿರ್ತದೆ ನಿಮ್ ರೂಲ್ಸ್ ಅಲ್ಲಿ? ಯಾವ ರೀತಿ select list is approved ಒಂದು ತಯಾರಿ ಮಾಡ್ತಾರೋ? Secretary will prepare it perhaps.
Please.
Controller and secretary.
Controller and secretary.
ಅದನ್ನ ತಗೊಂಡು
It will be put up, Manoj, before the commission for approval.
Commission has to endorse it.
Endorse it, and for that purpose, Manoj, the commission members can secure for any information, or if they have any doubts, they can actually before the. ಎದರಲ್ಲಿ ಅದು ಅಷ್ಟರೊಳಗೆ ಹೋಗ್ಬಿಟ್ಟಿದೆ.
ಹೋಗಿದೆ ಅಂದ್ರೆ ಏನರ್ಥ? ತಾನೇ ಇಲ್ಲಿ ಓದಂಗ್ ಹೋಗ್ತದ? ಯಾರ ಕಳಿಸ್ತಾರೋ?
ಇಲ್ಲ.
ಯಾರು ಕಳಿಸಿದ್ರು?
The commission meeting that was held on 31/1 was found to be defective, and without an agenda, without this matter being in the agenda, the secretary got it approved and sent it. That is the allegation.
Got approved by whom?
By the persons, Manoj, who were apart. The chairman was not part of the meeting that day.
ಎಷ್ಟು ಜನ ಇದ್ರು ಮೀಟಿಂಗ್?
Meeting ಅಲ್ಲಿ. Let's fight. I'll get the proceedings. 5 to 6 people.
Agenda ಎಷ್ಟು? Requirement ಎಷ್ಟು? Quorum requirement ಎಷ್ಟು? 4.
Please.
4 ಜನ ಇದ್ರೆ. But it should be informed to the chairman. ನಾವು ಹಿಂಗ್ ಮೀಟಿಂಗ್ ಮಾಡೋದಿದೆ, ಹಿಂಗ್ ಅಪ್ರೂವ್ ಮಾಡೋದಿದೆ ಅಂತ ಹೇಳಿ ಮಾಡ್ಕೋಬೇಕು.
Please.
ಆ 4 ಜನ ಯಾರು ಇದನ್ನ ಅಪ್ರೂವ್ ಮಾಡಿದಾರೆ?
I'll get
ಮೀಟಿಂಗ್ ನಲ್ಲಿ
proceed.
ಹೆಸರುಗಳನ್ನು ಕೇಳಿ. ನಿಮ್ಮ ಮಗ್ಳಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಅವ್ರು ಏನು ಅಫಿಷಿಯಲ್ ಅಲ್ಲ, ಇದೇನು ಮುಚ್ಚಿಡೋದಲ್ಲ ಏನಲ್ಲ.
No, I'll get it. ನೋಡಿ
ಯಾರು 4 ಜನ?
Just check.
ಇನ್ನು ಉಳಿದಂತ ಮೆಂಬರ್ಸಿಗೆ ಒತ್ತರ ಇತ್ತ ಇಲ್ಲ? ಅಜೆಂಡಾ ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಿದ್ರ? ನಾವು ಹಿಂಗ್ ಫೈನಲ್ ಸೆಲೆಕ್ಟ್.
This was not part of the agenda. The allegation,
that very agenda part of was it sent to members?
No, members it was sent, but ಇದು ಅಜೆಂಡಾ ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ. 31/1 ಗೆ ಅಜೆಂಡಾದಲ್ಲಿ ಇಲ್ಲಿಗಲ್ ಅಲ್ಲಿ ತಂದ್ಬಿಟ್ಟು ಅಪ್ರೂವ್ ಮಾಡಿದ್ದಂತ. That is the allegation against the then secretary. It was not part, this approval of the select list was not part of the agenda in respect of the meeting that was called for on that.
ಆ ಮೀಟಿಂಗ್ ಅದಕ್ಕೆ ಇರ್ಲಿಲ್ಲ.
ಇರ್ಲಿಲ್ಲ. That is.
ಸಡನ್ ವಿತ್ ಲೀವ್ ಆಫ್ ದ ಚೇರ್ ಅಂತ ಅನ್ಕೊಂಡು ಹೋಗಿ
ಹೌದು.
ತಗೊಂಡು ಕಳಿಸ್ಬಿಟ್ರು ಅಂತ.
Please, that is.
ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಫ್ ಬಿಸಿನೆಸ್ ರೂಲ್ಸ್ ಏನಂತೆ, ಯಾವ ರೀತಿ ಟ್ರಾನ್ಸಾಕ್ಟ್ ಮಾಡ್ಬೇಕು
Let's, please, I'll place it on record. Let's, we have Sikta. 31 on meeting proceedings is.
The secretary shall prepare the agenda and convene the meetings of the commission after giving notice to all the members. ಇದಾಗಿದೆ.
ಅಲ್ಲಿ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇದು ಆಗಿಲ್ಲ.
ಅಲ್ಲ, ಅವತ್ the agenda prepared for 31st did not contain. ಈ subject ಇರ್ಲಿಲ್ಲ.
Figure as an agenda.
But 31st, whatever was the agenda prepared was circulated. ಇದಿರ್ಲಿಲ್ಲ.
So that others may think ಯಾವ್ದೋ ಒಂದ್ ಸಣ್ಣ ಪೆಟ್ಟಿ ಬಿಸಿನೆಸ್ ಆಗ್ತಿರ್ತದೆ, ನಾವು ಹೋಗೋದು ಬೇಡ ಅಂತ ಮನೆಯಲ್ಲಿ ಇರ್ಲಿ ಅವರು, ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ನಲ್ಲಿ ಮಾಡ್ಕೊಂಬೋಣ. So there are such decisions.
Please.
We decide to participate in the meeting depending upon the issue.
Importance of the issue.
Importance. ಯಾವ್ದೋ ಒಂದು ಎಂತದ ಇರ್ತದಪ್ಪ, ನಾವು we don't want to waste our time. ಇಂಪಾರ್ಟೆಂಟ್ ಇದ್ರೆ ನಾವು ಬರ್ತೇವೆ. ಹಾಗಾದ್ರೆ ಇಂಪಾರ್ಟೆಂಟ್ ಅನ್ನೋ ಇಂಪ್ರೆಷನ್ ಕೊಡೋದು ಬೇಡ ಬೇರೆಯವರಿಗೆ. KPSC ಪಾರ್ಕ್ ಹೌಸಿಗೆ ಹಳದಿ ಬಣ್ಣವನ್ನು ಕೊಡಬೇಕು ಅಜೆಂಡಾದಲ್ಲಿ ಬರ್ಕೊಂಡು, ಅಲ್ಲಿ ವಿತ್ ಲೀವ್ ಆಫ್ ದ ಚೆಕ್ ಅಪ್ರೂವ್ ದಿ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಅಂತ ಮಾಡ್ಕೊಂಬ.
Page 1.
Why I do not know, we cannot say more, but people know, people should know, we'll make the people know. ಜನರಿಗೆಲ್ಲ ಗೊತ್ತಾಗ್ಲಿ ಅದೇನಿದೆ ಅಂತಾನ. ಇಷ್ಟು ಹೊರಗೆ ಬೀಳ್ತಾ ಇದೆ, ನಿಮ್ಮ ಕೈಯಿಂದ ಓದಿಸ್ಬಿಟ್ವಿ ಈಗ. ಅಲ್ಲಿ ಕಮಿಟಿ 3 ಮೆಂಬರ್ಸ್ ಕಮಿಟಿ ಇತ್ತು, ಅದನ್ನ 5 ಜನರ ಕಮಿಟಿ ಮಾಡ್ತು. ಗವರ್ಮೆಂಟ್ಗೆ ಫೆಬ್ರವರಿ 2ನೇ ತಾರೀಕಿನ ದಿವಸ ಸರ್ಕಾರಕ್ಕೆ ಹೇಳಿತ್ತು. ಬಹಳ ಸೀರಿಯಸ್ ಆಗಿ ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸಿ ನಾವು ಕಮಿಟಿ ಮಾಡಿದ್ದೇವೆ, ಸಮಿತಿ ಇದನ್ನೆಲ್ಲ ನೋಡ್ತಾ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿತ್ತು ಪ್ಯಾರಾ 3 ಅದರಲ್ಲಿ. ಹಾಗಾಗಿ ಸರ್ಕಾರಕ್ಕೆ ಗೊತ್ತಿಲ್ಲ ಅನ್ನೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ. ಸರ್ಕಾರಕ್ಕೆ ಪೂರ್ಣ ಪ್ರಮಾಣದಲ್ಲಿ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಹೇಳಿದ್ಮೇಲೆ ಮುಗಿದೋಯ್ತು, ಬೇರೆ ಹೇಳೋ ಅಗತ್ಯನೇ ಇಲ್ಲ.
ಕಂಡೀಷನ್ ನಂಬರ್ 8 ಇತ್ತು ಓನ್ಲಿ.
ಸರ್ಕಾರಕ್ಕೆ ಇಲ್ಲೆಲ್ಲ ಏನ್ ನಡೆದಿದೆ ಅಂತ ಗೊತ್ತಿತ್ತು. ಗೊತ್ತಿದ್ದುಕೊಂಡು ನೇಮಕಾತಿ ಆದೇಶಗಳನ್ನ ಕೊಟ್ಟಿದ್ದೇವೆ.
Because of shortage of the post, Manoj, and assistant engineer.
ಎಲ್ಲಿದೆ ಡಿಸಿಷನ್?
ಅದನ್ನ ಅಲ್ಲಿ ಪ್ಲೇಸ್
ಶಾರ್ಟೇಜ್ ಇದೆ, ಅರ್ಜೆಂಟ್ ಆಗಿ ಈಗ ಅವ್ರನ್ನ ಕುಡಿಸ್ಲೇಬೇಕು, ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಬೆಂಕಿ ಹತ್ತಿ ಹೋಗ್ತದೆ. ಏನಾದ್ರೂ ಮಟೀರಿಯಲ್ ಬೇಕಲ್ಲ, ಆನ್ ವಾಟ್ ಬೇಸಿಸ್
ನಾನು ಪ್ಲೇಸ್ ಮಾಡ್ತೇನೆ. And during that period of time also, Manoj, the other posting also were being.
Mr. Advocate General, something is going to happen in this case. Something is going to happen in this case, and it will be highly. Many will be embarrassed by your orders, perhaps. Many will be embarrassed.
Manoj, it's a case, Manoj, what they sent the final selection list, Manoj. We have implemented the final selection list. I understand, Manoj. Ultimately, Manoj, we have put conditions.
Appointing authority, ನೀವೇ.
ನಾವೇ.
ಯಾಕೆ ಕೊಟ್ರಿ appointment orders?
Manoj, that is why we put condition number 8.
Condition. ಅವ್ರ ಮೇಲೆ ಒಂದು ಕ್ರಿಮಿನಲ್ ಮರ್ಡರ್ ಕೇಸ್ ಇರ್ತದ, ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡ್ತೀವಿ, ಮುಂದೆ ಕನ್ವಿಕ್ಷನ್ ಆಯ್ತು ಅಂತಂದ್ರೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಹೋಗ್ತದೆ ಅಂತ ಹಾಕಿ ಕೊಡಕ್ ಬರ್ತದ? ವಿಚ್ ಇಸ್ ದಟ್ ರೂಲ್ 11 ಯಾವ್ದೋ ಒಂದು ರೂಲ್ ಇದೆ, ಜನರಲ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ರೂಲ್ಸ್ ತೆಗಿ, ರೂಲ್ 20 ತೆಗಿರಿ ಕೊಡಿ. ರೂಲ್ 20, ವಾಟ್ ಜಸ್ಟಿಸ್ ಕುಮಾರ್ ಸೇಡ್ ಆನ್ ದಟ್?
General recruitment.
Manoj, ultimately now insofar out of 24, 25, actually it's 24 which they have filled up, Manoj. Insofar as 14 people are concerned, there's absolute.
I told them, tainted ಇದೆಯಪ್ಪ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ತಾ ಇದೆ, ಇರಿ ವೇಟ್ ಮಾಡಿ. Then nothing is going to happen. Diwan post alla ಏನು?
Probably that is one of the approach that which they could have followed, Manoj. Ultimately.
Whether is there any precedent for this? ಇದೇ ರೀತಿ ಆದಾಗ
ಇಲ್ಲ
ಹಿಂದೆಂದಾದ್ರೂ ಈ ರೀತಿ ಇರುವಂತ, ಇದೇ ರೀತಿ ಇದ್ದಾಗ ಯಾವ ರೀತಿ
ಮಾಡಿಲ್ಲ. I verified ಮಾಡಿಲ್ಲ.
I think there are reported judgments where government has taken the stand. Tainted candidates ಎನ್ಕ್ವೈರಿ ಆಗ್ತಾ ಇದೆ, ಹಾಗಾಗಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ಸ್ ಕೊಡಲ್ಲ ಅನ್ಕೊಂಡು ರಿಪೋರ್ಟೆಡ್ ಜಜ್ಮೆಂಟ್ ಇದೆ. ನಂಗೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಹೇಳಲಿಕ್ಕೆ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ. ಬ್ರಿಂಗ್ ಸಚ್ ಜಜ್ಮೆಂಟ್ಸ್. ದಿಸ್ ಇಸ್ ಅನ್ಪ್ರೆಸಿಡೆಂಟೆಡ್. KPSC ಇತಿಹಾಸದಲ್ಲಿ, ಸರ್ಕಾರದ ಇತಿಹಾಸದಲ್ಲಿ ಈ ರೀತಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್, COD, CID ಇದನ್ನೆಲ್ಲ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ಅಂಥವ್ರಿಗೂ ಸಹಿತ ಅಪಾಯಿಂಟ್ಮೆಂಟ್, ಅಫ್ಕೋರ್ಸ್ ರಿಪೋರ್ಟ್ ಕೇಮ್ ಲೇಟ್, But this was briefed to the chief secretary in writing. In writing. And a select list ಅನ್ನು approve ಮಾಡೋ ಅಜೆಂಡಾದಲ್ಲೇ ಇಲ್ಲ.
That is with the KPSC.
KPSC ಅಂದ್ರೆ ಪಾಪ ಮೆಂಬರ್ಸ್ ಹೆಂಗ್ ಮಾಡತ್ತ, ಅದು ಯಾರು ಅದನ್ನೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಅದ್ರ ಬಗ್ಗೆ ಅದು ಸರಿಯಾಗಿ CBI ಎಂತದ ಒಂದು ಒಳ್ಳೆ ಏಜೆನ್ಸಿಯಿಂದ ಇನ್ವೆಸ್ಟಿಗೇಷನ್, ಇದರಲ್ಲಿ ಹಂಗೆ ಆಗಕ್ ಸಾಧ್ಯ ಇಲ್ಲ. ಇದೆಲ್ಲ ಇದರಲ್ಲಿ ಹಂಗೆ ಆಗ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ. ಪಾಪ ನಿಮ್ಗೂ ಗೊತ್ತಿರ್ತದೆ, ನಿಮ್ಗೆ ಒಂದು ಪಾಪ ತೊಂದರೆ ಇರ್ತದೆ ಹೇಳಲಿಕ್ಕೆ ಹೋಗ್ಲಿಕ್ಕೆ ಮಾಡ್ಲಿಕ್ಕೆ, ದಟ್ಸ್ ಅನದರ್ ಥಿಂಗ್. ಬಟ್ ಸಾಮಾನ್ಯವಾಗಿ ಒಂದು SSLC ಸೆಕೆಂಡ್ ಕ್ಲಾಸ್ ಆದವನಿಗೂ ಸಹಿತ ತಿಳಿದು ಬಿಡ್ತದೆ ಏನಾಗಿದೆ ಇದರಲ್ಲೆಲ್ಲ. ಅಂದ್ರೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಕನ್ನಡದಲ್ಲಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ಗೆ ಕನ್ನಡದ ಈಕ್ವಲೆಂಟ್ ಪರ ವ್ಯವಹಾರ. ವ್ಯವಹಾರ ಅಂದ್ರೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ನಾ ಹೇಳ್ತಾ ಇದ್ದೇನೆ, ನಾ ಬೇರೆ ಇನ್ನೊಂದೇನು ನೀನ್ ನಾಟ್ ಅನ್ಕೊಳ್ಳೋದು ಬೇಡ. ಅದು ಈಕ್ವಲೆಂಟ್ ವರ್ಡ್. ಈಗೋ ಕನ್ನಡದಲ್ಲಿ ವೆಂಕಟ ಸುಬ್ಬಯ್ಯನವರು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಪದಕ್ಕೆ ಕೆಟಲ್ನಲ್ಲಿ ವ್ಯವಹಾರ ಅನ್ನುವಂಥ ಮಾಡಿದ್ದಾರೆ. ನಾವ್ ಹೇಳೋ ವ್ಯವಹಾರ ಅದು ಬೇರೆ ವ್ಯವಹಾರ ಅಂತ ಅನ್ಕೋಬೇಡಿ, ಆ ವ್ಯವಹಾರದಲ್ಲಿ ಮಾತಾಡ್ತಾ ಇದ್ದೇವೆ ನಾವು. ನಾಳೆ ಮತ್ತೆ ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಟುಮಾರೋ ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ನಮ್ಗೆ ನೋಡಿ ಈಗೆಲ್ಲ ಪ್ರಶ್ನೆಗಳೆಲ್ಲ ಗೊತ್ತಲ್ಲ, ಇದು ವಿಡಿಯೋ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಎಲ್ಲ ಗೊತ್ತಾಗಿ ಹೋಗ್ತದೆ ನಮ್ಗೆ ಏನೇನು.
ಅದಕ್ಕೆಲ್ಲ ಉತ್ತರ ತರಿಸಿ.
ನಾಳೆ ನಮ್ಗೆ ಅದಿಲ್ಲ ಇದಿಲ್ಲ ಅಂತ ಹೇಳಂಗಿಲ್ಲ. ಹಾ ನಾಳೆ FSL ರಿಪೋರ್ಟ್ ನಲ್ಲಿ ಏನಂತ ಬಂತು?
ಟ್ಯಾಂಪರಿಂಗ್ ಆಗಿದೆ ಅಂತ.
ಟ್ಯಾಂಪರಿಂಗ್ ಆಗಿದೆ ಅಂತ ಬಂತ?
ಹೌದು, ಅಲ್ಲಿ ಈ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ
10 ಜನಕ್ಕೆ
10 ಜನ ಟ್ಯಾಂಪರಿಂಗ್ ಆಗಿದೆ.
ಟ್ಯಾಂಪರಿಂಗ್ ಆಗಿದೆ.
ಟೆಂಪರ್ ಆಗಿಲ್ಲ ಅಂತ ಬಂದ ಸ್ವಾಮಿ,
ಹೇಳ್ತಾ ಇದ್ದೇವೆ ನಾವು, ನಿಮಗೆ ಬರ್ತೀವಿ ನೋಡೋಣ. ಸಿಂಪಲ್ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ
ತೊಂದ್ರೆ
ಎಲ್ಲ ಆಪ್ಷನ್ ಅನ್ನು ನೋಡ್ಬೇಕು. ಯಾಕಂದ್ರೆ ನೀವು ಅಕಸ್ಮಾತ್ ನೀವು ಇದನ್ನ ಹಿಂಗ್ ತಕೊಂಡ್ರೆ ಸಹಿತ ಬೇರೆ ಆಪ್ಷನ್ ಏನು ನಮ್ಗೆ ಅದನ್ನೆಲ್ಲ ನಾವು ಥಿಂಕ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
ಈಗ ನಾವೇ ತಪ್ಪು ಮಾಡಿದ್ರೆ ನಮ್ಮನ್ನ ಖಂಡಿತ ಪರೀಕ್ಷೆ ಮಾಡಿ.
ನಾವ್ ಅದನ್ನ ಹೇಳೋದೇ ಇಲ್ಲ, ನಾವ್ ಏನನ್ನೆಲ್ಲ ಹೇಳಲ್ಲ. ನಮ್ಗೀಗ ವಿ ಆರ್ ಹೌ KPSC ಯಾವ ರೀತಿ ನಡ್ಕೋತದೆ, ನಮ್ಮ ಸರ್ಕಾರ ಚುನಾಯಿತ ಸರ್ಕಾರಗಳು ಯಾವ ರೀತಿ ನಡ್ಕೊಳ್ತಾವೆ, ನಮ್ಮ ಸೆಕ್ರೆಟರಿಗಳು, ಪ್ರಿನ್ಸಿಪಾಲ್ ಸೆಕ್ರೆಟರಿಗಳು, ಚೀಫ್ ಸೆಕ್ರೆಟರಿಗಳು, ಅಡಿಷನಲ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿಗಳು ಅವ್ರು ಹೆಂಗ್ ನಡ್ಕೋತಾರೆ, ಬೇರೆಯವ್ರ ಬಗ್ಗೆ ನಾವು ಹೇಳೋ ಪೊಲಿಟಿಕಲ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಬಗ್ಗೆ ಈಗ ಮಾತಾಡಲ್ಲ. ನೋಡೋಣ ಅವ್ರಿಗೆ
ಆಲ್ ಆಫ್ ಅಸ್
ನೋಡೋಣ ವಿಲ್ ಸಿ. ಆದ್ರೆ ವಿ ಆರ್ ಟೆಲಿಂಗ್ ಇದರಲ್ಲಿ ಬಹಳ ಜನ
ತಾವು FSL ರಿಪೋರ್ಟ್ ಅನ್ನ ಓದ್ಬಿಟ್ರೆ ಸಾಕು, ತಮ್ಗೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. 11 ಮಾತ್ರ they are not able to reach them, they are punished. 14 have reached them, not they are left off. That's all the commission's intent.
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಒಂದು ಹೇಳ್ತೀವಿ, ನಾವು ಏನು ಮಾಡಿದ್ರು ನಡೆಯುತ್ತದೆ. ಈ ಸೊಕ್ಕಿನ ಅಟಿಟ್ಯೂಡ್ ಅನ್ನ ಸಂಬಂಧಪಟ್ಟವರು ಇಮಿಡಿಯೇಟ್ಲಿ ಬಿಡಬೇಕು. ಅದನ್ನ ನಾವ್ ಏನು ಮಾಡಿದ್ರು ನಡೆದು ಹೋಗ್ತದೆ. ಅಲೆಕ್ಸಾಂಡರ್ ಅಂತ ಮುಗಿದೋಗ್ಯಾನ, ಕಾಲದ ಗರ್ಭದಲ್ಲಿ ಮುಚ್ಚೋಗಿದ್ದಾನೆ. ಹಾಗಾಗಿ ನಾವ್ ಏನ್ ಮಾಡಿದ್ರು ನಡೆದು ಹೋಗ್ತದೆ, ಅದನ್ನ ನಾವು ಬಿಡಲ್ಲ. ನಾವು ಹಂಗ ನಿಲ್ತೇವೆ. ನಾವು ಏನು ಮಾಡಿದ್ರೆ ನಡೀತಿದೆ, ನಾವು ಹಂಗೆ ಬಿಡಲ್ಲ. ವಿಲ್ ಇನ್ಫ್ಲಿಕ್ಟ್ ಬ್ಲೀಡಿಂಗ್ ಇಂಜರಿ, ಡೀಪ್ ಕಟ್ ವಿಲ್ ಇನ್ಫ್ಲಿಕ್ಟ್. ಹಂಗೆ ಬಿಡಲ್ಲ. ಯಾರ್ಯಾರೆಲ್ಲ ನಾಳೆ ನೋಡಿ, ನಾಳೆ ನಮ್ಗೆ ಬೇರೆ ಏನು ಹೇಳಂಗಿಲ್ಲ. ನೀವು ಎಲ್ಲಾ ರೆಕಾರ್ಡ್ಗಳನ್ನು ಬೇಕು, ಒಂದು ಲಾರಿ ತೊಗೊಂಡೋಗಿ ತೊಗೊಂಡ್ಬಂದಿಟ್ಬಿಡಿ, ಕೇಳ್ದಂಗೆ ಉತ್ತರ ಕೊಡ್ಬೇಕು.
ಪ್ಲೀಸ್
ಅದರಲ್ಲಿ
one request. Day after
ಇಲ್ಲ
ನಾಳೆ ತರಿಸಿ
ನಾಳೆ 2:30ಗೆ ಬಂದ್ಬಿಡಿ. ಡೇ ಟು ಡೇ ಬೇಸಿಸ್ ಮೇಲೆ ಬೇಕಂದ್ರೆ ಬೇಕಂದ್ರೆ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಜನ ಎಲ್ಲ ಮತ್ತೆ ಏನಪ್ಪ ಸುಮ್ಮನೆ ಜಡ್ಜ್ ಏನು ಸುಮ್ಮನೆ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ ನೀವು.
Sorry to interrupt you, my lord. All these 10 candidates, they are all rank holders, my lord. I'll produce the records. They have cleared 7 exams, not 1. 7 exams. They did not join there.
ನಾವು ಎಲ್ಲಿ ಅವ್ರ ಮೇಲೆ ಏನ್ ಹೇಳಿವಿ?
ಇಲ್ಲ, ತಾವು ಹೇಳಿಲ್ಲ. ಆದ್ರೆ ಅವ್ರ
ಹೆಸರು ಸಹಿತ ನಿಮ್ಗೆ ಓದೋದ್ ಬೇಡ ಅಂತ ಹೇಳಿ
ತಮ್ಮ ಮುಂದೆ ತೋರಿಸ್ತೇನೆ, ರೆಕಾರ್ಡ್ ಇದೆ.
ನಾವು ನಮ್ಗೆ ಬಹಳ ಕೆಟ್ಟ
ಹೌಸ್ ಟು ಬಿ ಕ್ಲಿಯರ್ಡ್ ಅಂದ್ರೆ ಅವ್ರಲ್ಲಿ ಅರ್ಧ ಮೆಂಬರ್ಸ್ ಅಲ್ಲೇ
ಒಂದು ಅಂತಿಮ ಹಾಡ್ಬೇಕಿದೆ.
ಅದಕ್ಕೆ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಮೇಲೆ
ಈ ರೀತಿ ಆಯ್ತು,
ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಮೇಲೆ ಮಾತ್ರ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಒಂದ್ ನಿಮಿಷ. ಈ ರೀತಿ ಆದಾಗ ಬೇರೆ ಬೇರೆ ರಾಜ್ಯಗಳಲ್ಲಿ ಯಾವ ಏಜೆನ್ಸಿಯನ್ನ ಉಪಯೋಗಿಸ್ಕೊಂಡು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತಾರೆ, ಯಾವ್ದ್ರಲ್ಲಿ CBI ಕಿಂದ ಮಾಡ್ತಾರೆ, ಯಾವ್ದು NIA ಕಿಂದ ಮಾಡಿಸ್ತಾರೆ. ಇದು COD CID ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ, ಅದೆಲ್ಲ ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ. ಅದೇ ಅರ್ಥನೇ ಇಲ್ಲ ಅವಕ್ಕೆಲ್ಲ. ಯಾಕಂದ್ರೆ ಆ ಪ್ರಕಾರ ಏನಾಗಲ್ಲ, ಅದೆಲ್ಲ ನಿಮ್ ಕಂಟ್ರೋಲ್ನಾಗೆ ಇರ್ತಾರೆ. ಅದಕ್ಕೆ ಅದನ್ನೆಲ್ಲ ನಾವು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಎನಿವೆ ಅದಕ್ಕೆ ನಮ್ಗೆ ಸ್ವಲ್ಪ ಪ್ಯಾಟರ್ನ್ಸ್ ಕೊಡ್ಬೇಕು ಅಂತ ರೂಲಿಂಗ್ಸು ಇದರಲ್ಲಿ. ಈ ಹಂತದಲ್ಲಿ CBI ನ ಪಾರ್ಟಿ ಮಾಡ್ಲಿಕ್ಕೆ ನಿಮ್ದು ಯಾವ್ದಾದ್ರು ಅಭ್ಯಂತರ ಇದೆಯಾ?
That may not be required, man. Because we don't know where it will take us, because we have objections to that. Insofar as
ನಾವು ಅವಶ್ಯಕತೆ ಇದ್ರೆ ಮಾಡಿ.
all parties to this proceeding are put to notice that court may explore the possibility of entrusting the investigation to the CBI established under 1947 Act.
Correct. Police system.
1947 Act. First off, therefore, they may file their versions pro or against, so that a meritorious decision in that regard would be taken at the appropriate stage of the proceedings. First, we request ಯಾರು ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ ಯಾರಿರ್ತಾರೆ CBI? Shri Prasanna Kumar, the standing counsel of CBI, to sit in the court hall when these proceedings go on. Okay, let him sit. We requested him to come and sit.
we can't have objection for him to come. He can be.
Yes. NIA ಗೂ ಅವರೇ ಇದಾರನು?
ಅವರೇ
Standing counsel for CBI stroke NIA to come and sit in the court hall. So that if any urgent information or action needs to be taken, time may not be wasted. Okay.
Not entry order, my lord, granted last occasion maybe.
This early as well interim order question may not arise.
ನಾವು
also.
last
I
occasion
have
ಕೇಳೇ
objections
ಮಾಡಿದ್ದೀರಿ.
for extending.
ನಾವು ಡಿಸಿಷನ್ ತಕೊಳ್ಳಿವರೆ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ ಅಷ್ಟೇ.
ಕಮೆಂಟ್ ಸಿಟ್ ಅಂತ ಬರ್ಸಿದ್ರಿ, ಬದಲು ಬಿ ಅವೈಲೇಬಲ್ ಇನ್ ದಿ ಕೋರ್ಟ್ ಹಾಲ್ ಅಂತ.
ಅಲ್ಲಿ ಕಮೆಂಟ್ ಸಿಟ್ ತೆಗೆದು be available in the court hall. Graciously be available in the court. Thank you. This is how they should correct our language. Otherwise, ನಮಗೆ ಗೊತ್ತಾಗ್ತದೆ. Very well. Thank you so much.
But whatever.
No.
Yes. But interim order, whatever is there, Lord, may be continued. Interim order may be continued. ನಾನು ಹಾಕಿದ್ದೇವೆ ನಾವು ಅಷ್ಟೇ.
Sir, 28.
ಸರ್ ಅದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರು ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತಿಲ್ಲ.
ಡೇಟ್ ಕೊಡ್ತೀರಾ ಸರ್ ಅದರ? ಅಲ್ಲ ಯಾವ್ದಾರು ಡೇಟ್ ಕೊಡ್ತೀರಾ 2 ವಾರ? ಅಲ್ಲ ನಮ್ದು ಹಿಯರಿಂಗ್ ಅಂತ ಇತ್ತು, ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂತ ಇದೆ 28.
ರಾಘವೇಂದ್ರ ಸ್ವಾಮಿಗಳ ನಾವು ಮಂತ್ರಾಲಯದಿಂದ ಬರ್ಬೇಕಲ್ಲ, ನಾವು ಧಾರವಾಡದಿಂದ ಬರ್ಬೇಕು ಅದಕ್ಕೆ